Good morning, Victor.
Good morning. How are
Good morning, Victor.
you? Good morning.
Morning,
Good.
Victor.
Morning, morning, morning. How is everybody this morning?
Morning, Vic.
Wait.
Good
Good.
morning.
How are you?
Doing good.
Good morning.
Good morning.
Morning.
Good morning. Ooh, somebody's up.
Everybody's wake up today.
Oh, it was hard.
Good morning.
Why, was there a party last night or something?
I still have a jacket. My room
Feels
is
like it.
cold.
Good morning, Lillian.
Good morning, Richard.
And the party's tomorrow.
Let's see. We have our brains stretched out today for a little learning.
Little something.
Well, we got a little learning to do today.
Good morning.
Good morning, good morning, good morning. Good morning to all. Just opening up all my folders so that we could get started here. Ba, ba, ba. Good morning. And notes. One more folder to open and I'm good. All right, guys. Good morning, good morning, good morning. Let me do a little housekeeping, put my phone on silent here so we don't get disturbed. And let's get started, shall we?
Yes, sir.
So today we're going to be boogieing a little bit. We're going to be doing chapter 5, 6, possibly even 7, probably. A lot of and 20. We're going to get boogieing. We're going to be doing a lot of real estate now. We finally got to real estate. That we got past the rules and regulations, the laws, learning how not to discriminate. Now we're going to finally start learning a little bit about real estate, all right? So before we do that, what is an illegal discriminatory zoning practice called?
Panic peddling.
Mount Laurel? I don't know.
It was outlawed by the Mount Laurel decisions.
Regulations.
For my
Zoning
Regulations.
law is for food. Zoning practice.
exclusionary
Oh,
zoning.
yeah.
Who was excluded?
Blockbuster.
Or exclusionary.
The poor, the less fortunate, the low
Right.
income.
Right. So, and how was that?
Because of the land, they
Because of the zoning, they use the zoning powers to require you to have more land in order to build. That's how they did it. I want you guys to understand this. So if they give you scenario based, you could be able to at least pick it out, you know? So
yeah.
an illegal discriminatory zoning practice was outlawed by the Mount Laurel called exclusionary zoning. Who was excluded? The poor, right? What do we call the state anti-discriminatory laws?
Law.
The lad.
LAD, the New Jersey Law Against Discrimination. And how do we notify people about the LAD?
To the Attorney General
the Attorney
memorandum.
General.
The Attorney General's memorandum about the New Jersey laws against discrimination. Correct. And when do we give it to people?
It has to be on the office.
the property is
They have
listed?
to sign when
At
they
the
sign
time
the
of listing. At the time of listing.
Right.
Get a listing, you give it to the owner. You only give it to the owner. Because buyers and renters are free to discriminate all they want. They can choose where they want to live. But if you're offering property for sale or lease, you cannot. Right? So that's why we give it only to the owners. What do we do if we're going to get a listing and an owner tells us that they intend to discriminate? What do we do?
Cancel the listing.
Cancel. Don't take it.
Walk away.
Don't take it. You don't have to cancel it, right? What do we call it when the parties are in agreement on all the terms?
Meeting of the minds.
It is. And what do we call the agent who's owed the commission who did the most leading up to the sale?
The procuring cost.
They are the procuring cause of it. So therefore, they're the one who is owed the commission. And what do we call someone who is prepared to purchase a property, they're financially capable, and they're ready to take steps towards consummation of the transaction?
procuring?
No.
Ready,
Is that the ready, willing, and able
They're
buyer?
a ready, willing, and able buyer. There we go.
Okay.
They're a ready, willing, and able buyer. And as a salesperson, what does your broker owe you?
Commission.
Really don't.
Guidance and
You
direction.
need to
Sorry.
earn that.
Guidance and direction. My bad.
Guidance and direction and office space.
Office space.
Office space. Okay.
Remember, any broker has to have a physical place of business, right? Now, as an independent contractor, what are you responsible for?
You get your own insurance.
Get your own insurance, pay your own taxes. You're responsible for maintaining your own license, right?
Yes.
Okay. What are your fiduciary duties?
Cole.
What does that stand
To
for?
be honest.
COL.
Honest.
Client.
Accountability,
Care.
loyalty, and disclosure.
All right, we gotta do this again because you guys are all over. Some people are shouting out stuff that has nothing to do with it. Care,
Yeah. Obedient.
obedience.
Obedience, accounting,
Loyalty,
loyalty, and disclosure.
So care, obedience, accounting, loyalty, and disclosure are your fiduciary duties. So what is a fiduciary relationship based on?
Trust.
Trust.
Honesty,
Trust and
Trust.
confidence.
loyalty,
Where you're
Confidence.
responsible for your client's money and or property. And you got to put their interest above all others, including your own. That's the whole definition. That's what you need to know. I can't be finishing this for you every day. All right. What do we call one person who owes someone else fiduciary duties?
A fiduciary.
They're a fiduciary. And somebody who owes somebody, how do property managers usually work? What kind of agent?
General.
General agent. What can a property manager, what can a general agent do that a special agent cannot?
Legally bind their clients to a contract.
They can legally bind their clients to a contract. Correct. And so what's the difference between a client and a customer?
The customer, you owe them, the client, you owe them, the customer,
Fiduciary duties.
yeah, and the
customer.
client, you just need to be honest,
You got to treat them fairly and honestly.
fairly and honestly, yeah.
A client you owe fiduciary duties to. A customer you only need to treat fairly and honestly. Right? And what do we call it when the broker can be held just as liable as one of their agents who do something wrong?
Guilty knowledge.
Guilty knowledge. What is the least severe discipline the real estate commission can take against you?
Probation.
Put your license on probation. And what's the most severe?
Revocation.
Revoke.
Revocation. And what's the process? Before they,
10 days, they'll notify you within 10 days to come to court.
they give you a 10-day advance notice to attend a hearing, correct? And what's the minimum and maximum fines that are possible?
250 to 50,000.
$250, maximum $50,000. How soon does your broker have to pay you your commission?
As soon as the check clears.
In 3 days, you give them the payment. I mean, the
Within 10 days, or
Plus
as
10 days.
soon as the check
You got
clears?
Within 10 days or so.
And what does your broker need to give you after your termination, and when?
30, a notice, 30 days.
Anything, any commission is pending and any deal, and with 30 days.
Okay, so within 30 days of your termination, they have to give you accounting for any outstanding transactions that haven't yet closed that you may still earn commission on, right? What do all real estate property ads have to have in them?
To a qualified.
The actual property ad. What is the property? Every property ad have to
Or
have
the municipal location.
municipal.
the municipal location where the property is located. And if you're offering rebates, what do you got to put in the ad?
You have to get an attorney.
Qualified buyers?
Qualified primary
No.
resident buyers. No?
You have with an attorney. You have to advise them to get You have to advise them to get an attorney's opinion or something like that. I know what it is, but I can't
Tax
pull
professional.
it up right now.
You got to advise them to consult with a tax professional with regards of receiving the rebate. Why is half my head invisible over here?
No, we can see you.
We see you.
Yeah, we see you first.
So you have to advise them to consult with a tax professional, okay?
Yeah, that's a ton of.
Now, anytime you mention certain triggering terms in an ad, full disclosure is required. What law requires these triggering terms when talking about financing in an ad that would trigger a full disclosure requirement?
Regulation D.
Just say it could be negotiated.
So what are those triggering terms?
Yeah.
The interest rate.
If you mention an interest rate,
Full disclosure.
The payment amount.
interest rate, not the, interest rate, payment amount,
The term.
or
The number of payments or years. Or the down payment amount.
Well, that's the term, the down payment amount. Okay, so
Sorry.
if you mention an interest rate, a monthly payment or payment amount, down payment amount, or a term, these are the four triggering terms that would trigger full disclosure requirement. And the full disclosure requirement would require you to now disclose three things and say a statement. What is the statement you got to put in the ad now?
To those who qualify or to a qualified buyer.
Those who qualify or to a qualified buyer. And now you got to also disclose.
Agency relationships.
No, three things, three items pertaining to financing.
Oh.
The APR,
The APR.
down payment amount if required, and the term.
APR down payment.
CCIM?
Sorry?
CCIM?
CIM. No.
CC, CR, is it CR?
No.
Yeah, maybe it's a different thing.
Yeah, that's different. We're talking about if you mention financing in an ad, you
Got you.
have to disclose when is it considered that you mention financing in an ad? when triggering terms are used. What are those triggering terms? You mentioned the monthly payment, an interest rate, monthly payment, down payment amount, or term. Those are the triggering terms. They would trigger a full disclosure requirement that you would now have to say to those who qualify or to a qualified buyer. In addition to that, you have to disclose the APR, which is different than the interest rate. It factors in all those one-time ancillary payments that are factored in, that are costs associated with getting the loan. So you have to mention the APR, down payment amount if required, and the term. Okay. If your name is in the ad, tell me something about it.
You have to, I guess, have the same name. The name that's your correct
The name has
you
to
have
be
a correct-
exactly how it's on your license.
Your name has to be exactly as it is on your license. And
You can use a nickname.
you don't have to use any middle name. You can use a nickname, but you got to still use your real first name and last name. And what about the size of it?
It cannot be
Font
big.
size.
You have to put it
It can't be bigger than the name of the brokerage.
of the broker.
Correct. The brokerage's name has to be in larger type and more prominently displayed. And any particular real estate ads for property have to have what in each individual property ad?
What's the question again? Sorry.
What do you need to have in each individual property ad? For each
At the
of
front of it,
each property, because you could have many property ads within an advertisement. What do you got to have in each individual property ad?
Municipality
The
location?
municipal location, correct. Can you ever offer anything for free to the public?
until it's genuinely free. Only if it's
Yes.
genuinely free.
If it's genuinely free, no strings attached. What if you want to brag about an ad and put in an ad that you offer low commission rates,
So,
and you specify a commission amount or rate in the ad? What do you got to do?
It can be negotiated.
You have to say in
You
each
have to advertise.
commissions are negotiable. Yep. All right. If you have your own website, what do you got to put on that website?
you have to put a link heading back right to the brokers.
And
Their
their phone
and-
numbers.
Phone numbers.
and the phone number.
And the phone number back to the brokerage as well. Okay. And if you mention that you're a member of an MLS, if that ad is large enough, what do you need to do?
Please.
List all the MLSs.
Spell out the full name of every MLS which you're a member of. Correct. All right. What's another word that means ownership?
Title.
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 Is title proof of ownership?
No.
No.
How do we transfer
To
Title.
deed. To deed.
some sort of deed of conveyance? And in a much later chapter, we're going to be learning about different types of deeds. But for now, we use a deed for transferring ownership, title. But is a deed proof of ownership?
Yes.
No.
No.
There are 4 proofs of ownership. What are those 4 proofs of ownership or evidences of title?
Torrent certificate, which is not in New Jersey.
Correct.
I'm only giving that one.
Oh, I need 3 more.
Somebody else give the other 3.
Abstract title.
Abstract of title with attorney's opinion,
Certificate of title.
certificate of title, and,
Torrance certificate.
well, she said torrent certificate already,
Oh, and title insurance policy.
and a title insurance policy. Those are the 4 evidences of title. Correct. Whew. See, this is why I don't save this one for the last day, you know, because this is usually chapter 21 stuff. I usually like to go over it early, so every day we could review it, and hopefully we'll remember it by the time we get to the last day. Wait, where am I? Why am I here? I'm on the wrong page altogether. What federal anti-discriminatory law has some exceptions to it?
Federal Fair Housing Act of 1968.
Correctamundo. And the Federal Fair Housing, the Civil Rights Act of 1866. What's the main protected class? There's a couple, but what's the main protected class?
Covers.
Race.
Race.
Are there
Color, religion.
this law? Are there any exceptions when it comes to race?
No.
No.
No, there's never any exceptions to when it comes to race in the law. What kind of property does the Civil Rights Act of 1866 cover?
Primary residence.
No, all the property, residential, commercial, land.
All property, personal property, and all real property. Remember what happened back in the 1800s.
Yeah. When they discriminate for poor people or for race before the slave.
1866, that's when Lincoln freed the slave, and he gave equal rights to everybody for all property. Said that black people have the right to own real estate and have personal property, like the clothes on your back, right? Everybody has the right to equally have all property. That's what happened that long ago, right? Everybody got the equal rights that they could have ownership in real estate as well as personal property. And when it comes to real estate, that doesn't say just a house to live in, all real estate. Doesn't matter what you use it for. So it covers all kinds of property, real and personal, and residential or commercial, doesn't matter, all real and personal. But the Fair Housing Act, house is your keyword there, the Fair Housing Act of 1968 covers what kind of property?
Oh, residential?
Residential real property only. Doesn't cover commercial. What kind of property does the LAD, New Jersey Law Against Discrimination, cover?
Real and personal.
It covers
all
real property only. All real property, not personal property. It only covers real estate, but all real estate, whether it's residential or commercial. See, Civil Rights Act of 1866 covers all kinds of property, real property or personal property, residential, commercial, doesn't matter, as well as the personal property like the clothes on your back. Federal Fair Housing Act of 1968 covers only housing, which is residential real estate. The LAD, New Jersey Law Against Discrimination, covers all real estate, commercial, and residential. Okay, so now that we know what those three laws cover, how long do you have to file a complaint if you feel like you've been discriminated against the LAD?
1 year.
1 year.
6 years.
180 days or 6 months? For New Jersey law.
Oh.
For the federal law, how long do you have to file a complaint?
I think that's 1 year.
1 year. That's it? 1 year?
Or 2 years at the federal.
Or 2 years if you want to make a federal case and have it heard in federal court. Remember I said if you want to make a federal case out of it, 2 years, right? So that one, you know, there's two options. Because federal law, you can make a federal case out of, right? State law, well, stick in the state, okay? So that little saying will only work with the federal law. 1 year, you have to bring charges, or 2 years to make a federal case out of it. Now, the violations of the New Jersey LAD, Law Against Discrimination, what are the penalties for the first, second, third offense?
19,000 and change.
No,
$10,000
$10,000.
49,000
Oh.
and 98,000 and change.
No. $10,000 for the first violation. 25 for a second.
And
up to
50,000 for consequences.
For further violations, correct. So it's 10, 25, 50,000. Okay, for the lad. You were mentioning Richard. You were mentioning the fines for the federal law, which you don't need to memorize the fines for the federal law. Those are off the wall numbers. I don't know how the hell you would remember them. You got to be some kind of like a savant with the numbers to remember that. You know. What are the different ways you could terminate an agency relationship?
Bankruptcy.
Bankruptcy.
For mentally dead or mentally or physical.
Death or incompetency of either party. Bankruptcy. What else?
That's too much to remember.
Expiration of
the agency, term of the agency.
Yeah.
Why are you being hired?
To do a job.
Okay, and so that was a hint. When you've completed the job, fulfillment of the purpose of the agency, right? Yeah. What else? Can you decide you don't want to work with somebody?
We had the right to leave.
Yes.
So cancellation by the agent. If you could cancel it, can the other person cancel it?
Yes.
Yes.
Cancellation by the principal, or you could both agree to mutual. What else?
Mm-hmm. Any alterations on the property that they may do?
Not alterations.
Construction?
What if it burns down?
Yeah.
What's that going to do to your listing?
Take it right off the...
right?
Yeah.
Okay, so here, let me read down the list here for you. Death or incompetency of either party. Destruction or condemnation of the premises. Expiration of the term of the agency. Fulfillment for the purpose of the agency. Cancellation by the agent. Cancellation by the principal. Mutual agreement. And I already said bankruptcy, right? Yeah, so that's...
Yeah.
What's the first document that you give to anyone that you intend to do business with?
The CIS.
CIS. What does CIS stand for?
Consumers Information Statement.
Consumer Information Statement. And what is the purpose of the Consumer Information Statement? What is
it? An explanation of the business relationship.
It's an explanation of business relationships, correct? And you have to. Who do you have to give it to?
To the owners or the house.
Anyone
you intend to do business with. For what kind of property?
Residential.
It's only required for residential. It's only required for residential. Or leases if the lease is longer than
1 year.
125 days. Because that's anything less than 125 days is considered seasonal rental. All right. What is a unpleasant event like rape, murder, suicide that could affect the property's value?
Stigmatizing factor.
Stigmatizing factor, correct. What are we required to investigate and disclose to all parties?
Physical, structural damages or anything that's unseen.
Material damage.
Home inspectors. We're required to investigate and disclose all material information. What is material information?
That's it.
Anything has to do with the house, whatever we have to find any information about the owners, like they have a late paint, how long is, the more information we can get it from the house before we list it.
It's any information, usually about the physical condition of the property, that a buyer would place importance in wanting to know. It's not necessarily damages. It could be improvements that were made. How many bedrooms? How many baths? The architectural style. Is there a garage? Is it attached or detached? What kind of heating system is used? What kind of fuels used for the heating system? Etc. Etc. That is material information. But owners are required to disclose all material defects, or for that matter, even ones that, what is a material defect?
Latent defect.
No, what is a, no, those are two different things. What is a material defect?
The physical condition of the property. I think.
Material defect is any problem that can be discovered by a visual inspection. If you looked around, you could find it. A hidden defect is called a
Latent defect.
latent defect. Owners are required to disclose both material and latent defects. Okay. What is the right of rescission for the discovery of off-site conditions?
5 days.
5 days. Exaggeration as salesmanship.
Puffing.
Puffing. Is there anything wrong with that?
No.
No,
But
you should
you
puff.
have to.
What do we call it when we all get together and we talk about the commissions that we charge and we all agree not to charge less than a certain amount?
Mutual mind, I don't know.
Sherman Antitrust? No.
Well, Sherman Antitrust Act makes it illegal.
Price fixing?
Price fixing. We're all getting together to conspire with each other to set an industry standard for pricing. That's called price fixing. Okay. And what is the penalty for price fixing?
The highest. I think it's.
Here's a little hint. You see one guy doing this in the movie.
What is it, up to $1 million?
Yes.
Up to $1 million, right? And up to
10 years?
10 years in prison. Correct. And it's considered a misdemeanor, right? So that was Dr. Evil.
Such a hefty fine for a misdemeanor.
Yeah. Up to $1 million, up to $1 billion fine, and 10 years in prison. Correct. And our equivalent to medical malpractice insurance that a doctor would carry.
Errors and omissions.
Errors and omissions insurance. Correct. And which law? Who enforces the federal anti-discriminatory laws?
HUD.
HUD. Who enforces the New Jersey anti-discriminatory laws?
The highest law enforcement officer. I think.
Who's that?
Lad.
No, who enforces the New Jersey laws against discrimination?
That's LAD.
LAD is the law.
Yes, it is.
The Attorney General.
The Attorney General. The Attorney General is the highest law enforcement officer in the state. So it's the Attorney General who investigates that, right? The easy way you could remember that is how do you disclose to people the LAD? How do you disclose to owners the laws against discrimination?
Attorney General memorandum.
By giving them the Attorney General's memorandum, and that's the highest law enforcement officer in the state. So it's the Attorney General that you have to that enforces it, right? How about a form of discrimination where you're playing on somebody's fears of a protected class. It's also known as panic peddling. You're trying
That
to
blockbusting?
you're trying to scare them to sell their house. That is blockbusting.
Blockbusting.
You're trying to get them to bust up the block. That's right. You're trying to get them to bust up the block by scaring them into moving. These people are moving into the area, and then make up a story to try to scare them. All right. That is called blockbusting. And what about discrimination by limiting someone's options, or when you make the decision of where they should live?
Steering.
That's called steering. That's called steering.
Steering.
And what law makes blockbusting and steering illegal?
That falls under the 1968 Act.
The Fair Housing Act of 1968.
Fair housing.
Or they may just say it's covered under Title 8 of the Civil Rights Act of 1968, which is the Federal Fair Housing Act. All right, so that's another way they could word it, though. They could say Title 8 of the Civil Rights Act of 68, which is the Federal Fair Housing Act of 1968. All right, and discriminating by not giving somebody a mortgage loan or a loan or
Redlining.
insurance. Redlining. Correct. All right. Can you not rent to somebody because they're getting government assistance to pay the rent that's temporary?
No.
No,
No.
that's
Why not?
because we discriminate.
That's
That's discrimination.
discrimination.
Because you cannot discriminate because of source of lawful income. Doesn't matter where it's coming from. If it's a lawful source of income, you cannot discriminate, right?
Right.
What do we call those undercover mystery shoppers that try to make sure that we're all treating
Testers.
everybody Testers. All right. Okay, doke. Let's jump into chapter 5 now, shall we? I'll answer for you. We shall.
We shall.
That's good.
There we go. Chapter 5. We got up on the board right now. On the board, up on the screen. Jeez, got to change my vocabulary. I'm used to, well, we got up on the board. No, we got up on the screen over here in front of you. Okay, so chapter 5. That's a pretty good question. What is real estate? We're going to be getting into that in this chapter. By the end of this chapter, you're going to be able to identify characteristics of real estate. Here, let me just mute everybody for now unless you got a question. Now, you'll be able to identify characteristics of real estate, distinguish between the characteristics of personal property and fixtures. More than that. We'll be able to do more than that. But anyway, let's start off with real estate. Real property ownership is often described as the bundle of rights. So what are you buying when you purchase real estate? You're buying not only the land and all the improvements to it, but you're buying, the owner is transferring to you the rights that they have in that real property, the rights to ownership. Now, sometimes those rights may have been limited or restricted. They can only pass on to you the rights that they have. So if their rights are already limited or restricted, they can only pass on to you those limited or restricted rights. Make sense?
Yes.
Okay.
Yes, it does.
Included in the bundle of rights. So what do we call all those rights you get with ownership? The bundle of rights.
Right.
And that includes the right of possession or season. That's the exclusive right for you to possess the property. You've seized the land. The right to use the property in any legal manner. The right of quiet enjoyment. That's to be able to keep others off of your property. The right of exclusion, the use of the property without having others entering or occupying it as well. The right of disposition or alienation. Disposition means, well, you're right, well, both disposition or alienation is your right to transfer that ownership, sell it, lease it, give it away. All right. Now, add this term alienation to your notes. It's in here in this slide. Alienation is a transfer in its simplest definition form. The shortest, simplest definition I could give you is it's a transfer of property. You need to know this. The word alienation will pop up when we get to mortgages too. There's an alienation clause in mortgages. Basically says that when you transfer the ownership, the mortgage loan needs to be paid off in full. So that's whether you sell the property, lease it, give it, or you sell the property or give it away. All right. Now, alienation can be voluntary or it can be involuntary. If something is voluntary, what does that mean?
That you're gonna give it.
Willingly.
It's something you wanted. And if something's involuntary, what does that mean? Something you don't want.
Something you didn't want.
So voluntary alienation would be if you sold the property, gave it away, or if you left it to somebody in a will. Involuntary alienation would be foreclosure. You die or you die without a will and no heirs can be found and the state takes the property. Somebody sues you, forcing you to sell it, or somebody sues you to gain ownership of the property. And alienation can be during your lifetime or after death. We should have probably put that one first. Yeah, in that list. So alienation can occur during your life or after your death or after death. Now, within these rights include further rights, the rights to improve, devise. Devise means to leave by will. You see on page 67, it says underneath the olive branches here that are tied together with your bundle of rights.
Yes.
Underneath that, it says devise, leave by will. Highlight devise, leave by will. Devise means to leave by will. We're going to be getting into that. That's on chapter 20. We're going to be skipping there today in a little while. To mortgage, encumber, cultivate, explore, mine, build, lease, license, dedicate, give away, abandon, share, trade, or exchange the property. These are all terms that we're going to learn. So far, we learned about alienation. And we learned that it could be voluntary or involuntary. Before you die, during your lifetime, or after your death. Right? We went over that first term, devise. So we're going to go over some other death terms, but we're also going to go over a term that's often confused with devise. What does devise mean? To transfer or leave property by will. When they say will, they mean your last will and testament. When you die, you make a will that determines what's going to happen to your assets after you die, right? So devise is the one that means death. You leave a property by will. Not to be confused with demise, which sounds more like death, right? You finally met your demise. Demise sounds like death, but it isn't. Devise is the one that is death. Demise is a transfer of property by lease. That's the only reason why I'm bringing it up now is because the two sound alike, and it's easy if you've got them on a multiple choice next to each other to get it wrong. So I tell you this one, the way to remember it, the one that sounds like death isn't, right? Demise sounds more like death. But demise, every lease has a demising clause in it. The landlord is to let the premises and the tenant is to take control over it. So demise is just a transfer of your rights for a limited period of time in the lease. So it's a transfer of property by lease. Devise is a transfer of property by will. These are terms to know. Testate. Testate is what you call it when you made a will. If you prepared a will during your lifetime, the last will and testament, that's called testate. Intestate is when you did not prepare a will. So if you die intestate, what am I saying?
If you died,
You did not
well,
prepare a
you
will.
definitely didn't devise.
If I say that you died intestate, then I'm saying that you died without a will.
Right.
Yeah.
If I say that you died testate, I said that you died with a will. I'm saying it in one word. How did they die? Testate or intestate? Okay. Testate means with a will. Intestate means without a will. Now, it doesn't matter if you die testate or intestate. Your estate has to go through probate. What is probate? Probate is it's a court proceeding. It's a legal process that determines who the heirs of an estate are if you died without a will, and what the assets of the estate are after all debts have been paid. And then whatever's left over can get distributed to your heirs according to your will. So that's no matter if you had a will or not. All your debts have to be paid first. All estates have to be probated first. Okay? Doesn't matter if you had a will or not, it's got to go through probate. What's probate? They want to make sure that all your debts have been paid. Mainly, you paid all your taxes. There's no outstanding taxes. See that? Two things are certain in life. We know what they are, right? Death and
taxes.
We're all going to die, and we all got to pay taxes. Hell, you even need to pay your taxes after you die. That's what probate's there for, to make sure that you paid your taxes after you die. You're not cheating the government, not unless you die penniless. Right? You spent it all, and they can't get anything. All right. Now, a legacy is what you leave behind after you die. It's and the bequest is the gift of your personal property that you've left behind. I bequeath to thee my vast fortune of $4 in my bank account. Hopefully you have more than $4 to leave behind when you die, or unless you lived a full life and you just got down to those last $4 and you spent it. And then you led yourself a nice full life enjoying it. So, but if you got kids, you're going to want to leave them something behind. Doesn't need to necessarily be monetarily. Maybe it could be life lessons, teach them some good morals. Yeah. But either way, that you don't have to put in a will, right? So a bequest is a gift of a personal property. A legacy is what you have, your fortune that you have amassed during your lifetime, all your property. So it's a gift of personal property after death, what you left behind. Dower and courtesy rights, we'll be getting into here as well in the coming pages. But let me go over it now really quick. Dower and courtesy are an ancient right in which your spouse has a right to all the property that you had during your lifetime upon their death. Okay? So dower is the wife's right to half of all the property, or to half. It's not half. The right to all. That's incorrect. Dower is the wife's right to all the property her husband had during his lifetime, and courtesy is a similar right that the husband has to all the wife's property. Why do I keep saying to have? To all the property the wife had during her lifetime. Now, New Jersey abolished the creation of any new dower or courtesy rights on May 28, 1980. This is a date to remember. That's the date that New Jersey abolished the creation of any new dower or courtesy rights, but it did not get rid of any current existing ones. So people who are married before May 28, 1980 still have dower and courtesy rights.
They're grandfathered in.
Yeah. Now, marriages after this date, after May 28, 1980, your spouse only has the right of joint possession. I believe you'd have to increase the volume on your speakers if you're not hearing me right there. Everybody else hear me fine, or?
Yes, I
Yeah.
can hear you.
Sounds good. Okay. Yeah, you're gonna have to
Good.
the volume on your speakers. Then it's not me. I'm up all the way here on my microphone. My mic volume's up pretty good. I raise it up too much, it starts getting staticky on people. All right, guys. So if
Yes, sir.
yeah, so if you're, I mean, I got the gain up on my mic a lot. So just try to raise your speaker volume up. All right. You're welcome. Okay, let's see. So dower and courtesy. Dower is the wife's right, and courtesy is the husband's right to all the property that their spouse had during their lifetime. If they were married after May 28th, 1980, your spouse has now the right of joint possession for only the primary marital residence. You can own property that your spouse has no interest in. I bought a separate investment property. The spouse doesn't have any interest in it. Okay, that's you're allowed to do that, and then you're allowed to sell without having your spouse's signature on there. But if you're married before May 28, 1980, your spouse has the dower and courtesy rights, so they have rights to all the property that you own. But
I have a question.
after May 28, 1980, your spouse only has rights to whatever the primary marital residence is. You can own property that they have no interest in. Go ahead. What's your question?
Okay, my question is if the couple was married before 1980, but a property was purchased by either the husband or the wife after 1980, regardless for the wife or the husband, that law still falls in effect. They have full rights to it, correct?
They can still make claim to it, yes.
Okay.
So, for exams, you need to know which one is the wife's right and which one is the husband's right. So, dower is the wife's right, courtesy is the husband's right. The way that I remember this really easily, I don't know. You guys ever remember? I don't know. You guys remember what I believe it was, The Sound of Music or whatever? They had that song,
Yeah.
"Doe, a deer, a female deer." Well, dower begins with a doe, and a doe is a deer, a female deer. So dower is the wife's right, the female's right, and courtesy, because men are courteous to women or should be, is the husband's right. So dower, doe, a deer, a female deer. Dower is the female's right, the wife's right. Courtesy, because men are courteous to women. Courtesy is the man's right. And then you just need to memorize this date outright. May 28, 1980 is the date that New Jersey abolished the creation of any new dower or courtesy rights, but any existing ones that are in place, if you were married before then, they're still in place. We did not do
Yeah,
away.
so it was definitely wiser to get married after May 28, 1980.
Well, you didn't have, I mean, well, I was going to say you didn't really have a choice, but I mean, back then, how would you know that they were going to change the law, right?
Yeah, right.
All right. And then what we're going to be getting into a little bit in a few as well is this one, the laws of descent and distribution. That's over here where we're going to be getting into these death terms and descent and distribution. That's more of a death term. We're going to be going to chapter 20 in a moment, and we're going to be discussing this. So we're going to actually skip forward and do chapter 20 before we come back and finish chapter 5.
Victor, I have one more question.
Yep.
Okay, we're going, the question is pertaining to the dower and the courtesy.
Okay.
That May 28th, 1980, that falls for either death or even in divorce?
No.
Only at death.
If you were divorced, you're not dead yet, so your spouse doesn't have any rights to anything that you have until after you die. Dower and courtesy is the wife's right to all the property her husband had during his lifetime after his death.
Gotcha.
All right, and
Gotcha.
vice versa. All right.
All
So
right.
descent and distribution is the law that determines who gets your assets if you die intestate. What is intestate?
Without a will?
If you die without a will. So every
Yeah,
state
that's right.
has a laws called descent and distribution. That if you die and you did not prepare a will, who's getting your assets? Who's getting your money?
Government.
The state.
Well, I mean, your heirs, your natural heirs have a right to it. Before the government can take your stuff, your heirs can, but who can be considered an heir? And who gets how much and who gets what? This is why it's very important for you guys to have a will, especially if you have children. You want to make sure that your children are getting your stuff. Well, you know what? By having a will, you're going to actually make the probate, because all estates still have to go through probate. Probate can be a long, and sometimes even you're going to be paying for attorney's fees and stuff. It could be a costly process. But if you had a will prepared, probate goes a lot smoother and a lot quicker and is a lot cheaper, right? But if you don't, then you wanted to leave stuff, your assets to your kids, it's going to be, they're going to have to fight for what was rightfully owed to them, and it could take a while to do. All right. So
It could be costly too.
everybody should have a will. You guys can go get Quicken Will Maker. It costs like $20. You could get it on Amazon or eBay or whatever. Or Susie Orman, her estate package, and she has a will maker as well. I mean, you could get these things and they're like $20. The software that's legal in all 50 states, or you could go to your attorney and get a will made for relatively low cost as well. Probably not $20, but okay. So you should have at least a basic will made up, and if you have a will, make sure it can be located. Make sure people know where it is, right? What good is it if you lock it in a safe, but nobody's got the combo, All right. And then I got a couple links here. So what we're going to do is we're actually going to go to chapter 20 for a moment on page 262. Oh, that's not right. 262.
274, isn't it? No. Yeah, 274.
Hold on a second. I got the wrong thing written here. Hold on. We're on chapter 5. And let me mark my page on chapter 5, but I have it written here. What it should be 276, page 276. Why did I write 262 here? Chapter 20, page 276. I don't know where I got page 262 from. The hell's on page 260? Nothing's on page 262. 276. Okay, that was wrong. All right. So on page 276, I'm marking my page in chapter 5 because we'll come back to it after we do chapter 20. So we're going to complete chapter 20 today. The first 2 pages of chapter 20 are going to be reviews for things that we've already gone over. They talk about alienation, voluntary, involuntary, and something called adverse possession, which we didn't go over yet, but we'll get it in chapter 7. So by the time you get to chapter 20, these first 2 pages are only a review. So 276 and 277 are the only new information. So we're going to go over this. These are things that we actually already went over here in the slide, but we're just going to highlight these things. And then how the process of descent and distribution works, we're going to go over on these pages as well. So on page 276, under transfer of deceased person's property, everybody there? Everybody there?
Yes.
Yes.
Highlight intestate without having left a will, and testate has prepared a will in the first paragraph there. Then you see down where it says probate, it says probate or administration is a legal process by which the court determines who inherits the property of a deceased person and what the assets of the estate are. Either an executor or an executrix. An executrix is a female version of an executor. You're a female if you're an executrix. If you're an executor, you're a male. Named in the will, or an administrator if you had no wills and the court had to appoint somebody to determine who your heirs are and how to distribute your assets. That's an administrator is appointed by the court. If there was no valid will, and they would oversee that distribution of your estate. Now, how does transfer by will work? How does the transfer by will work? Well, a last will and testament is made by an owner to voluntarily convey title to their property after their death. A will takes effect only after you die. So you prepare a will while you're alive, but the will has no power until after you die. It's you're writing what you want to happen to your assets after you die. But nobody can get those assets. Like if you leave your property to somebody in a will while you're alive, they can't touch it because you wrote it in a document that said you wanted to leave it to them. That doesn't take effect till after your death. A party who makes a will is known as a testator. Well, what's testate? Testate means you prepared a will. So testator, words that end in OR, legal terminology. Words that end in OR is the person giving, whatever the root word is, okay? Testate means you prepared a will. So the testator is the one who prepared that will and left you something in it. Let's see if I can touch these legal terminologies at all. Nope, not yet. All right. And a testatrix is a female. The gift of real property by will is known as devise, and a person who receives real property by will is known as a devisee. Words that end in EE is the person that's getting something. Okay, devise is leaving property by will. Devisor is the one that's left it to you, that gave it to you. Devisee is the one that's receiving it. Highlight a gift of money or other personal property as a legacy or bequest. Person receiving the property is a legatee. You don't need to study that or add that to your terms. In New Jersey, children can be disinherited, so be good to your parents. But a surviving spouse is entitled to at least 1/3 of the estate. So you can't write your spouse out of your will. You got to leave them at least 1/3 of the estate. Now, I know sometimes we get people in this class and they're like, oh, that's bullshit. I got divorced. She got half of everything. Well, no, that's because she had a good lawyer. All right. Your spouse is only entitled to 1/3 of your estate. So how do spouses get half of everything when you get divorced? How does that happen? Well, they had a good lawyer. I really mean that. Now, what do I mean? Well, can you own an investment property that your spouse has no interest in at all?
Yes.
You can.
I assume yes.
You can. But how does your spouse end up getting half of it?
Because she became accustomed to the lifestyle of living that
if you
had.
If you used one penny from the joint marital assets to maintain or purchase that property, hey, she's contributed to it, so now she's entitled to half, or not she or he, okay? Your spouse is entitled to half because you used the joint marital assets to purchase or maintain it. So all they gotta do is follow the money. Your spouse had a good attorney that followed the money, right?
So what if it's not a joint account with your spouse?
So your spouse always had a separate bank account that never any of the joint marital assets went into that bank account, you mean?
Yes.
Well, as long as you kept those assets separate from the get-go, then you can make purchases and your spouse can't touch anything because you have things that are separate. But I don't know how that marriage is going to work out if you're going into that marriage keeping everything separate. You know, I mean, if you're planning on staying in it for the long term, I know everybody plans on staying into it and divorce happens, you know. Well, get a prenuptial agreement, right? A prenuptial agreement's a legal document that determines in the event that things don't work out, who's going to get what from the assets. You're better off doing it that way instead of scheming behind them. I'm going to keep my own bank account that you're not going to be able to touch, and we're going to keep those assets separate. What's mine is mine, and what's yours is mine. Yeah, that type of a scenario won't work out good.
That sounds good.
So
what's mine is mine, and what's yours is mine. You like that?
I like that.
So
my way.
Victor.
Yes, Richard.
So even if, regardless, if both parties, couple, had their own separate account, the only thing they went on joint will be the resident that they live under if they bought the house together. But if the husband or if the wife was investing into other properties and only using their account and everything shown on the banks that they maintained the property through their own personal account, would the significant other still?
You know what? You get a good attorney. A good attorney can even blast holes through that, because look.
Yeah.
How did you make your money? You made your money through your job. Okay, that job. Would you be able to perform that job if you weren't married? If you didn't have the support of your spouse? You know.
Gotcha.
You have to go to college first, and you wouldn't have been able to go to college if the wife wasn't taking care of the kids and allowed you to finish the college. Or, you know, there's always a lot of arguments that could be made that could poke holes through that as well. So you're better off with a prenuptial agreement, so you don't got to try to scheme and then hope for the best. You know, just if you get an attorney that specializes in creating a prenuptial agreement. This is a legal document that says what happens. You know, I hope that our marriage works out. I love you and all that stuff. But in the event that sometimes relationships don't work, sometimes they fail for various reasons.
Right.
Irreconcilable differences, where a spouse cheats on another spouse, or something happens. You know, stuff happens. Okay, but people who are not rich need a prenuptial agreement more than those who are. Because people who are rich, if I'm a multi-millionaire, billionaire, it's nothing for me to say, here, take $1 million, now get the hell out of my life, you know. But you know what? I was married and I'm divorced. And I remember when I was getting divorced, after I was married, I remember after the first couple of weeks, I was like, holy shit, what did I do? I made a mistake, you know. I ended up being married for 6 years because I was like, you know what? I'll deal with it later, you know. So I started looking up, you know, attorneys and seeing the costs when I was ready to get divorced. I looked up attorneys' costs to get divorced. They ain't cheap. Divorce attorneys ain't cheap.
No.
You know?
They're not.
The cheapest divorce attorney I found was like $350 an hour or some kind of crap like that, $325 or $350 an hour. So minimum billable time, a half an hour. So if they send a fax or make a phone call on my behalf, that's expensive. It's an expensive phone call.
Yep.
That's an expensive fax, you know. And I was like, the only person that's going to get rich in this divorce is the attorney, you know. So I was like, you know what? I put it off. And so I was married a couple more years, and until we were, you know, we were separated already. And then once I got something on her, then I put together I put together a written document, a written settlement. And I had her sign off on it. And went to court, and I got I got the divorce. Now I did it myself in court by filing the court fee of $350, I think it was, or $300 court fees. And I did the paperwork myself, and I went to court and I did the divorce myself with no attorney. All right, but in order to do that, it would have to be an uncontested. So.
Yeah, my ex-wife took me to the cleaners twice.
It happens. She took you to the cleaners twice. You married her twice, or two different wives?
No, but she ran me through the dryer and ran me through the washer and left me with nothing.
Multi-cycled, yeah. Okay, I got you.
Yeah. She went full-blown cycle on me.
But you know what? A prenuptial agreement would have settled that out, because prenuptial agreements say, well, in the event of just irreconcilable differences, you know, you get this and I get that, you know. And in the event that we had a child, what happens? Or in the event we have 2 children, in the event we open up a business, in the event that one spouse cheats, in the event that one spouse is abusive, you know, there's a lot of scenarios that would spell out what you would get of the assets, and we're also trying to predict what your assets would be at the time as well. But all of that stuff is covered in those prenuptial agreements if you have them written up right. And people who are not rich need a prenuptial agreement more than those that are, because now you don't have to go through attorneys and go through all that BS and garbage and pay high attorney fees. You paid an attorney up front to do the prenup. And that'll save you a lot more in attorney fees on the back end should you need them. All right.
Yep. Yep.
As you've learned, painfully so.
Stay single.
Yeah,
is the best.
painfully.
Yeah.
Stay single.
Yeah. What's that?
Stay single. Stay single.
Stay
That's it.
single. Yeah.
Yes, that's
have
the best.
fun.
That's the best.
Spread the
I
love
can
around.
That's the best.
Listen, I'm divorced, but I'm not jaded. You know, I'm just I made a wrong decision with the person that I chose. But
I divorced twice, and that's it. Enjoy the life for me.
yeah. Well, that's what it feels like after a while when you feel like you've wasted a lot of your time, right, and time and your effort. But you know what? It's just like dating.
Yeah.
You know, things work out. Sometimes they don't. You hope for the best. You know, and that's what happens when you get married. You really love somebody. You know, but so I'm open-minded to it again. But
You don't need a
I'm not looking for it.
only the heart. You don't need a paper sign. Only the heart. That's it.
That's right. All right. So in New Jersey, children can be disinherited, but a surviving spouse entitled to 1/3 of the estate. And the determination of an augmented estate is a complex calculation. In a case where the will does not provide the minimum statutory inheritance of 1/3 to your spouse has something called the right of election, which is reserved only for a surviving spouse. You don't need to write that. I don't think you're getting that on exam, but it's good to know for real life. In the event that your spouse died and they left you less than 1/3 of the estate, you could be like, I don't think so. I'm going to elect for the higher amount that the state requires as a minimum instead. So I'm going to exercise my right of election. Okay, that's what that is. It's reserved only for a surviving spouse. Now, a will differs from a deed in that a deed is how you transfer the ownership of your real property while you're alive, and a will only takes effect after your death. So what is required to create a will? Well, New Jersey requires that in order to create a will, you have to be at least 18 years of age, and it requires 2 witnesses. And those witnesses' signatures should be notarized so that you could streamline that probate process a little bit later on. Somebody who is serving as somebody who's a beneficiary in a will can serve as a witness to the will as well. But if you wrote the whole entire will, this is called a holographic will. And holographic wills do not require any witnesses. If you hand wrote the whole entire will, you don't need any witnesses. But I hope that your handwriting is neat enough that it can be read. All right. Otherwise, print it out and then sign it in front of 2 witnesses and have their signatures notarized soon after. Okay. Video wills in New Jersey are not legal. Video wills are good for drama purposes. You know, if you want to videotape yourself reading your will in front of the camera, just make sure that its terms match whatever's on the video there. You know, you could do it for dramatic purposes, just read the will. And for you get nothing. No zoop for you. You know, if you want to embarrass them there, come to the video reading and you get nothing. All right. but the video will really means nothing. It's okay. It's for dramatic purposes. Wills in New Jersey have to be in writing. All right. I want you to highlight in that paragraph on the right side of the page, about halfway through, to be valid, a deed must be delivered during the lifetime of the grantor. Deeds are
Okay,
always,
is this under legal requirements for making a will?
no, it's above that, just above that, 2 sentences above that. To be valid,
Page 276, sir.
To validate, yes.
correct.
Sir,
Okay.
page
Be
276.
valid.
Yes. Page 276, upper right-hand corner, second sentence. To be valid, a deed must be delivered during the lifetime of the grantor. It's next to the last sentence under the transfer of title by will section. Okay. To be
Okay.
valid, a
Gotcha.
deed must be delivered during the lifetime of the grantor. You're going to highlight that a couple more times during this book. When does the transfer of a deed take place? When does the transfer of, how about this? When does the transfer of ownership take place? Upon delivery and acceptance of the deed itself. That's why deeds don't need to be dated or signed by the buyer. Buyer just needs to be named in the will. I'm sorry, in the deed. And it needs to be signed by the seller. Okay, now legal requirements for making a will, I just went over that. And towards the end of that, the last paragraph, they talk about the dower and courtesy, which I already went over, but we're going to go over again later on in the book in chapter 6. So we don't need to talk about it anymore right this moment. So go down to transfer by descent. So I told you every law, every state has a law called the transfer of descent and distribution. So under the title here, transfer of title by descent, just there's nothing to highlight. There's nothing on exam here. I'm just gonna read to you what the process is. If you died intestate, what does that mean?
Without will?
Without making a will.
Without prepare a will.
So if you die without a will, who gets your stuff? So before
It goes through court.
the state can get it, your natural heirs have a right to it. So who are your natural heirs and who gets your stuff first? Well, let's read how this works.
Kids.
So title to real estate and personal property of a person who dies intestate passes to their heirs. Under the descent statutes, the primary heirs of the deceased are their spouse, civil partner, domestic partner, and close blood relatives, the blood relatives. When children have been legally adopted, most states consider them to be heirs of the adopting parents, but not heirs of the ancestors of the adopting parents. So if you got adopted, you're an heir from your mother and your adopted mother and father, but not from their brothers and sisters or their extended or their family side. Now they could leave you something specifically in a will, but like if they die without a will, you can't claim that you're a blood relative and have rights to whatever it was that they had. You follow?
Gotcha.
So when children are adopted, most states consider them to be heirs of the adopting parents, but not heirs of the ancestors of the adopting parents. In most states, illegitimate children, okay, an illegitimate child is one where you were born and your parents were not married at the time when you were born. Let's see, for the younger crowd here, that's let me talk to you in Game of Thrones type of understanding terminology that you could understand. You are the bastard child. Okay, that's how they refer to it in Game of Thrones, right? If anybody ever watched that show. Okay, so illegitimate children, or the bastard child, is one where your parents were not born. Your parents were not married when you were born. Okay, so how does that work? Illegitimate children inherit from the mother, but they do not inherit from the father. Wow. Remember in Game of Thrones, they were referring to him as the bastard child, so he didn't have right to the throne or whatever because he was, unless the father has admitted parentage in writing or parentage has been established legally in some other way. So if your parents weren't married at the time that you were born, you can inherit from the mother, but not from your father, even though it's your real father, unless you can prove that that's your real father, unless he signed like the birth certificate or there was a blood test done or he admitted parentage in some other legal way, you cannot inherit from the father. So let's just say that you do. He admitted and he is your father, okay? If he legally adopts that child would inherit like an adopted child would. You can inherit now from the father, but not from the father's brothers, sisters, or father's side of the family, which is kind of messed up because you're really a true blood relative, but you still can't inherit like a true blood relative. You know, these are some medieval type laws here, aren't they?
Yes.
Okay, so intestate real property is distributed according to the laws of the state that where the property is located in. The New Jersey law of descent and distribution provides that real property belonging to an individual who's died intestate is distributed according to the list below. And once again, this is only after all debts have been satisfied. So after it goes through probate, and if the person died without a will. So let's go down to number 1. A surviving spouse or partner becomes the sole heir if the descendant leaves no parents or children. If there is a child or children who are also the children of the surviving spouse, the spouse or partner receives the first $50,000 plus 1/2 of the remaining estate. The rest goes to the child or children. Now keep in mind, this is only in New Jersey. If the descendant leaves parents and a spouse, but no children, the spouse or partner receives the first $50,000 plus 1/2 of the remaining estate. The rest goes to the parent or parents. If there are children who are not the children of the surviving spouse, the spouse or partner receives half the estate and the child or children receive the other half. Where no spouse or partner survives, children become sole natural heirs. Where there's neither surviving spouse nor children or children's own heirs, the estate first goes to parents, and failing that goes to brothers and sisters or their heirs. In default of any other natural heir, grandparents, aunts, uncles, and first cousins may be considered heirs. But beyond that point, the entire estate goes to the state of New Jersey by the process of a chit. So the state treasurer would sell so how does this cheat work? Well, the state treasurer would sell the property at a public sale, at an auction, giving notice by publicizing it in a newspaper in Trenton and the major newspaper in a county where the property is located. The proceeds from the sale are held in a fund for 1 year. And if no relatives make claims against the fund within that year, then the funds go to the state.
They tax you your whole life and then they take away everything and they keep it. Crazy.
And I have 2 links at the bottom of the slide that you see in front of you, missingmoney.com and unclaimedproperty.nj.gov. I think New Jersey recently is no longer putting their stuff in missingmoney.com. They used to, but don't quote me on it, so I'm leaving it up there anyway. When we have break later on, I want you guys to go to missingmoney.com and unclaimedproperty.nj.gov. Look up your name. Look up your close relatives' names. In every single class I've ever had, I've always had at least one person who has found money due to them, one thing or another. Okay? Whether it's from a job or whether it was from I don't know, a bank a statement that you may have bought that needed to mature first. If it was closed bank accounts and the bank didn't return the money to you, they have to hold it in a fund for like 10 years. So these funds are people put money in for various reasons. I had one girl that used to work at Hot Topic and her boss never paid her last check, and instead he turned it over to the state. So she went on the website. She found she had a couple $100 due to her from her last job or her old job. You know,
I did that one time, and I came across anywhere from like $700-800, but I can't remember the exact site where it was. But I ended up receiving like $700-800, and this was around 2005, 2006.
Well, these two websites are owned. These two websites are operated by the federal government. All right, you shouldn't have to give any credit card information. If you do, you're not on the right site. I had one girl in one of my classes. She went to missingmoney.com. She's like, I went to missingmoney.com. You have to pay $29. You got to give your credit card. I'm like, no, you don't. It's run by the government. It's free. I said, what she did is she went to Google and typed in the Google search bar missingmoney.com, and then she clicked on one of the links at the top, which those are all advertisements all the time, right? And she ended up going to some website that was some scam website that took her for her credit card. I'm like, no, what are you doing? Don't do that. Can't call your credit card company and cancel that. You know, that was so. In the address bar of the browser, you type missingmoney.com or unclaimedproperty.nj.gov. Put in your name, put in your relatives' names. You may find something there, okay? And let me know if you guys find anything. The finder's fee is only 10% that I charge. I just kidding. I just kidding. Yeah. If you feel it in your heart and generous that you want to donate, though, I'll be gladly accepting it. No, but anyway, but just let me know. I'm curious to find out if anybody finds anything. There is no finder's fee. Okay.
I already do in New York.
Okay. I hope you guys do find something, though. You know.
I do already. New York, I do. I don't think I have it here.
Oh, you did find something, though?
Almost $4,000 for one house. I have it in 2009.
This class is more than paid for itself. If you got $4 grand already, look at that.
No, but I do it for like 2 years ago.
Oh, that don't matter. If it's in that database, you are owed that money. So you got to, they'll tell you, you go there. Sometimes they tell you how much money you're owed. Sometimes they say undisclosed. Sometimes they'll tell you what it's, you know, who it's from. Sometimes they'll say undisclosed because they want you to put in your information first, and then they'll give it to you. And they'll tell you what forms you need to fill out and send to them, and then you'll get the money. So look at that. Found money. Missing money, right? Look at you. Good for you. Good for you. Congratulations. All right. So let's see. Let's do the key terms for chapter 20. So that we could close out. And we did chapter 20 today too already. Ready? Transfer of title with the grantor's consent.
Yes.
Voluntary alienation.
Yes, it's voluntary alienation. 13 is A. Acquiring of property by natural heirs. We just went over it.
Descent.
Descent. 3 is B. Court proceeding to establish validity of a will.
Probate.
Probate. 10 is C. A document disposing of property after one's death.
Ooh.
What
Last
document?
will and testament.
You guys don't even
Last
need
will.
the will, right? The will, the last will and testament.
Last will and testament.
All right, so 9 is D, the will. Having made a will. That's testate. 11 is E. One who makes a will.
Testator.
Testator. 12 is F. One who can inherit. They're an heir. They're an heir. 6 is G. One who receives real property through a will.
Number 4.
Devise. It's pronounced devisee. Devisee. Okay.
Thank you.
H, not a problem. Devisee. 4 is H, correct. Person named in a will to administer descendant's estate.
Executor.
5 is I, executor. Title acquired by usage. This one we didn't go over.
Administrator.
Yeah, this one's adverse possession. This is the one I told you we're going to go over in chapter 7, I believe it is. So adverse possession, 2 is J. Transfer of title without the grantor's consent.
Involuntary.
Involuntary alienation. 8 is K. Without a will.
Intestate.
Intestate. 7 is L. And person named by the state to administer a descendant's will.
Administrator.
An administrator. 1 is M. Correct. So So let me read them straight down the list, okay? If anybody that missed any, let me read them straight down the list. M, J, B, H, I, G, L, K, D, C, E, F, A.
Okay.
All right, thank you.
And back to chapter 5. See, we got a little work done, made a little money. Wonder who's buying the beers today? No comment.
Modelo.
I noticed that.
Modelos. I like my Modelos.
Yeah, Modelos are pretty good.
Or a Heineken. I'm good with that.
Or mixed drinks. Mixed drinks are fine too. I'll have a little red Stag and Coke.
With a good cigar.
All
Yes,
right.
sir.
So you could see once again, I got on the slide these links here for you. You know what? I'm going to copy and paste these and put them in that one slideshow that's only for links as well. Done. All right. Let's go back to page 67 we were on. And land versus real estate. So what is land? Everybody sees a slideshow in front of you now? Still?
Yes, I did.
Yes.
I just want to make sure that it's visible. So land refers to the Earth's surface, including the water and anything permanently attached to it by nature. Permanently attached to it by nature only. All right? In other words, things like trees, bushes, and grass that don't have to be planted every year. They're permanent. That's what they mean by permanently attached by nature. You don't have to plant it every year. You don't have to plant it every year, and the thing grows back every year on its own. It's considered part of the land. And it includes everything extending downward from the surface of the earth to the center, and everything up to from the surface to infinity. It also includes subsurface rights, air rights, and water rights, which we'll get into. Real estate is the land, so it's the same definition of land, plus all man-made improvements, which includes, once again, the subsurface rights, air rights, and water rights. I got a little diagram I drew here on the bottom of this slide, and I gave you the different definition and such. Let's highlight in the book first, and then I'll explain it, and we'll go over the slide, okay? Go to land, where it says land in the book. And now everybody has access to the water, because water is a precious resource, and we all need it to survive. Nobody owns the water, all right? But let's go to the second paragraph under land, and we're going to highlight it. It says, land may be defined as the earth extending downward from the surface to the center of the earth and upward to infinity, including all things permanently attached to it by nature. Now, right after that, they talk about the definition of what a parcel is. A parcel is a specific tract of land that has legally defined boundaries. That is considered a parcel, a specific tract of land with legally defined boundaries. All right. Real estate, on the other hand, is the definition of land. It is everything that land is, plus, we're going to highlight on the right side of the page, real estate is defined as the Earth's surface extending downward to the center of the Earth and upward into space, including all things permanently attached to it by nature or by people, and all the rights, benefits, and interest in it. Another way to say that is the bundle of rights. So real estate is land, as you can see on this slide here. The definition of land, plus man-made improvements, plus all the rights, interest, and benefits that go with it. Or you could say land plus man-made improvements plus the bundle of rights. So this little diagram shows you what the definition of real estate is, because it has a house here. So real estate is the definition of land. Let me explain land first. It's the surface of the earth and all things permanently attached to it by nature, like trees and bushes and grass. Everything beneath the surface of the earth to the center, and everything above the surface of the earth to infinity. That's land. The definition of real estate also factors in all man-made improvements and the rights, interests, and benefits that go with it. I don't know how I would draw a right here, so I didn't. Maybe if I drew like those olive branches, I don't know, or a scroll. I don't know. Okay, so either way, so real estate. You must know the difference between land and real estate. Land is the surface of the earth, including all things, including the water and anything permanently attached to it by nature that does not require annual cultivation, like grass, trees, bushes, and everything below the surface to the center of the earth, and everything above it to infinity. Real estate is land plus man-made improvements and all the rights, interests, and benefits that go with it, or the bundle of rights. Now, what is an improvement?
Anything that's been upgraded physically by hand, by
So
man.
it does not have to be, a man-made improvement does not have to be a structure. It can be a paved driveway, or it could be a sewer pipe running under the land. These are man-made improvements. If you have them on it, what do you own? You own real estate. It's no longer considered land. It is now real estate. With any man-made improvements, it's considered real estate. Okay. Now, we talked about subsurface rights, air rights. Hold on a second. Oh, man, plus man-made improvements. I should give a definition on this slide of what a man-made improvement is. Hold on, I know you may have lost it. There we go, put it back. Plus man-made improvements. Well, what is a man-made improvement? A man-made improvement. What is a man-made improvement? Hold on a second. These things should have their own thing. Plus man-made improvement. What's a man-made improvement? Structures or sewer pipes, sewer or water pipes, a paved road. These are all man-made improvements, right? All right. All right, so property rights, getting back to property rights. Subsurface rights is the right to use the natural resources lying below the Earth's surface, such as mineral rights. And they may be owned or leased separately, individually of the land itself. They may be owned or leased individually of the land itself. I'm going to put owned or leased separately, or okay. So you can own real estate and you can sell or lease the rights to anything that's below the surface of the earth. Sometimes this is referred to as mineral rights, subsurface or mineral rights. The rights to the natural resources lying below the Earth's surface, such as mineral rights, or the area below the surface. What do I mean by that? Hold on, hold on, hold on. I got some info here I wanted to add to slides still. Sometimes we have you know, in congested areas, we have limited space that we can work with. And sometimes, I'm waiting for an image to open up right now here. I don't know why opening images is slow on the computer right now, but anyway. Look at this structure here, the MetLife building in New York. Okay, the MetLife building in New York was this building was constructed directly above. You guys know what this is?
The Grand Central Station?
That's Grand Central Station.
Yeah.
So you have two different owners. You have one owner that owns everything below the surface of the earth here, and a different owner that owns what's above it. I mean, technically, we could even break it down to 3 owners if we wanted to. I think it's only 2, but we could break it down to 3 owners. Let me see if I could get the, because I have a bunch of pictures of this, just this one example here. All right. Here's the designers. Of the building when it was getting constructed. You have Grand Central Station. This is just the entrance, but Grand Central Station goes under the earth over here, under the MetLife building. MetLife was actually constructed above Grand Central Station. So beneath the ground surface over here, you guys can see this picture?
Yeah.
Yes.
So beneath the ground surface over here, you've got the railroad, you got the train underneath this huge building. This 59-story.
A different picture from the MetLife building?
Which building? Which picture are you looking at?
The
Oh,
MetLife building.
Oh, I got
Yeah,
two.
this is the same building.
Oh, I got 2 pictures open. Oh. All right. There we go. See this one? This was in.
Okay.
This was when they were proposing the construction for the. At the time, it was called. It used to be called the Pan Am building. Pan Am was
Right.
was the largest airline in the United States at the time. Pan America, Pan Am. This was actually Pan Am, and now they went out of business. It's now the MetLife building. So they underneath. See, this is Grand Central Station, the entrance, and then this goes beneath the ground, and it goes under this building here. So we have occupying the same space. You know, this. I mean, we were told that the definition of real estate is the surface of the earth, and everything beneath it, and everything above it. But you got different owners here because they sold the subsurface rights. Actually, it worked the other way around. They bought the surface and air rights above Grand Central Station, and they constructed this huge 59-story building.
Who bought it? Pan Am?
Because
Well, it was Pan Am, the airline that constructed this building at the time.
No, I understand that. Well, my question is, because the way how I'm looking at it, if the Grand Central Station is underneath, they owned what was underneath and what was on top. But what I'm thinking is they probably leased out the land to Pan Am, and
they sold it. They could do that, and often that is done in New York, where people don't sell the land; they just sell the air rights to it. Air rights are very valuable in New York, in congested cities like New York City, where you can only build up, where you can't build out. You're limited on space, so then you got to build up. But the city also has restrictions on how high you could build.
Right.
All right, here, let me give you a little, let me put a little drawing over here. I'm gonna open a whiteboard for you, show you really quick. Let me get
So
my.
Pan Am and ended up purchasing. Wonder how that was worked out with the train station still going underneath.
Well,
I guess that was sold as part of the property, but the
well, the
Grand
train
Central
station,
Station handles maintenance.
You have different owners. You have one owner, which is the railroad, which I guess it's the city that owns that, you know. And then you have another owner of the land. Pan Am at the time owned was sold the land and everything and the air rights above it, but the subsurface rights are owned by whoever owns the train station, whether it's the city or what have you. Let me just go through.
MTA.
I got a bunch of the pictures here for this, for Pan Am. Okay, here's that MetLife. It's now the MetLife building with Grand Central Station beneath it. Here's another view. Actually, take a look at this. There's actually, this could be 3 owners. I'm not sure if it's 2 owners or 3 owners. You have storefronts here at the ground level. That could be 1 owner. You got the train underneath the ground, and then you got the Pan Am building above it.
Yeah, the stores are subleased.
All right.
I'm sure.
Well, they probably are owned by the MetLife now, right? The former Pan Am building. But let's just say it could be owned by 3 different individuals. You could have one person that owns the land, one person that owns the air rights, because the Pan Am building was built on foundational supports where they own small areas of the land. Here, let me pull up. I do have some slides, some previous slides that I created here from a whiteboard. Actually, I have it in the next slide of the slideshow. Here, I drew this slide and I said, look, this is the surface of the earth here. And so you could have one person that owns the ground level, everything that's on ground level. You know what? This slide could be kind of confusing. Let's go to, let me open up my Microsoft slide. I have it where it's color coded a little bit better. Give me 1 second while the slide opens. It'll open one of these days. Chugga, 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 chugga. Anyway, you've got 3, you could have 3 owners. You could have one that owns the land and has the storefronts on the land. You got MetLife that has the air rights and they have the building above the land, which means that they have to still own small areas of the land and the subsurface rights where they constructed the building's foundational supports, the columns that hold it up. And then beneath the surface of the earth, you have the railroad. Okay. So let me see. I know I got that drawing here somewhere. Hold on. At least I thought I did. Either way, here, let me make another drawing. I'll make a drawing special for you guys, because you guys are very special. All right. So let's just say that we have ground level here, right? Here's the surface of the earth. And then you have beneath the surface of the earth, I'm going to do it in a different color. We have beneath the surface of the earth, you have whoever owns the train station over here in blue, right? Okay, why did it do that? All right, whatever. Here. So here's the surface of the earth again. And then you have whoever owns beneath the surface of the earth here. That's another owner. And then you have people who have, let's see, the MetLife building itself, I'm going to make in red. So they have to have foundational supports. Okay, so this is the MetLife building. The MetLife building is there floating in the air. But wait, buildings don't float, so it's got to sit on foundational supports. So they have to have these small areas of land that are, they have to own small areas of land here and the subsurface rights where these foundational supports are sitting, right?
Right.
In order to hold that building up. And they're going to be a lot straighter lines than I'm drawing, right? So they have to own these small areas of land here. And they have the air rights. In the meantime, in green now, let's just say that you could have a separate owner for those storefronts that they own the land, that they have those storefronts on. So technically, in the same area, you could have 3 owners, right? You could have, in blue, the train station owns this. In red, the air rights and small areas of land where the building's foundational supports are, along with subsurface rights for those supports that are driven under the ground. And then you have somebody else who owns the land itself here, where they have these individual buildings sitting on. So technically, in the same area, you could have 3 owners, right? I'm just trying to, I'm not saying that this is what's going on here. I'm just saying technically this is what could be happening. So I want to open your minds up to real estate, that real estate's not just you either own the land or you don't. You own the real estate or you don't. You could actually divvy it out like this. So with these rights, now these people who have the air rights for the building, the subsurface rights, do they own real estate? No, they only have rights. They have rights. Now, for the building, they do own real estate. They own these small little areas of land where they constructed the foundational supports. But if you possess rights to real estate, you don't own real estate. You only have rights to it.
So let me ask you a question. What does that, how does that come in term as far as property taxes being paid when you?
Well, you only pay, if you only own these little bits of property here, you're only paying taxes on that. Okay. Do you have, when you have rights, there's 2 kinds of property in this world. It's either real property or personal property. And property can be tangible. That's something you could touch or feel, or it can be intangible assets. It can be a tangible asset or an intangible asset. So there's 2 types of property in the world, and that's real property and personal property. And the assets can be tangible or intangible, something you could touch or something you cannot. When you have rights, you own real estate. Or is it personal property? Is it real property or personal property when you have rights?
Personal property?
It's personal property. Your rights are personal to you. Now, can you touch a right?
No.
No, not necessarily, because it could be.
So it's an intangible asset. So rights, if you have air rights or subsurface rights, you do not own real estate. You possess only rights to it, which is an intangible personal asset. Okay? So let's go back to the, let me minimize this and go back to that building here. So let's see, I got a bunch of pictures of this building. Let's go through them. The MetLife building, boom. Here's when they were building in 19 whatever. Here you see, here's where the here's where the MetLife building is standing now. Okay, where they're attaching it. Then you got the entrance here that goes into from Grand Central Station.
You can see at the corner the supports.
Yep. Okay, so they're
Right
starting.
there, you see?
They're starting to build these foundational supports, which are going under the ground, which will hold this
Absolutely.
59-story building up. Okay, so there it was as they were starting to build it, right?
Mm-hmm.
And there's the finished product. This building has a lot of history to it. It's a very unique real estate in that not only that it shares the air rights, the subsurface rights, and the land rights, but look, here's when it was the Pan Am building. You see it says Pan Am on the building there? You see a helicopter, you see a helicopter landing on it?
Yes.
Pan Am was an airline, and they partnered with this another airline that offered helicopter service from the local airports. I think it was American Airways or something like that. It was called. They built this building with a heliport on the roof. And so this was, you got the train station here. You could come up to the Pan Am building. You could easily get to the airports and stuff quickly. This was the future of New York City from the metropolitan. Great way to avoid all that traffic in the city, right? A lot of people thought
Right.
so. However, today, see, here's the inside the train station. The elevator is going up to the MetLife building. Another architectural drawing of it or a model of it.
Yeah.
Now, I don't know if I got the pictures here. That's
Oh, that's interesting.
They had two buildings connecting over a city street. We'll get into that with air rights. All right, I don't have the pic.
I have something to say about that. So I took an architectural course for a lot of the infrastructure in New York City, and I learned something interesting from that course was that so back in like the 1800s, 1700s, there were people coming here from Europe to colonize the United States. And these people were looking for areas to farm because that's how they produced their money. That's how they lived. So they were looking for places to farm. But when they got to New York City and started farming, they noticed that everything was dying. So
well, New York City is
that everything was dying. Yeah, when they noticed that everything was dying, they looked into the soil and saw that there was a bunch of bedrock. So this bedrock is actually what allowed for these tall structures to be built. This is why New York is able to build such high skyscrapers, is because they have a solid foundation.
Well, actually, they built it on shaky ground. A lot of New York City is a man-made peninsula, so they actually built it out a lot, and I could prove it. New York City is a peninsula that comes out. That means it's surrounded by water on three sides. All right. And New York City in the past, back then in the 1800s, was not as large as it is today. And there's proof of that. When the trade centers, when the World Trade Centers fell, when they were attacked and the trade centers collapsed, remember they were going to build the Freedom Tower in its place, but they had to first dig out and try to get any human remains, etc., that were left behind. Those buildings collapsing. Put some of this, compacted it deep into the earth, right? Well, when they were digging out for the foundation of the Freedom Tower, which was going to be an even taller building, they had to build an even deeper foundation for it. Do you guys recall what they found underneath where the Freedom Tower is?
I heard of something, but I can't recall.
They found a pirate ship. That used to be a dock where the World Trade Centers were sitting. That used to be where the docks were. And a ship had sunk. It's not a pirate ship, but it's from back then. I refer to them as pirate ships, whatever. Anyway, it was a ship back then, and a ship sunk at the dock. So all they did is they buried it with more dirt when they did the backfill to make New York even larger, the peninsula larger. They just buried it. So that's how a ship actually got underneath the World Trade Centers. They actually had to stop the construction process because there was a ship under the ground there. They had to get the Historic Society to come in now and find out what the hell is going on here. Let me see if I can pull that up really quick for you guys. I'll show you.
That's interesting.
Yeah,
So then the trade tower or the Freedom Tower is actually man-made land.
Yes.
By placing.
And there's a lot of that. You see that in a lot of places that are short on that. Like look at Japan. Their airport is entirely actually it's not just man-made. They were building it out for building land, but they even started building floating structures where the land is actually floating.
Dubai is big on that too.
So that's more towards the riparian zones by water. But I'm talking about like if you go to Central Park and you walk around and you see huge pieces of rocks.
Yep.
And that's what they use to anchor the foundation of all these skyscrapers. And I thought that was pretty interesting. Like how you never wondered, wow, how is New York able to make 200 tall story buildings? It's because it has a solid foundation, a solid structure underneath of it.
Well, they could build that in a lot of areas throughout the United States as well, though.
Yeah, but that facilitated the building for them.
Correct.
They started using these huge drill machines and anchored it into the ground.
But that's not the only reason why they did that. The only reason why they did that is they're limited on space of where they could build, so they had to build
because there's no scalability to build out, so they have to build up.
Correct. Here, ship found under the trade centers. I'm gonna try to share with you. I pulled up a browser window. I just did a search for ship found under the Twin Towers. Okay, you can see scientists have found the secrets of the old ship unearthed in 2010 under the ruins of the Twin Towers. The large vessel. Let me try to see.
It was buried 22 feet below.
History. No. It was buried under 22 feet of, or 6.7 meters of soil, and wreckage is built. That's after what they found. There was a basement. There was parking decks underneath the Twin Towers. This is underneath that. CBS News. Hold on a second. History. Okay, here we go. Go to the History Channel. By the way, I downloaded a newer browser. I was using the old internet, not Explorer, but the old Microsoft browser, whatever the heck it was called. They came out with a newer one I was unaware of. I downloaded it, and this one seems to be a little bit quicker. Okay, so where are the pictures? But apparently it still loads slow as hell. So there we go. So underneath, they found this wooden vessel under it, and they actually found, listen, this thing was sitting under for how many years underneath the Twin Towers that already had been constructed, and they had foundation underneath it. This was all underneath that. It was a 32-foot long partial hull. They had to put a halt on that construction project while the Historic Society and scientists came in to determine, to do their research about the ship, its origins, remove any kind of whatever they could. It's amazing that the wood was still intact in any way and not fully disintegrated after hundreds of years. But by examining the slices of the ship's timber and comparing them to archaeological samples from tree rings everywhere, they found, came from Palisades Park, New York, in the late, the white oaks used to build were felled in 1773. So the ship was, the wood was from trees from 1773. So here's a picture of that ship in the ruins underneath the Trade Center. They actually found money, old money from back then and what do you call it? Artifacts, you know, the drinking cups and all kinds of stuff like that they found underground. And this is not a good page for showing that from the History Channel. I did see something from History Channel though, a previous one that was had some pretty good pictures here. Let's see if there's something here with this little quick video. We'll watch it just for a second and then we'll move on. I don't want to waste too much time on this. So the boat
It says the ship was built in Philadelphia.
Yep. Philadelphia in 1773. Come on, it's garbage. Here's a decent picture of it. Of the framing of it anyway. Anyway, that's some lost history. These pictures are taking forever to load for some reason. So, yeah,
wow.
carrying out some of those logs. You can see the size of it compared to the truck over here, you know, the crane. They're guessing that it was a ship that looked like this. I'm trying to see if they have any of the artifacts here. Okay, look, they've found some bullets on the ship. Huh. Or cannonballs. They look small there. I thought they were bullets. See, they found some money on that ship. They found some other artifacts. It's interesting. That's it. They got a little bit of a video there, but we're not going to go over this now. This website's full of ads taking forever to load. But it's an interesting bit of real estate there, right? What if you're building a project in real estate and you come across, we live in New Jersey. We live in a state that's the third state. We have a lot of history here. If you got a construction project going on and they find human remains on the property, you got to stop that construction project. You got to get, first of all, the coroner's got to come in and determine how old those human remains are. Then they're going to have to determine if they're new. Well, you got a crime scene. If they're older, well, now you got to get the Historic Society to come in there and see what happened, do some research. Hopefully they don't find that some historic battle was found and they need to preserve that land. If that's the case, then you're screwed. You ain't building that project, right? Let's close that browser.
I saw a documentary one time where a house was purchased, and I forgot where the house was at, but the new owner wanted to reconstruct the back area of the deck. And when they started digging, the contractors were there. They found the body buried underneath the deck in the backyard. They called the cops, forensic came, they did a whole thorough investigation, and it came down to the fact that going back like 2 or 3 families prior to that, there was a guy who lived in his house with his wife and his kid, and then he just came out and said his wife had up and left him, and she disappeared. He raised the kids by himself, but yeah, he killed her and he buried her right in the backyard underneath the deck that he made. And at that time, they did things without permit, so he did it.
Or they did them, or, you know, they bury them in the basement, concrete the basement, or in the walls. There's stories. We see crime shows about this stuff all the time. People that's not uncovered until they're doing the, you know, you got the new owners that are doing some kind of improvements on the property, right? Then they come across human remains. It happens all the time. But
the new owner had to stop construction until until they completed the investigation and identified the body. And as to
Well, how about
once
this?
it was done, then they show the after projects. I mean, they came out really nice, but that's pretty creepy to find a dead body
Well, how about this
underneath your
one? It's
porch.
not just that. Sometimes we have grave sites on properties. Look,
Yeah.
you guys ever hear of this website that I am going to put on screen? WeirdNJ.com.
Yeah, I've heard of it.
All kinds of stuff, weird stuff in New Jersey. It's an entertaining site, and they also have a Facebook page. But look at this one, the parking lot grave. So there was this story about Mary Ellis. It was actually a very romantic story. Her true love. He pledged his love to her. He was a ship captain. He went out to sea. He said as soon as he comes back that they would marry. And so every day she came out and she looked over the what's that river over there in New Brunswick, North Brunswick? The Raritan River.
Raritan River.
Their property overlooked the Raritan River. So every day she would walk out to this area, this high view where she could get a good view of the Raritan River to see if her love's ship was coming in. You know, and unfortunately she did that for the rest of her life, and he never came back. So ship must have sunk. Pirates, who knows what happened, but either way, he never came back. So this became a historic site. She was actually buried there, where she was always going to view them, and this was on their property, on her property. Now, let me open up that story a little bit more, and you could see what happened with that property. So this was over 186 years ago, right? Now, what happened was that property had been sold over the years. Mary died there 14 years later, 1828, still faithfully anticipating her captain's return. So they tell you about that whole story here. Then later on, that property became the parking lot for the Route 1 flea market. I don't know if you guys may have pulled your cars next to it and parked and not even realize there's a grave in there. That was a grave site. They preserved the grave site. So they tore down the construction or progress. You know, this was all beautiful area over here, that wooded lot, as you could see here. And this is where that grave site.
It's now the movie theater. That's where the movie theater is at.
And today they did the construction again, and now it's the Lowe's movie theater over there. And they still have that.
Yep.
Now the Lowe's movie theater, during the construction phase, they let this thing get in horrible shape. You see the grass getting all overgrown and stuff. They weren't maintaining it. But that was part of the thing, the ownership. Every time the transfer of the rights of ownership takes place, it's written in the deed. They need to keep that burial ground there. They cannot remove that, but they got to maintain it. See, they were letting this starting to fall apart. They have to maintain this. So anyway, that's the story. So now look, it's a little bit better, but
there's the theater in the back.
Yeah, the theater in the back. They still got that grave site there. This is elevated. You may be parking next to this and see the wrought iron fence and not even realize what's sitting there. Interesting little bit of New Jersey history. Weird NJ, to say the least, right?
Yes, sir.
So I just wanted to share that with you guys as well, but that's part of property rights and what happens when you transfer ownership. Sometimes there may be things written in the deed pertaining to that. So let's go back to our air rights story. There was something else another image I wanted to show you guys when we were talking about those buildings. Just hold tight. I do have some more images here. I wanted to add to this slideshow, but all right. No matter for now. Let's just go back to the slideshow. Where are my controls? Oh, here they are. Okay, so subsurface rights, we could see where they constructed the building, all right? You can own, when you own real estate, you don't have to, it doesn't have to be just own it or you don't. Look, I had one girl in my class that moved here from Texas, And she said in Texas, it's a pretty common thing. What they do is when they sell their real estate there, when they sell their land, they retain the mineral rights to what's below the property. And they usually have some sort of additional writing in the contracts that says we're not only retaining the mineral rights, the subsurface rights, but we're also granted a permission that we could continue exploring on the property to try to find oil, okay, for example, because that's pretty rich in those areas. So she said that she sold her property. She's now living in New Jersey. She does not own real estate anymore, but she retained the mineral rights in the land, and she hired an exploration company or partnered with an exploration company that knows how to search for the oil. And then they found it through their methods of being able to find where to drill. And then they drilled and they found oil. Now she said they didn't hit the mother lode or anything, but she's getting enough money from the oil that they're extracting out of the ground there to pay her and her mother's mortgage every month. That's not a bad find if I don't say so. You know, mortgage is a pretty big expense, right? So even though she's not rich, she didn't hit the mother lode. For a property that she no longer owns, it's paying the mortgage on her new house. Not a bad deal. So would you say that rights are valuable? Do you value your rights?
Yeah.
Yeah. Now, in this case, we're talking about mineral rights. You guys ever watch those shows on TV, Alaskan Gold Rush and such? Where these guys are digging. They got the gold fever. They want to dig for gold and strike it rich. But a lot of these guys in those shows, they don't own the land that they're digging on. They're going to property owners and signing a lease with them, a mineral lease, they call it, where they're leasing the land for the purpose of digging on it to try to find gold, extract gold out of the ground. So there's usually, they're paying the landlord rent for the land. They're allowed to dig on it. There's a further agreement that they usually have that whatever gold they find, they have to split on some kind of a split with the owner. And often they have a further agreement that the owner wants them to find at least so much gold within a period of time. This is why these guys often get nervous. If you ever watch those shows, they're like, "Oh no, the landowner called us. He's coming. He's going to be coming down." And they start getting all nervous. They're like, "Oh, let's count up and see how much gold we got. Oh my God, we got to see where we're at." You know, because if they don't meet the landlord's requirement, they're not on pace to, then the landlord can cancel their lease and get someone else in there who knows how to get the gold out of the ground. So that's why you see those guys getting nervous on TV. Okay, but otherwise, that's how some of the subsurface or mineral rights go, and they could be leased or owned individually of the land itself. Same thing with the air rights. They constructed that MetLife building. That MetLife building, or originally the Pan Am building, was built with the intention of it not just being for Pan Am, but also they put that heliport on the roof in hopes that it was going to become a central hub for travel in the congested New York City area. They had high hopes for that back then. Let me look up something real quick. The MetLife, the old Pan Am building. I'm just looking up some of my links I have here saved. You know that there is no heliports in operation on roofs in New York anymore?
Really?
That's because
after 9/11?
No, way before that. Right here, you guys are seeing the web browser. The helicopter coming into a landing on the Pan Am building here. Well,
yes, I see it.
Here's another view of that. And they were doing a lot of landings over there, landing and taking off. And eventually, there was a tragedy and there was a crash. One of these helicopters, just from all their use, one of the Sikorsky helicopters. Let me see if I could try to find which one did it. I was trying to find the images of it. They actually crashed. on the roof. And the building, some of those blades, 4 people got killed. Some of the blades went through the lower level glass in the building. And parts of the helicopter fell 59 stories to the street below and killed a young woman that was on her way walking home from work. And they realized, you know what? Is this really a good idea having air travel like this in case of a crash, something like that, in a highly populated area? Was that the best decision of a thing to do? And so the city put a halt to all rooftop landings in New York City. That's why today, even though they may have buildings with heliports on the roof, they're not allowed to do those landings anymore. Let me see if I could pull up the pictures of that. Okay, here's a picture of it. Here's a picture of the crash at the Pan Am building with this helicopter. And it ended up being that the helicopter landed, but some of its landing gear gave way. Some of its landing gear gave way, and the helicopter turned on its side. See these things right here? This is where the wheels were on the helicopter, and due to stress on this side, you can see right here it bent, and so the helicopter tilted on its side. The blades hit the ground. They cut into some people that were on the ground and killed them instantly. People on the ground below died. Was it 4 or 5 people died from this accident, and therefore they put an end to air travel in New York City. But you guys could find documentation about this. There's a really good video that I found about that as well for the air travel in New York and that Pan Am building. Pan Am crash. Nope. Okay. I thought I had the video somewhere. I guess I didn't because it was too long of a video, but Pan Am building crash. Okay. So you guys may be able to find, there's a good documentary building talking about the history of New York. I could share it with you guys later if you like to. It's I don't want to put it up here and waste any more time for the class. We need to be going through the topics here. Okay, so now air rights. Because you have air rights over everything over the surface of the earth, they could limit how tall you could build your buildings. Municipalities, you still need to follow the zoning laws, the local zoning laws. Now, because you have air rights, that does not mean that you can prevent airplanes from flying over your land, even though you own everything from the surface of the earth to infinity. The FAA, that's the Federal Aviation Agency, they have exclusive jurisdiction of everything above the highest point, above 500 feet above the highest point of the property that's owned. Okay. Now, air rights can be very valuable too. We had somebody here that said that they went through an architectural course before. Well, if you were learning about New York City, then you probably also learned about what happens in New York. What happens in New York City? New York City is a unique animal in that now these rules will be unique from municipality to municipality. So it's not throughout the state of New York, but just in New York City. New York City has something like, let me clear off this slide really quick. Empty this canvas.
Victor.
Yeah.
I'm sorry. I don't mean. So basically, buying a property is just buying rights?
No, it's buying the land. Well, it's buying the land and all the rights, interest, and benefits that go with it. Is in the air rights are rights. Rights are rights. Okay. Now look, I could sell you. Shell gas station often sells their gas stations that they for properties that they no longer need or using anymore. Now, when they do that, when they choose to sell their property, what often what they do is they'll put a limitation on what you could do. They'll sell their property, their former gas station, with a they'll say in the deed they'll put a restriction and they'll put a deed restriction in that says they're going to sell you their real estate, but you can't use it as a gas station again. Or they could throw in another additional thing that says that you can't use it as a gas station unless it's a Shell gas station. Now, are they limiting your rights if you choose to buy it? Are your rights to that real estate going to be limited?
Yes.
Yeah.
Yes, they are. They're restricted. So now if I were to buy that property from you, what am I buying from you? I'm buying the real estate plus all the rights that you had, and your rights were already restricted. So that means that my rights are going to be restricted. I won't be able to use that property as a gas station unless I'm building a Shell gas station, because they wrote that into the deed, and that restriction will run with the land. That means anytime the property is sold, it will pass on to the next owner as well. And the next owner has to abide by that as well.
How long can that, can that last? I mean, what if the company goes out of business and no longer in there? Are you still can't put a gas station on there because it was on the deed?
As long as it's in the deed, if somebody writes a restriction in the deed, you agreed to purchase the property according to that restriction, so you must follow that restriction. You have unrestricted ownership. Well, you have ownership forever of this property, but that ownership is based on a restriction that you agreed to when you purchased it. If you violate that restriction, whoever put that restriction in the deed can take you to court and take the property back without giving you a penny because you violated the terms of the sale.
Gotcha.
Even if you bought it from somebody else, you are inheriting.
You're
the
inheriting
same
their rights
terms.
or restrictions.
Okay.
See, their rights, the person that you bought it from, like if I bought the property from you and you had those restrictions on it already, if I buy the property from you, you can't give me more rights than what you already have. You could only pass on the rights that you have. And your rights have already been limited by Shell, who said that you cannot use it as a gas station unless it's a Shell gas station.
Okay, Victor, so let me ask you this. So if I have a residential property, I own my home, and the state decides that they want to build a highway where my house is, they can force me out of my house, right?
Yeah.
If through eminent domain.
What is that?
Eminent domain is the right of the government to take a property for an from a private party with just compensation. They have to pay you for it. They can't just take your property. They have to pay you for it, whatever the market value of the property is. If they need it for a greater public good.
Yeah. That happened in Perth Amboy.
It happens all over. It happens
Yeah.
all over for various reasons. But so did you have?
What if you refuse?
Well, you could fight it in court, but if the municipality can prove that they need it for the greater good of the public, the greater good of the people, then you're probably going to lose that court case, and you're just going to get the money, and you got to move. But they'll pay you for you have to be justly compensated for the property. They can't just take it from you. And they can't just take any property and pay you for it. They have to prove that they have a need for your particular property, that's the property that they need because that's where they need to put the exit for the highway. Now, if you give government powers like this, are there ever the opportunity where they could abuse those powers?
Yes.
Oh, yeah.
Of course there is. So it's a matter of keeping them in check. So sometimes these powers do get abused, and eminent domain does get abused a lot. But here,
Yep.
let me talk about my point that I was going to be making here. All right, New York City is a unique animal. So in New York, okay, here's the ground. There's a lot of buildings that were built in New York City. You got a lot of these high rises. These are all high rises, okay? You got these high rises that are built all over New York City, right?
Are
There's
you
nothing showing on my end.
Yeah,
We can't see it.
You can't see
I
it.
can't see.
Well, you will in just one moment. Hold on.
Okay.
There you go. Okay.
All right.
Oh, wow.
Oh.
Look at that. Look at all these buildings, all these high rises here in New York that they're building, right?
I thought they were somebody's teeth.
Those some busted up looking teeth. Okay.
Yes, sir.
So anyway, you have all these buildings throughout New York City that are getting built, right? And you get these people that build these buildings. Well, years ago, there was this guy, a developer, that built he built a building in the area, and he went to all the property owners around him. He went to all the property owners that were around him that also had high-rise buildings, right? And this was a major news story way back when, because he went to all these property owners. New York City limits how high, just like any municipality can limit how high you could build a structure. Now, he did something unique. He went to all the property owners in the area around him, and he said, hey, you planning on building your building any higher? If not, I'd like to buy the air or the rights to the air rights above your building. And people were like, well, you want to do what? They're like, no, we don't want you building anything on top of our building. And he's like, no, I'm not going to build anything on top of your building. I just want to buy the air above it. I want to buy the air rights that you have above your building. And they're like, wait, let me get this straight. You want to buy the rights to the air above our building, but not be able to build anything above our building. Is that what you're saying? He was like, yeah. This actually became a major story. People were like, this guy is crazy. He's either a nut or he's got more money than he knows what to do with. All right. Now, so some other people gave the argument, you know what it is? He owns this building over here. You know what? He probably is just so vain. He doesn't want anybody else to build and obstruct his penthouse views. All right. He's like, whatever, believe whatever you want. But this guy had a reason behind why he was doing this. And this building that he built, the Trump Tower, he actually did not own it. This was Donald Trump. He was a developer, a real estate developer, still is, but he's a real estate developer. And he built this building. And if you guys don't know the history behind it, Donald Trump did not own the Trump Tower when he built it. He built it for someone else. He negotiated with the guy that he was building it for that to be able to put his name on top of the building. He actually did not own the building, but he went to all these building owners around and bought the air rights. And people are like, oh, this guy, he just got more money than he knows what to do with. He's crazy. And so it became a story. This guy's wanting to buy air from the building owners around him. Now, he was a developer. And that wasn't the last building that he was going to develop. Now, in New York City, the way that it works is if you build a building so high because the city gave you a permit only to build it so high, and you have the air rights from another building, you could transfer those air rights on top of this building so that you could build that building that much higher. So is there value to that for a developer?
Yes.
Hell yeah, there is. So, people were saying, this is crazy. This guy is nuts. I mean, they started speculating, oh, he just doesn't want them to obstruct his penthouse views because he did live there, even though he did not own the building. All right. And he had his name on it. So people thought, okay, let people think whatever they want. But he could take these rights from other buildings and stack them on here and build it higher. New York City allows that. Now, this will vary from city to city. Okay, not state to state, but city to municipality, what the zoning rules are. So was he crazy? Crazy
No.
like a fox. because he developed a lot more buildings and was able to transfer those air rights to them and build them higher than he would normally be allowed to build. So that
He's a
equated
smart
to a lot of
businessman.
money. That equated to a lot of money here, right?
Yeah.
So there's just another example of how air rights have value to them, how your rights, even though you can't touch them, they do have value to them. They are an intangible asset, but definitely has value to it. All right. So those air rights definitely do have value to them. Yes. Okay, I thought somebody was saying something. Okay, and then we have water rights. Now, the next slides we're going to be getting into are talking about water rights. When we talk about water rights, we are not talking about, when we talk about water rights, we're not talking about your right to the water. Water is a precious resource. We all need it to survive. We all have access to the water. You could use the water as long as you don't disturb any other person downstream use of the water. So we do have rights to the use of the water, reasonable use, okay? When we talk about water rights, we're not talking about your rights to the water. We're talking about your land, your ownership rights of the land when it borders water or has water on it or running across it. When you have littoral property rights, littoral begins with an L, and so do lakes and large bodies of water. But the key to understanding when you have littoral rights, it's not next to large, but what kind of large bodies of water are we talking about? The ocean is a large body of water, right? The key to it is they are navigable. What does navigable waters mean? It means commercial.
Navigate.
It means commercial shipping can go through it. Navigable waters are any waters where commercial shipping can go through. We're not talking about you could get your wave rider or your little vacation, your little leisure fishing boat through. But this is where freight liners, super freighters, cruise ships can go through. Those would be considered navigable waters. And navigable waters are usually controlled by tides. You got high tide and low tide, right? You guys ever go to the beach and you see the stains in the sand at the beach? You got where the high tide was, where the water was at high tide, but now it's low tide, so you can see the stains in the beach, right?
Yeah.
Well, where that water stain is left in the sand, that's the high water mark. So somebody who owns that beachfront property only owns the land up to that stain in the sand, where the high water is. Okay.
That's in the state of New Jersey, right?
That's everywhere.
Are you? Okay.
All right. So you have these are water rights. The water rights are universal. All right. Now the rights can vary slightly from state to state, but generally they're the same. Where meaning that what do you own? First of all, you need to be able to identify what kind of property rights you have. You have littoral property rights when you own land that borders navigable waters controlled by the tides, right? You have riparian property rights. Riparian begins with an R. So do little flowing rivers and, well, rivers anyway, right? Don't think about like the raging Mississippi, because the Mississippi is actually, people who own land on the Mississippi River actually have littoral property rights because commercial shipping goes through it. So the key here is, right, you have riparian property rights when you own land that borders non-navigable waters. Non-navigable, which are not controlled by the tides. You don't have high tide, low tide, right? So if you have, when do you have riparian property rights? If you have land that borders a river or stream or has a lake or pond on it or bordering it, that is non-navigable, meaning commercial shipping doesn't go through it, and it's not controlled by the tides. Because look at, you could own a house on the Great Lakes, right? You could have a house on Lake Michigan, right? Those things have their own weather systems. They have high tide, low tide, commercial shipping is going through them. If you own land on that's on Lake Michigan, you have what kind of property rights?
Littoral.
You have littoral property rights. All right. So now we know how to identify when you have littoral or riparian property rights. What does it matter? Well, if you have littoral property rights, what do you own? You own the land up to the mean high water mark. The mean is the average high water mark. Okay. Now the average, we know that we have storms sometimes and sea levels rise above the normal. You don't count those outliers. Those are anomalies. Those are not the normal. So you take the mean as the average. So you take the average high tide, and that property owner will own the land up to that average high water mark. Okay?
Mm-hmm.
If you have riparian property rights, you own land that borders non-navigable waters, that either borders non-navigable waters, or those waters are running across your land or sitting on it. Can you have a pond or a river on your property running across it?
Yes.
Okay, so now I want you to repeat what I just said. Where is the river or pond?
Should be behind or in.
On your property. So if it's on your land, you own the land under the water, right?
Yeah.
So that's the thing. If you have riparian property rights, you could actually own the land under the water. You could have a lake or a river on top of your land. Now, if two properties are separated by a stream,
half and half.
Let's open up the whiteboard. Not that whiteboard. Excuse me. If you own property that is separated by a stream, let me a little bit. And get my whiteboard controller out. Give me a second here. Okay, so if you own land and you see you got two property owners here. You got two property owners here, and here's the property line, okay? And the properties are separated by a stream, and that stream is running right here, right on the property line. Where is the property line? The property line actually becomes the center of the stream. Each property owner owns the land up to the center of the stream.
Mm-hmm.
So they own the land. So where is the property line now?
In the middle?
Right up to the center of the stream.
It's in the center of the stream. But what if that stream now, it's been flowing this way for hundreds of years, but now all of a sudden it unearths, because it, as water flows, it starts moving dirt around. It unearths a rock, a big boulder over here, right? As the water hits that, it's going to start jettisoning off in a different direction. The stream changes its course, right? That does happen sometimes. The property line would not move. It would be where the property always had been. The property line would not be running now like this. It wouldn't be going like that now. The property line would remain where it always was. It will remain right here, down the center of the stream. Okay? So what do we, yeah.
Okay, Victor, I know we're talking about the stream. There's a place in Florida that they would say is a private owned beach property, private or beachfront property.
Okay.
And then you have the public beach that you're able to, you know, to go swimming, whatever. But there's a line of demarcation. When you go, they said, okay, this is private property. You can't go. You can't even go where the water is directly facing to that beachfront property.
Uh-huh.
And they're considering that as private property. But you said, you know, earlier you were talking about the littoral rights where you're, as long as there's things that can travel on the water,
All right.
there's
I
tideways.
I understand what you're saying. And yes, well, it is not private property, but the municipality is, because the owner only owns up to the mean high water mark. But the municipality has a rule there then that does not allow the public to go behind those properties. They're trying to taunt, I guess, the rich people who own those multi-million-dollar beachfront properties. They probably created a rule there that does not allow them to. I know exactly what you're saying, but it doesn't matter. It doesn't change the fact that they do not own that land. Anything past that out into the water, that's publicly owned property. That's not private. However, the municipality has the right to restrict where the public can go.
Okay.
Okay, and that's all they're doing there. It's unfortunate, but yeah, that's what they're doing. Okay.
Thank you.
You're welcome. Now, so when a stream, we're back at the slide you see here, a vulsion is when a stream suddenly changes its course. It's not gradually, it's sudden. It's a sudden change. When a stream suddenly changes its course. Now, I'm not going to get too deep into this definition because it could actually get very confusing. So for exam purposes, just to have enough knowledge in this, a vulsion is when a stream suddenly and violently changes its course. If this happens, the property line would not change. It would remain where it previously was. Property line would not change. It would remain where it previously was. Now, technically speaking, a vulsion is a sudden change of a stream or water that tears away the land. And it could cause, so if this stream were to suddenly change its course, now it starts ripping away into this guy's property, tearing away, carving out the land. Technically, this guy did not lose the land. He still owns that land that's under it. You know, if this stream dries out again, and this was only a temporary sudden change, he could backfill it back up again. It's not considered a waterway, even though it did see water.
Can I need to ask a question. So if a boulder from lot A fell into the stream, blocking off the water from moving forward, and then it created a new stream into lot B, can the owner of lot B then request that boulder be removed if he doesn't want it cutting across his property? If he doesn't want the stream cutting, can he request the removal of that boulder to set it back to normal base? Do you know what
I believe so, but you got to take care when you're messing with anything with water. You need to get permission before you do anything with water.
Yeah. I mean, he will request a permission, but he could come out and say,
well, that's exactly. Hold on a second.
The new flow could damage my land.
That's exactly what a vulsion is, though. A vulsion is the sudden change of a course of a stream. It usually causes the breaking away of land from one side into the other that pushes the water. So basically, the example you gave where a boulder would have broken off from this guy's property, causing the water to shoot back on this guy's property. And now his land is not usable anymore, but that's still his land that the water's sitting on. Now, whether or not he gets that permission to remove that boulder or not if that's, he does have the right to rebuild that land. If that stream were to stop and starts flowing back again, he could backfill it and reuse the land again. If it's a
Is
beach,
it wise to, is it wise to, prior to purchasing the property, to see to it that the erosion is stated in the
No.
in the contract, where it states that
You
if
can't-
something was to happen?
no, you can't predict it. Avulsion is an act that's sudden and
Okay.
violent, sudden change. Look, here's a thing. Look, if you got your house over here, okay, on the property, and it's a beachfront property, and then you got the water that's flowing in over here, right? Here's the water flowing in. Now, if there's a sudden violent storm that comes in and causes the sudden breakaway of land, this land breaks away, and now the water comes all the way up to here, right? But then the tide goes out and the tide remains back here and is no longer here anymore.
Gotcha.
But yet the land used to go all the way up to here, right? But it broke away. The property owner did not lose that land, even though there was a sudden violent change in the water. He still owns this land. Even though that land's not there, he has the right to backfill all this land to regain his property.
Gotcha.
Now, if that was not a sudden change, but it was a gradual change, they call that erosion.
Yes.
And he would not be able to backfill it. That would be up to the municipality whether they're going to do that or not. So erosion is I'm going to put the gradual wearing away of land by wind or water. Whereas avulsion is the sudden, when a stream suddenly changes its course, or it's a sudden change in the water, sudden change of the course of the water. So when a stream suddenly changes course.
So even though it's your property, Victor, and erosion takes place, the municipality has to decide whether or not you fix that?
Well, the situation he gave where it was on a stream and a boulder fell on someone else's property and caused the water now to rip away. I just gave you guys an example of what had happened if it was at a beachfront, if this was at the ocean and the water came in and ripped away the land. You know, they're two different scenarios, but basically the same thing is happening. There's a sudden change. But in the scenario he gave, the land ripped away from one's property and put onto the other guy's property. Okay. Does that mean that the other guy gained additional land?
No.
No.
No. So basically, here, what the example he gave here, let me put it, instead of being at the ocean, let me draw the picture. So if you have two people's property over here, okay, and here's the property line, and so that's the two people's property. Here's the property line, and you got the stream that's running over here, right? If that stream were to break off a chunk of the dirt from this side, and then it deposits that chunk of dirt on this side, did this guy gain that additional land?
No.
No.
No, it's actually his land. He didn't lose the land. He could build that back up. That's why I said it gets confusing. For exams, just study this. That term could be very difficult to understand. So let's just keep it with the definition that avulsion is a sudden change of a course of a stream. Is the sudden.
No, I was referring to erosion. You said
I'm sorry. Erosion is gradual wearing away of land by wind or water. Okay, so what was your question then again? I'm sorry.
I'm saying, no, you were saying that when erosion takes place, it would be up to the municipality if they want to
replenish.
to do that.
Yes.
So even though it's your property, You're not able to, if you don't want your property to stay like that, erosion takes place. It's the breaking away of the land. You don't want your property to look like that.
Yes.
It would be up to them to decide whether that's fixed or not.
Yes, because it is an act. It's erosion well, I mean, they're both acts of nature, but they consider erosion is the wearing away of that land. That land is gone now. You don't have the right. You don't have the right to build it back up. It would, but municipalities would have that right. But the individual property owner can lose land through erosion. But if it's a sudden change, a sudden tearing away of your land, a sudden loss, the law says that you have the right to replenish it. Now, these laws can vary. Like I said, they can vary slightly from state to state. I was trying to do some research on this the other day, knowing we're coming up to this, because I'm trying to find easier ways to explain this. And the water rights are they're not that easy, because they could also vary from state to state. Hold on one second. I could show you some resources for this. Let me see. Rights by a lawyer. I got a couple videos. I just want to look at them real quick. See, I don't want to show you the wrong thing.
Owning waterfront property can be wonderful, but you need to understand exactly what you own. Riparian rights.
Well, let's see if
owning waterfront.
With this guy, water rights under surface way. I don't know if he talks. I want to see his write-up and see what he talks about here. And he's just talking about this lawyer is just talking about the rights of way to the water, but he's not talking about the tearing away of it. Let me look at, I'm trying to find one where I do have a video that talks about the tearing away of the land. No, that's not it. See, this topic of avulsion is a tricky one. On this website, this is a Long Island lawyer. Long Island is, well, it's got a lot of arguments about erosion, and because it's surrounded by water pretty much. It's not, pretty much a peninsula. I guess some areas are even considered an island, Long Island there, connected by bridges and such. So there's a lot of issues that come up. Here's this lawyer here, Farrell Fritz, talks about a lot of these issues on his website that I found, talking about whether something is erosion or if it's considered erosion or if it's considered avulsion. Not sure if this is the argument, but it would greatly vary from state. Well, it could greatly vary from state to state legally when it comes to legal issues. And the examples you guys have been bringing up to me have been more legal issues like accretion, erosion, avulsion. Here we go. See this link? Look at this. You see this? If this was see this image on the screen here?
Yes.
See, if this was a gradual wearing away, it'd be up to the municipality to replenish this. But if this just suddenly tore away, this was all land that came out here, and it just suddenly tore away, this landowner can replenish that land here. And this is an issue that this attorney talks about here.
I guess the best scenario is to use Hurricane Sandy as an example. When Hurricane Sandy hit, it hit so hard, it just annihilated the shores from New Jersey all the way up into New York. So that will fall under evulsion.
Well, hold on a second.
Yeah.
Hold on a second. Because Sandy was a little bit unique. Most areas, not all, some did experience that avulsion, that sudden tearing away of the land, the sudden breaking away of it. However, Let me see if I have another example here. However, Sandy did a lot of depositing of additional land. You saw houses that were completely buried. Here, let me
Yeah.
see if I got a link here. All right, I don't want to look through this all right now. Let me just do a Google search. Hurricane Sandy, New Jersey. And if we do a quick search of Hurricane Sandy, New Jersey, I can look up some images. And are you guys seeing the browser window still?
Yeah.
Okay.
Yeah.
No, I can see the images.
Yeah, this is all in the web browser. Okay, you're seeing the images with the water here, right?
Yes, sir.
Okay.
Yes.
So in some areas, Sandy tore away land, but in some areas it deposited it. Look at this house. This property looks like it's covered in sand. I'm trying to find. There's a couple of images that are real interesting where the house is completely buried in sand.
I remember seeing that.
That Sandy did not just destroy property and tear away land. In some areas, it actually built it up. You know, look at this house. This house got sand halfway up it over here on this side, right?
Right.
Let me click on that. This is Ocean Beach, New Jersey. A lot of these houses. You see all this additional. No. Trying to find because it could. You know, water sometimes deposits additional soil.
Yeah. Yep.
Anyway, I don't want to waste time. Well, here, look at this. Look at this image. See, Sandy, see, instead of wearing away the beach here, it looks like it deposited additional soil here, okay? But there are some, I mean, it really screwed up this house though, but there are, excuse me, there are some houses that actually got the entire beach side of the house was completely buried in sand. I just can't seem to find those images right now. I don't want to waste your time looking for images just to show you. But there are some images like that. That's why I've been scrolling over here. I've been trying to find some of them where these houses get buried in sand. You can see there's some sand added here. Anyway, that's a depositing of the soil, which is another term we need to know, which is accretion. Hold on. There we go. Accretion. Accretion is the opposite of erosion. It is the process of water increasing the land by depositing solid material. Okay? I should say it is the gradual. It's the opposite of erosion. It's the gradual process of water increasing the land by depositing solid material. Because avulsion is a sudden change of the course of the stream. It can be the tearing away of land or the sudden depositing of it. Whereas erosion is the gradual wearing away of land by wind or water. Accretion is the process of the water gradually increasing the land. Yeah, I put that there. There's a process of water gradually increasing the land by depositing solid material over time, sand, rock, and dirt. And that solid material that it deposits is called alluvion. So when water is, what do we call the process of water depositing solid material gradually? Accretion.
Accretion.
And what do we call the solid material that's been deposited? The sand, dirt, rock? Alluvion.
Alluvium.
Now, if you see some of these if you see these as multiple choice answers on an exam, you're going to see all these A words, alluvian, avulsion, and they're going to throw in a bunch of other words. Oh, what was that? Somebody's water is boiling. So when you see a lot of these words, look at these two words, alluvian, avulsion. You put them next to each other in a multiple choice along with two other words that begin with A. You know, you're taking an exam, you're like, oh my God, which is which? Well, avulsion has the letter S in there. S for sudden change, I guess you could put, right? S for sudden change in a course of a stream, right? Alluvian doesn't have an S in it. Avulsion is sudden change. Alluvian is when you gain that additional solid material, the sand, rock, dirt. Alluvian, avulsion has one L. Alluvian has two L's. You gain an L, you gain some dirt. That's the way I look at it, you know. So the one that has two L's is the dirt that you gain, that additional soil. You gain an L, you gain some dirt. Is that a good way to remember it?
Yeah.
Yeah.
I mean, if it doesn't work for you, you got to find your own way to try to remember it. I'm just trying to figure out ways that you guys can try to, you know, remember these words easier, you know. So the one that has two L's in it is you gain an L, you gain some dirt. That's the dirt that you gained. It's called alluvian. All right. Now, reliction, you guys, when the tide goes out and the water recedes from the land, recede begins with R-E, so does the word reliction. Reliction is like a permanent receding of the tide where the water does not come back. The tide goes out and it never comes back. That does happen. It's a naturally occurring phenomena in science, right? And I'll give you an example of that about 30 miles away from here. The Meadowlands. The Meadowlands is a perfect example of that. We have highways, we got the Parkway, Turnpike, we got stadiums, we got all kinds of stuff there now. But this happened before any of us were ever born. The Meadowlands used to all be underwater. And one time, see, sea levels don't just rise. You know, the Earth, even though it looks like it's round on the globe, the Earth has a lot of hills and valleys, okay? And including underwater. You may see sea level rising somewhere, it's falling somewhere else, all right? So, you know, don't believe all the arguments that people just yell to you all the time. Oh, the sea levels are rising, we're all gonna be underwater. Yeah, well, it rises one place, it drops in another, okay? Reliction is a perfect example of this. The Meadowlands. If sea levels are rising, how come the Meadowlands is not all underwater again? That land hadn't been built up. This was a naturally occurring phenomenon. Okay? So reliction was a permanent receding of the tides where the water did not come back and bury that land. So now it leaves you more usable land. Reliction is not the creation of land. That land was always there. It's just making that land usable now.
Could it be the cause of, how do you pronounce that number one with allusion? How do you pronounce that word?
Alluvian.
Alluvian. So with the Meadowlands, could alluvian be the cause of what happened there at the Meadowlands?
No, because there was no additional soil that was deposited. That was an example of the water, the tide going out, and it just never came back.
That's wild. That's crazy, man.
You know what? I teach these classes. I've taught this class hundreds of times. I've had, I used to ask classes if anybody can give me an example of reliction. And I had one guy one time in one class, he was like as soon as I said that, he was like, oh, the Meadowlands. I was like, how the hell do you know that? What are you, a scientist or something? And he's like, no, he's like, I just did a tour with the Boy Scouts over there. My son's in the Boy Scouts and they actually did, I was like, they did tours of the swampland over there? Cause that's all like marshland, you know? And I was like, he was like, yeah.
Got a bad smell to it.
He was like, yeah, they go out in canoes over there and it's like a park ranger gives, they actually give tours of the waterways over there for the Boy Scouts and other people, you know? And as he's giving the tour and they're going out in the canoes in the water, they're explaining how at one point this all used to be underwater, and they're teaching the Boy Scouts that this was through a natural occurrence through a process called reliction, where the water receded and never came back. So look at that. So Boy Scouts, I guess, are still learning things, huh? So I guess it still pays to be in the Boy Scouts or something to learn, right? So this guy, the father, was with them. You know, I mean, I just found it kind of shocking that they're giving tours of that swampy land over there that stinks over there by the Meadowlands. You know, especially since you may find a body or two floating in there from time to time, right?
Oh my goodness.
Anyway, so the reliction could also be not necessarily that the tide went out and never came back. It could be when a waterbed dries up and, you know, where there may have been a lake or a pond and now that waterbed dried up and now it's usable land as well. They also refer to that as reliction as well. Okay, but it's not gaining any additional land. The land is just you're gaining land in the way that it just becomes usable now, but that land had always been there. It's not additional soil that's been deposited, like you were mentioning, through accretion. Reliction is when the water goes away, whether it's by drying up or the tide going out and not coming back. And that concludes our water rights words. And we'll come back. Wait, hold on a second. Let's highlight what we need to highlight now, and then we'll break for lunch, okay? So under water rights on page 68, I just want you to highlight littoral rights and riparian rights. You would pretty much have to go 2 lines below riparian, where it says riparian rights in bold, and underline the word navigable or not navigable. All right. And then on the right side of the page, we're going to highlight in the second paragraph under water rights. So it's basically 1, 2, 3, the third paragraph under water rights, the second sentence. If a stream were to suddenly change its course, it's a process known as avulsion. If you wanted to with your pen, you could just underline the property line would not change. You remember, if 2 properties are separated, 2 adjoining properties are separated by a stream, the stream changes its course, the property line would not move. It would stay where it would remain where it always had been. Accretion is an increase of land. We're going to highlight accretion is an increase of land caused by the gradual depositing of solid material called alluvion. And then 2 lines below that, we're going to highlight reliction is the creation of dry land by the gradual withdrawal of water from the land by the lowering of its surface level. And to avoid it being confusing, because I keep telling you it's not the creation of land, I want you to cross out the words creation of dry land by the. So this way you only have highlighted reliction is the gradual withdrawal of water from the land by the lowering of its surface level. And at the end of that sentence, you could write exposing land, not creating it.
Go to the 69 page.
68.
68. Right side, last paragraph.
Yep, reliction is the creation of dry land by the gradual withdrawal of water from the land by the lowering of its surface level. You're highlighting that, and then you're going to cross out the words creation of dry land by the. And then at the end of the sentence, you're going to write exposing land, not creating it. These water rights will be on school and state exam, I can guarantee. So study them. I know you didn't come to real estate class trying to learn about science, but sorry. I just don't shoot the messenger. All right. Now, I want to make one more point about water rights before we move on. Well, the word frontage describes the width of the front of the lot facing the street. So how many front feet you have is how wide the front of the lot is. But if you own a waterfront property, where's the more valuable part of the land? It's the side that's facing the water. That's why they refer to it as waterfront. So as you can, frontage is measured on waterfront properties by the side of the lot that's facing the water. So the water side of the property is the most valuable side, whether it's lakefront, ocean front, beach front property. In this drawing I made here, frontage is how wide. See, normally in the street, frontage is how wide the front of the lot is. So if you have a 50 by 100 foot lot, how much frontage do you have, or how many front feet? You have 50 front feet, or 50 foot of frontage. I want you to understand that terminology, how I'm using it in a sentence right now. However, if you have a waterfront property, frontage is measured by how much of your lot is actually facing the water side. That's the more valuable part of the land.
It's like owning property where you could ride your boat right up to your land and just get out and walk right through your backyard.
Yep. Yep. That's waterfront, right? Whether it's a lake or ocean or river or stream. I mean, you want to spend the time by the water, right? Everybody likes the water, except for those who can't swim. But, you know, most people like the water, so it's a more valuable part. All right, so we're going to break here for lunch. Okay, real property versus personal property. We need to know the difference between them because the methods of transfer of ownership between them differ. How do we transfer real property?
With a deed?
With a deed. How do we transfer personal property? We use some sort of a
bill of sale.
Some sort of a bill of sale, a receipt, bill of sale. Correct. All right. So personal property is all the property that does not fit into the definition of real property. Items of personal property are referred to as chattel or chattels. Okay. Chattel is a term that we need to know. Chattel is tangible personal property. So I don't like that definition. So I'm going to say chattel is tangible personal property. Because we do have personal property that's not tangible. What does tangible mean?
Anything that you could feel or touch.
Correct. So chattel or chattels is tangible personal property. Okay, trees and crops are real property. Well, no, crops are not real property. That is wrong. This is a slideshow that's created by the book manufacturer, so there you go. Crops, annual crops. That need to be planted every year are personal property. Trees and crops that don't require annual cultivation are real property. If they come back every year where you don't have to plant them on every year in order for them to come back. So real property versus personal property. Here's a good slide. Another word for tangible. Tangible asset is something you could touch or feel. Another word for tangible is corporeal. It's not corporeal. There's an extra O in there. It's corporeal. A corporeal asset is another word for tangible. So a corporeal asset is a tangible asset. It is one that you can touch or feel. Okay. Incorporeal is another word for intangible. This is an asset you cannot touch or feel. Assets based on emotions, such as views and rights, or interest, such as stocks or leases. Chattel is tangible personal property. It's usually movable and not attached to the real estate. So although sometimes people, when they sell property, they want to take the chandelier with them. A chandelier is considered to be part of the real estate because look how it's attached. It's permanently affixed. It's hardwired. But it can be removed if the person says so, makes that perfectly clear right from the beginning of the transaction that it's not included in the sale. But if they don't, and then the owner just tries to remove the chandelier at a later time, well, now they're in breach of contract because they're physically modifying the real estate that the buyer made an offer on. They didn't make an offer on the property minus the chandelier if you never notified them of that. So it's important for us as real estate agents to make sure that we are aware of what goes with the real estate and what the owner is taking with them. All right. So severance is a process of transferring real property to personal property by removal or severing it from the earth. For example, a tree. A tree is considered part of the real estate. You don't have to plant it every year and it's there year round, right? So a tree is considered part of the land or part of the real estate. However, it is possible to convert a tree to personal property. You cut the tree down, severing it from the earth. Thus, the process is called severance. So if you sever the tree from the earth, now you could cut it down. It could become personal property and you could sell it as a Christmas tree, for example, right? The reverse is also true. However, there's no fancy word for that. You guys can go to Home Depot or Lowe's and buy a bag of cement and take it home. What kind of property is that bag of cement?
Personal property.
Personal property. But you mix it with water, you pour it in a form, it becomes a step or part of the sidewalk, and now it's part of the real estate. Same thing is true is with the chandelier. You go to the store, buy a chandelier. What kind of property is that chandelier? It's personal property until you affix it to the real estate. Now, what determines whether it's going to be personal property or real property? Well, a couple things. The method of annexation to the real estate, how you're attaching it, the intention of the parties at the time they install it. You know, but because of that, it doesn't make it as clear what is considered personal, what is real. But we could automatically see if we're just to look at it and nobody says anything otherwise, when that chandelier gets attached to the real estate, it's considered part of the real estate because it's hardwired, it's bolted to the real estate, and it's usually not meant for removal. Emblements. What is an emblement? Emblements are annual crops, and they're considered to be personal property. So a tenant farmer, a tenant, not the owner of the farm, but a tenant farmer, a farmer who's renting the farm and tilling the soil and planting the seed and caring for the crop, they're allowed to return to pick the fruits of their labor to harvest the crop even after the farm had been sold. But they could only do this for this one harvest. They can't, it's the crop's not going to come back next year on its own unless you plant the seeds, till the soil, plant the seed, care for the crop until it grows again, right? So that's what they're talking about, a tenant farmer allowed to pick the fruits of their labor. So those crops that do not come back every year on their own unless you plant them again are called emblements. Another word to add to our definition list. So here's a couple words. Corporeal means tangible. Tangible is an asset you could touch or feel. Incorporeal is another asset that means intangible. It's something that you cannot touch, but it does have value, and it's like your rights or views or stock or leases. What is a lease? A lease is a document where an owner intentionally conveys all their rights, minus the right to sell the property. It's a document where an owner conveys all their rights to a tenant for a limited period of time as defined in the lease. So what does a lease symbolize? The tenant's rights to occupy someone else's property for a limited period of time. So therefore, a lease is an intangible personal asset. A lease is considered to be not real estate because you don't own real estate when you have a lease. You only have the rights to occupy someone else's real estate for a limited period of time as defined in that lease. So therefore, a lease is considered personal property and it is an intangible asset. You cannot touch your rights, but you do value them. Once again, chattel is tangible personal property. It is incorrect to describe chattel as personal property because as I just described, there is intangible personal property as well. So chattel is personal property that you could touch or feel. It's like the appliances, your furniture. This is your chattel. And you got to remove your chattel. You got to take your chattel with you on the way out. When you sell real estate, you're supposed to leave that property broom swept, broom clean condition. Okay. Once again, emblements. What kind of property are they?
Personal.
Personal property. And what kind of asset is it? Can you touch it?
Yeah.
So what kind of asset is it?
Personal.
It's tangible or corporeal asset.
Assets. Okay.
Okay.
That's what you're looking for.
Yep. Assets could be, okay, there's only two kinds of property in the world. It's either real estate we're talking about, which we also call real property or realty, or just refer to it as real. Okay. So real property is real estate or realty. Or we have personal property. Those are the only two kinds of property in this world, real property or personal. And then those assets could be tangible or intangible, meaning you could touch them or not, right? Would you pay more for a beautiful ocean view or mountain view?
Yes.
Yeah. So you do put value to an intangible asset that you cannot touch. Fixtures. Hold on, before we get into fixtures, let's go highlighting all this stuff that we just went over. How about that? Because we went over a lot of words. So under real actually before we even get to that, I like to go over the coastline and how much to finish up the water rights stuff. We did all those water rights, but on the top of page 69, we talked about how much coastline there is in New Jersey. New Jersey contains approximately 124 miles of coastline, with approximately half owned by municipalities, 1/4 is under private ownership, and the state and federal government each own about 14 miles. Property that borders on waters like rivers, lakes, and oceans are priced by front foot. Okay, I already went over front foot and waterfront properties with you. Just wanted to go over how much coastline we have and that some of it's owned by private parties, some of it's owned by the government, some of it's owned by our military. You know, we have the Coast Guard bases, right? The Coast Guard base over there, was that Sandy Hook? Okay, second paragraph down, highlight this almost the last sentence, tangible personal property is referred to as chattel. Everybody see that?
Yes.
All right.
Yeah.
What page is that again?
69. It's under real, it's under the title, real property versus personal property in the second paragraph, last sentence.
Okay.
Tangible personal property is called chattel or chattels. And if we go down to the next paragraph below that, the last two lines, real property ownership is transferred by deed, personal property is transferred by bill of sale. Which, let me go to the slideshow here for a second. I think I want to see if we have that listed on the next slide at all. Yeah, okay. I already got slides coming up with that. Okay, I just wanted to make sure. Okay, so real property is transferred by deed, personal property by bill of sale. Go to the last paragraph on the left side, page 69. 1, 2, 3, 4, 5, 6 paragraph down. It starts with vegetation. Falls into two classes. We have perennial bushes and grasses that don't need to be planted every year. They come back every year on their own. They're considered to be part of the real estate. They do not require annual cultivation. However, annual crops, we're going to highlight annual crops such as wheat, corn, and garden vegetables are known as emblements, and these are considered personal property. Okay. And then she made a note for myself on one of these future slideshows, and for a future class, I'm going to put in there a little clip from Stewie. You know, from Family Guy, how he says, "Wheat,
Cool whip,
wheat, cool whip."
yeah.
Make it a little entertaining, right? All right, can we sell mobile homes?
Yes.
Only,
Only
Yeah.
retail.
only
You can
they,
resell.
We could broker the resale of mobile.
Sale of
Yes.
mobile homes.
Okay,
We can't sell new ones.
exactly. All right, so that's all the next paragraph's talking about. And then the following after that is fixtures. I want you to highlight the first sentence. An article that was once personal property but has been attached to the land or the building in such a way that it's now considered to be part of the real estate is a fixture. And that's what I also have here on the slide. Fixture is an item that was once personal property, affixed permanently to the real property, making it part of the real estate. Now, trade fixture, I want you to highlight the first sentence in that. An article owned by a tenant and attached to rented space for use in conducting a business is considered a trade fixture. And then I want you to underline for use in conducting a business. And I want you to write next to the title, personal property. A fixture is part of the real estate. However, trade fixtures are fixtures that seem like they're attached and part of the real estate. However, they're installed by tenants to use for business purposes, and they're needed to conduct the business. So therefore, they're considered personal property, and that business owner can remove it, take it with them, as long as they remove it before the lease expires. It is possible for a trade fixture to become part of the real estate and the property of the property owner if the tenant does not remove it before the lease has expired. Okay, here's some examples of trade fixtures. A barber's chair. a gas station pump, shelvings in a supermarket, the ovens and stoves and hoods that are used in restaurants. These are all considered to be trade fixtures. The sinks in a beauty salon. You know, they got the sinks with the carved out neck, with the carve out for the neck so they could wash your hair in a beauty salon. Those sinks are for specific business purpose. They're not just sinks for the heck of it laying out in the middle of nowhere, not in a private bathroom, right? They're not, those are used for business purposes. They're trade fixtures. So you guys must know all the terms pretty much on this slide, except for severance. Okay?
All right.
You have to know the difference between a fixture and a trade fixture. Fixture is an article that was once personal property. Now it's part of the real estate because it's been attached to the real estate and made part of it. Trade fixture is also personal property that's attached to the real estate so that it becomes a fixture. However, it still remains personal property because it's needed by the tenant to conduct a business. And that tenant, when the business moves out, they can take those fixtures with them, provided that they remove them before the lease expires. If they did not remove it before the lease expires, then that trade fixture can become a fixture, part of the real estate, and now the landlord's property. Got it?
Yes.
Got it.
Got it.
Awesome. So, real versus personal property. Fixtures, personal property, permanently attached, tenant trade fixtures, legal tests of a fixture. Okay. Actually, I should just have this slide at this point to just be, the previous slide talked about fixtures. So this slide should just talk about legal tests of a fixture. Okay. All right, so we're just going to call this legal test of a fixture. So how do we determine what's a fixture or not? Fixture is personal property permanently attached to land or a building. Considered part of the real estate, right? So what are the legal tests of a fixture? How do we know if something is a fixture or not? And part of the real estate or personal property? It matters about the intention of the parties who installed it. Intention, parties installed it.
It's called Maria.
The method of annexation, the adaptation of the article to the real estate, and the relationship of the parties. Well, so I mean, if you were just to look at the book says, well, based on these explanations, it's pretty simple. It's pretty easy to tell what is considered a fixture or not, right? Well, let me ask you a question. A wall-to-wall carpeting that goes, it covers the entire area. It's not an area rug, but area rug is just a throw that covers a small area of the floor. But wall-to-wall carpeting, which is often stapled or even glued down, goes underneath the coping on the edges by the wall. Is that considered personal property that a tenant can take with them, or is it part of the real estate?
It's part of the
real estate.
I would say personal.
Real estate.
See, we don't
Personal.
see somebody said personal there. We don't get, not everybody's answering the same, and neither do judges. I mean, I would assume that it is considered part of the real estate. I mean, wall-to-wall carpeting is not an area rug. It is, when somebody installs it like that and they staple it to the floor or glue it down, I would consider that to be part of the real estate. Most people would, as they do here in this class. However, we still got one person over here. I don't know if he's just doing that for argument's sake or not, but just the same way, you get a judge that does the same thing. Not all judges rule the same. So even though we may have this here that shows you, it's not a definite, you go through these 4 steps and you automatically know if it's considered real property or personal. So
I said personal.
I know.
Said personal because of I know someone who lives in an apartment complex, and although it's hardwood floor, they chose to put wall-to-wall carpeting, and I told them, listen, you're gonna have to pay to have that removed, and they're like, I don't care, they're gonna pay for it to have it removed when the time comes, but they don't have no plans on moving it, but they did it because they wanted it. That's the only reason why, and that's of one person that I know that has done that. But
I think it's until the lease expire. What do you think?
Let me ask you a question. If you're selling your home and you got wall-to-wall carpeting in there, are you taking that wall-to-wall carpeting with you?
No, of course not. Without a doubt, that'll be a selling point. In fact, if it's the carpet is in really good condition, that'll be my selling point.
Okay, so
that'll be part of it.
So do you consider it to be personal property or part of the real estate?
I will consider it as part of the real estate, of course.
Okay, let me just mute that. We had some background noise. Okay, it's part of the real estate. I would assume it too. But that's part of the problem there, though, is because sometimes you still may get somebody who will say, "Oh no, it's personal property. I'm taking that with me." Look, you guys remember? Hold on one second. Let me give you a little clip over here and try to look up real quick. So, I mean, is the remote control for the garage door opener considered to be part of the real estate, a fixture, or personal property?
Part of the real estate.
It's part of the real estate, right?
Mm-hmm.
Yes, sir.
All right, and so that's considered to be part of the real estate. Well, but yet I've had instances where I've had people who wanted to, at the closing, they didn't want to turn over the remote controls for the garage door opener. They wanted an extra $25 or $35 for it.
Oh,
wow. What about the keys to the front door of the house? Are they considered personal property or part of the real estate?
They're part of real estate.
I mean, you guys are saying that like I should know this, and this is not shouldn't be assumed at all. But yet I've had people who try to hold the keys hostage for the front door. I mean, the keys go with the fixture, which is the front door lock, right? It's part of the real estate. But yet you get some people out there that, listen, never underestimate the cheapness of people, all right? It goes with the real estate. That's without a doubt. There's
common sense is
I've
not
never
common.
heard, common sense ain't so common though, right? Like what about the shades? You have shades or custom blinds for the windows.
Custom?
Part of real estate.
Yes.
Part of the real estate.
All right.
Part of the real estate. It's
So they're part of the real estate. They're
selling
custom
the car
for
and
that
expecting
window,
to keep
right?
the tires because they were brand new.
Well, you say they're custom because they're custom for that window, those blinds, right? But yet you
right.
But you may get the owner that says, no, I'm taking those with me. Because window treatments are considered personal property. Even though they're custom, I mean, they're custom for that window, they still are considered personal property. But this is why one person can interpret it one way, another person can interpret things the other. This is why it's important for us to ask when we're getting listings, homeowner, what are you taking with you and what are you leaving behind? You taking a chandelier, shades, things like that. I mean, personal property is like your furniture, the refrigerator, washer, dryer, that stuff. But are there any other items that would normally be considered part of the real estate that you were going to take with you that you consider to be personal property that you're going to take with you? If so, we need to know about that so we could disclose that to everybody now. If we don't disclose that, somebody makes an offer, then we could have some issues later, right?
Do you emphasize to them, Victor, that what's not on the list as part of personal property has to stay behind? Because with some people, and the reason why I understand, I have my own business, and you know, some of the things that these people come up with, you know, you'd be amazed, especially when you're dealing with different people on a daily basis. But you know, like when you go to a person and you're getting a contract, they want you to sell the house. You ask them, what is it that you're going to take? And then you go over the list with them, and then you come out and say, okay, only this. Do you find yourself having to do that? Only what's on this list is what can be removed. But what is not on the list, you cannot at the last minute decide to say, I want to take this, I want to take that.
Well, that's what we have to tell to the owner. We have to make that perfectly clear to the owner to avoid problems later in the transaction.
Absolutely.
Because otherwise the owner would be considered in breach of contract. They cannot just pop up something later on and say, oh, this is considered to be, I'm taking that with me, you know, like the chandelier. I think I already gave you the conversation about the one lady who said, like the toilet bowl, you know, are you taking the toilet with you? I mean, most people are like, no, toilet bowl is considered part of the real estate. It's connected to the plumbing, right? But I had that one lady who said, no, she's like, I'm taking the toilet bowl with me when I move. She's like, listen, I'm a tall lady and my husband is even taller than me. She's like, you know how hard it is to sit on you little people toilets, you know? And you know, it's a valid argument. That's a valid argument.
Yeah.
And one that I wouldn't have thought of because I'm an average size person. I'm 5'7", you know. So I wouldn't have thought about it, you know. But I could picture that. When she said that, you know, all I pictured was me sitting on a little kiddie toilet with my knees up in the air, you know? And so I could understand that, right?
Did you tell her she had to replace it with another toilet? She couldn't just leave it empty?
Well, no, this is one of my students when we were talking in class and we were just, you know, what do you consider to be real estate or personal property, you know? And I was like, the kitchen sink. I mean, what is that? Real or personal property?
That's real estate.
The kitchen, with the kitchen cabinets, part of the real estate. The toilet in the bathroom, part of the real estate.
Part of the real estate.
And this lady was like, nah, she's like, I'm taking the toilet with me when I move. And the whole class shot her a look like, what the hell? You know? And she was just like, no, she's like, I'm a tall lady and my husband's even taller. You know how hard it is to find a toilet for us? You know how hard it is to sit on you little people toilet seats? You know? And I was like, it was funny. But it made perfect sense. She had a good, valid argument for that, though. But if we did not find that out, we just put her home on the market, and then she pops that up later, well, you know what? Maybe the person buying that house is also tall, and they like the fact that they had tall toilet seats there. And now she's saying she's going to remove them and replace them with something else. Now, she'll be in breach of contract if she did not disclose that to begin with, right?
Right.
Right.
So one thing that I'm going to tell you guys is to never assume, right? What happened? I have the whiteboard open over here.
Yeah, it's stuck on that whiteboard.
Okay, you guys still see that whiteboard? Because one thing I'm going to tell you is like one of those Rodney Dangerfield skits, which I'm going to also say to add that into this class too, is you guys know what it means to assume, right? When you assume, you make an ass out of you and me. So
yeah,
always.
That's a good one.
Don't assume anything. Always ask what's included. Otherwise, you very, very well may be at the later on in this transaction be making an ass out of you and me, right? So,
Victor, I know of someone that real estate agent. They were selling a property, and the owner, normally you have to like they came in and they saw the house as is. But the owner was living there.
they're all as.
And and the owner was living there. And so after the closing, they went back to do a final walkthrough with the buyer. And when they went back, the stainless steel refrigerator was gone, and it was replaced with one of those regular white.
A white product. We call it a white product.
Right. It was replaced with one of those regular.
A white product does not describe it because it's white in color.
Right.
A white product is a typical appliance that you get off the shelf. Hold on, let me use this.
Oh, boy.
A white product is a product that you get off the shelf. What's that? Somebody at the beach there?
Yeah. I thought the same thing.
Yes, hi. Yes, Victor, it's me. Hello.
All right. Wow.
Colleen's at the beach and she didn't even invite us.
I don't need to disturb
Oh
you
my
guys. I'm
goodness.
sorry.
Okay, so
soak up some rays for me. God knows I need it.
hey, classes online, Who the hell she got an internet?
Yeah, well, yeah.
As she
Talk
learns,
about modern technology.
Right.
Hi, guys.
A white product, what I was saying, is not describing it just because it's white in color. A white product is a off-the-shelf standard product. They tend to be white, but so in this case, you just get a GE product off the shelf, the standard, GE fridge, you throw it out there. That would be a white product. So if they replace like a custom Viking refrigerator, they pull that out and then they replace it with some GE white product off the shelf from Home Depot. Yeah, that's a problem. That's a problem for sure.
Right, and it created an issue with the agent, and they called the owner. They said, "Listen, I didn't say I was gonna sell the house with this in it." And the guy was like, "But this is not something that was stated from the beginning." And
well, hold on one second. The refrigerator is considered personal property. They don't need to leave one there, period.
No.
No. Houses do not have, refrigerators are considered personal property. The house does not have to come with a refrigerator.
Oh.
Yeah. So there's that little thing.
Same falls
I
for
guess
washers
maybe
and
because
dryers.
the buyer was assuming that.
That's right. You know what happens when you ask.
I know.
He
You
made
just
an
said
ass
that.
as himself in the
I
realtor.
know. The owner already moved out, and it's not like the everything else was moved out apart from the stove and the refrigerator, and like the microwave, like the standard kitchen where everything is built in and whatever.
Yeah.
So I guess when the buyer came to do the final walkthrough.
Well, if the refrigerator is built in, hold on, that's a different story. If the refrigerator is built in to the cabinetry,
Yes, it is.
We have these ones that are called Sub-Zero. Sub-Zero is actually a brand, but Sub-Zero is a brand of refrigerator where you match the external, the sheathing on it, where it's not going to be like stainless steel. It's actually going to look like the cabinetry. It's made to be built into the cabinetry and to match the cabinetry. Those types of refrigerators, you better specify that you're taking it with you, because those could seem like they're part of the real estate. That one's not so clear. Usually refrigerators are personal property, but when it's built in, look at this method of annexation. How is it attached? How is it adapted to the real estate? Well, if it's built into the cabinetry, well, that's part of the real estate, or at least it could be considered such. Look, microwaves. Is a microwave considered personal property or part of the real estate?
Part of the real estate.
It all depends. If it's built into the...
It depends. Is it bolted in? Is it fixed in? Like bolted in? If that's the case, it's part of the real estate. But if it's just sitting on the countertop and you plug it in, that's personal property. You take that with you when you leave.
It was built in.
Dishwashers. Some dishwashers are not hardwired. They're plugged in and they're on wheels that you just slide under. Okay.
Right.
those ones they could go either way too. So you really have to, on things like this, you really have to nail the owner down on it and find out. And now you write it on the listing paperwork at the time you get, and on the seller's property condition disclosure report, so that it doesn't become an argument later. That's the whole point of me bringing this up. And look at this, we're doing arguments right now. We're just talking about it, you know? Imagine if this is a real estate transaction that you put an offer on, now you're surprised, you know?
The guy said he had to take money out of his pocket to buy because the buyer was like, I don't want this. And, you know, to kind of quench the argument, he kind of purchased the buyer refrigerator out of pocket just so he could go through with the sale.
Maybe he was just trying to avoid the problem altogether, but a refrigerator is not considered part of the real estate. It's personal property. The owner,
no, it was built in. It was built in.
It's built in. It's a little bit different. I thought you said it was the stainless steel. You know,
no, it was built. It was built in.
Yeah,
those same way with the microwave and everything.
Yeah, those built-in ones. It's a little bit different. Those are that's a different story. I understand.
It's not supposed to. We have to bring the buyer has to walk in before the closing, and be sure that everything is worked. They're not supposed to.
Well, you do
before the closing.
That's right. You do
the closing before that.
That's the whole purpose of what you just mentioned is a final walkthrough. Okay.
Yeah.
We do final walkthroughs here. We do final walkthroughs. Okay, so basically, real property ownership is transferred by deed, personal property transferred by bill of sale. All right, let me add another slide in here about final walkthroughs, okay? Or walkthroughs, how about that? So here, we'll do it this way. We'll just call it a walkthrough like that. Walkthroughs, okay. So with a walkthrough, we walk through the house at various stages. So a walkthrough, I know that's an abbreviation of it. A walkthrough is basically a walk through the house for inspection. Walking through the house for inspection, which can be done several times, right? So when do we do our walkthroughs? All right, we have a walkthrough when we get an appraisal done. Well, actually, you know what? We do a walkthrough when looking for a home. When looking for a home, you do the showing, right? Showings are walkthroughs, right? Right?
Yes.
Then you get appraisals. Appraisals are walkthroughs of sorts. We have home inspections. Home inspection after repair, follow-up walkthroughs to ensure work has been completed and satisfactorily. All right. Then we have
the inspection to get CO. That's a walkthrough too, right?
City inspections or municipal inspections, I can say.
So you could be there for every walkthrough?
If you are buying the house?
Yep. I would like to be if I'm the buyer anyway. Right?
Yeah.
And then let's see. So municipal inspections. What else? We also have the final walkthrough. We'll just leave it at that. We do the final walkthrough. Should be done the day of the closing.
Closing.
Should be done the day of closing, on the way to the closing.
Who will meet you there? The realtor?
For instance,
I mean, is realtor will meet the buyer there?
yeah.
Okay.
There's probably still a lockbox on the house. If not, have the seller's agent meet you there to let you through, to let you in. Okay. So the final walkthrough is extremely important, guys. And I'm gonna say it. When do you do it? On the day
of the closing.
Of closing, on the way to closing. Because I'm going to tell you a little story. I had a walkthrough that I did before where I usually did the walkthrough. Typically, I do my walkthroughs, maybe a day or two before closing, so that it's just for convenience. It's easier to get people through. But I had an instance one time where I took the buyers through the house. We did the final walkthrough the evening before the closing. And then the next day, I was getting ready to go to the closing, and the seller's agent calls me. And she asks me if I could do her a favor because the house is out of her way, but it's actually on my way to the closing. So I have to pass near that area. So she asked if I could do her a favor and get the lockbox if she gave me the shackle code for it. And I said, sure, not a problem. So the lockbox is a box. It's a digital lockbox. It's a digital key box.
Yeah.
I had one over here somewhere. I think I may have.
A sentry lock?
What did I do with it? I had a lockbox here somewhere. I think.
It's a spot where you lock the keys in. The keys, access to the house, the key's always there, providing you know the combination.
Well, it's a digital lockbox. It's a blue box. It looks
a sentry lock, right?
No, we use the ones from a company called Supra. It's actually
Supra.
GE Security. We use the Supra digital lock boxes. They're controlled by Bluetooth. Okay, so what happens is we could open up the shackle on the lockbox by Bluetooth on our cell phones. You have an app on your cell phone, and yeah, somebody left me a message. Okay, so we have an app. Let me see. I'm going to pull up an app I have on my cell phone called the Supra eKey. And when I click on it, we get something that looks like this, right? Got my picture there, my info. So I click on the key, and when I click on the key image here, I can put in my code, and it'll open up. It'll connect by Bluetooth to the lockbox. You press up on the bottom, it turns the key box on, so that it'll then communicate, and it'll then pop. It'll beep, and then you press up again, and the box falls out. It's a metal box.
The good thing about that, it keeps records of who goes in and what time.
It keeps a timestamp record. You could also limit the hours that another agent can open and get into that lockbox. But there's also here a shackle. You see, it says shackle, open shackle. Okay. So when you open the shackle, you click on that. If she gave me the code for it, I could type in the code and I could open up the shackle. And then I could take the lockbox off and I could bring it to closing to her. So that's what I was doing. And I figured out, while I was there, let me run to the house really quick, go to the bathroom, and just do a quick run through, even though I just went through the house yesterday evening. And then I get to I take the lockbox, I go to the closing. And I catch the attorneys talking to the seller, and he's like, did you guys get a chance to do your final walkthrough? Is everything okay? And they're like, yeah, everything's all right. And I'm like, we got a problem. Hold up, we got a problem. And they're all looking at me. They're like, what are you talking about? We were just there last night. And I'm like, yeah, we do have a problem, though. This purchase was a short sale. Now, this house, though, was high-end. The kitchen was all high-end, and the kitchen was all gone. From the time that we saw the house in the evening, the seller stripped out all the cabinets off the wall, They
Ay,
literally took the kitchen sink and the granite countertops. They
Wow.
they took all the appliances, and all those appliances were Viking appliances. Viking appliances are expensive. You know, you could get a Viking appliance. You could get a $30,000 stove. You know, so they had Viking stove, Viking refrigerator, Viking dishwasher, Viking hood. You know, for pulling the air out. A Viking. You know, everything was Viking, and everything was gone. There was nothing. It was four walls there with the pipes, just the pipes sticking out of the floor and the wall. And I was like, oh man, that sucks. You know, I was pissed off. You know, our job as real estate agents is to be neutral in the transactions. Well, we represent our clients, but we're supposed to keep business minded about it. So I flipped on the seller, who was there, by the way, and I flipped on him. I was like, you know what? I was like, the buyer, you know what? You stripped out the buyer, trying to screw them over here. If I didn't stop by that property and catch it, and you would have just went to closing, sold them the property, they would have had to call the cops because they've been robbed before they even get a chance to move into it. They're filing insurance claims. In the meantime, you're stealing the kitchen. You stripped out the kitchen yesterday after we went through and did that final walkthrough. Now, you took the cabinets, you took all that. You know what? And there were custom cherry cabinets, custom 42-inch cherry cabinets with nice etched glass and the wood. It was a very nice kitchen, you know. So I was like, you know what? They should back out on this, sue you, and let the bank foreclose on you. You know, I said, but if you still want to go through with this sale, you're going to need to bring back all of those appliances, and we're not going to close on this property till you bring back all them appliances, have an opportunity for us to inspect them to make sure that they're not dinged up and that they still work, that you didn't break anything. And then you're going to give them money. You could keep the cabinets and your countertops because for all we know, you broke them. You know, granite can break, granite can snap, granite can chip. You know, we're not going to have you come back and install it, and then they put in a teacup and the whole thing comes crashing to the ground. You know, you're going to pay for them to get a new kitchen. You're going to bring back those appliances, and you're going to pay for them to get new cabinets, new countertops, new sink, and everything installed, and you're going to give them the money. You've been living in this house for the last 5 years, not making mortgage payments, but yet you've been employed. That was the guy's situation. All right. And you're doing a short sale. You know, that takes balls that you're going to screw these people out of it because you put all this money in the property. And I understand that you don't want to leave this stuff behind because you're not walking away with a penny of profit. But look, you've been living in this house for the last 5 years, not making a mortgage payment. You earned your money back and you've been working.
Yep.
So it's not like you don't have the money to pay them. You're going to do that if you want them to close. Otherwise, they're not closing here. You could get foreclosed on, have your credit screwed up even further, and they're going to sue you, and the bank's going to foreclose on you. What do you want to do? You know? And then I let the attorney hash out with them how much money that they were going to determine that they were going to be paying out for that. But I told the attorney that it was all custom stuff, you know? So we did that. They actually closed, and they did the we put money in escrow. We held money back that we did not transfer over to their lender, to the seller's lender, until he brought back those appliances the same day for us to inspect them to make sure that they still work. And then they bought a house and they had to get a contractor to do work to, install a new kitchen. It was bullshit that they didn't have to deal with, but they did. So these final walkthroughs are very important. And even though I never experienced that before in my career until this one instance, but guess what I started doing after that one instance? Just takes one time. You learn your lesson. I mean, you could have
first time for everything.
Yeah, you could have hundreds of closings and never come across this. But the one that you come across, it's a nightmare, and it could kill a transaction. And what a scumbag this guy was. So I still managed to, I blew up on him. The attorney saw what I was doing. He just stepped back. He just let me go do my thing, because he saw I was all fired up, But then he handled like the money part of it and all that stuff, but they still closed on it. But they had to get a contractor, do the kitchen, all that, unfortunately. But they're at least glad that I caught it, because if I did not stop by there and I didn't catch that, they would have went to closing, bought a house, go to the house, the kitchen's gone. They would have called me screaming and yelling, right? I'd be like, hey, call a cop. You've been robbed. What do you want me to do? I mean, we know who robbed you, but what do you want me to do? You're going to have to file a homeowner's insurance claim, you know? So we were still able to do that. And so he came and brought them cash because you're not supposed to be paying somebody outside of closing and it not be disclosed on those closing statements. But he had to pay for that kitchen to get that kitchen. Otherwise, he was not going to close. You can't go back to his lender and ask them to lower the price now. They already agreed to a short sale for a specific price.
Yeah. Yeah.
The whole idea of them agreeing to do a short sale instead of foreclosing is because the seller is supposed to be working with the bank to help them on the close on a transaction. Anyway, so when you do your final walkthrough?
Day of the closing.
All right, so I guess that lesson was learned. That lesson was taught. All right, so we're done with this chapter. We're done with chapter 5. We're going to do the key terms to review. Key terms 1. Belong to the owner of the land below.
Right?
Yes, very good. That was a tricky one too, because if the land is below, what's above? The air. So 2 is A. Belongs to the land of the owner of the land below. 2 is A, air rights. The wearing away of land, usually due to the action of wind and water.
Erosion.
10 is B, erosion. Leave real estate to someone by will.
Devise.
Devise. 8 is C, devise. Another word for tangible.
Shit.
Corporeal.
Corporeal.
Corporeal. Correct. Corporeal. Yeah, I know, corporeal. I used to say it all the time until a student pointed out, hey, there's another O in there, you know that? And I was like, oh, you're right. Corporeal. Do it slow, okay?
It's number 4. It goes number 4.
So 7 is D. 7 is D.
7 is D.
Yep. Annual crops. Annual crops.
Embellments.
Emblements. 9 is E. Emblements.
We're hearing background noise.
Well, we're going to hear background noise from people during this stage, but here, I'm going to mute it because somebody's a little bit louder than the rest. All right, and so remember, if you're unmute. Which one did I leave off on? Annual crops, implements. Okay, tangible personal property.
Chattels.
Chattel or chattels, 6 is F. Manufactured attachments to land. Anything that you attach to land. Improvement. It's an improvement. 13 is G. Once 13 is G.
13.
Once personal property, now real estate.
Picture.
Sure. 11 is H.
Fixture.
11 is H. Sudden change in the course of the stream.
Avulsion.
What was that?
Avulsion.
Avulsion. 4 is I.
Okay. Oh, okay.
Anything that can be inherited is well, we kind of skipped over this, but it's hereditament. And it even sounds like inherit. So 12 is J. You don't need to add that term to your definition list. You're not going to see it on exam. Actually, you will see it on exam, but it'll be like one of the wrong answer options for something. Anything that can be inherited is a hereditament. 12 is J. An increase of land that's caused by the gradual depositing of solid material by the actions of the water.
Accretion.
1 is K, accretion. Possession, control, enjoyment, and so on.
Bundles of rights.
5 is L, the bundle of rights. Solid material deposited by a body of water.
Alluvium.
Alluvian. 3 is M. That's the one with the extra L. You gain an L, you gain some dirt, right? So 3 is M. So let me just run down that list real quick. All right. Number 1 is K, A, M, I. Hey, it's almost spelling my name, Kaminsky. K, A, M, I, L, F. 6 is F. 7 is D, C, E, B as in boy, H as in Harry, J as in John, G as in George. Key terms 2. Ready?
Mm-hmm.
When we do the key terms here, next to the letter A, I want you to cross out creation of and write the word exposing in its place. Next to A. Exposing dry land by the gradual withdrawal of water.
Religion.
No, improper.
Religion. Religion. 9 is A. Religion. Everything that's not real property is
Personal property.
Personal property.
6 is B. Personal property. Personality. A specific tract of land with legally defined boundaries.
Parcel.
5 is
Parcel. That is a parcel.
subsurface rights.
Mineral rights.
4 is D. Removable by the tenant.
Fixtures. Trade fixtures.
Trade fixtures. 12 is E. Land, improvement, and bundle of rights.
Real estate.
Real estate. F. 7 is F. Use of water by adjoining landowners.
Riparian rights.
Riparian rights. 10 is G. Intangible.
Incorporeal.
Incorporeal. 1 is H. The earth, including the air above. If the air is above, what is below?
The land.
2 is I. Land. Synonym for real estate.
Real property.
Real property. Realty.
8 is J. 8 is J. Correct. Ownership of minerals, oil, and so on.
Mineral rights.
Also known as subsurface rights. So 11 is K.
Yeah.
Land bordering bodies of water affected by the tide.
Littoral rights.
Littoral rights. Littoral rights.
Littoral rights.
Okay, so let me just run down that list real quick. H, I, L, D, C, B, F, J, A, G, K, E.
E.
As in Edward.
Thank you.
You're welcome. Let me get a second here. I got to open up that other slideshow, so just let me pull out the slideshow for chapter 6. Okay, where's my control? Let me get my controller here in the Zoom interface and open up the slideshow in chapter 6, estates and interests. All right. This chapter, we're going to learn about how to identify the characteristics of estates and land and describing the characteristics of encumbrances, liens, and easements, encroachments. And so let's just jump into it. Estates. What is an estate in land? Well, this particular chapter is talking about ownership in this chapter. But in the strictest speaking, an estate in land describes the amount and kind of interest. So an estate in land describes the amount and kind of interest that a person has in real property. There are 2 categories of estates in land. Freehold estates, which describe ownership, and there's 3 types of freehold estates. Hold on one sec here. There are two types of freehold estates. I'm just going to put them all down here real quick. A list, or do I have them in another slide in that little list already? I do, but I'll put it all in one slide here. That's not a, nah. We got it on another slide. We don't need to put it here again. Okay, so there are two categories of estates and land. They're either freehold, and freehold estates describe the amount of ownership. Okay, freehold estates describe ownership. It's the category of ownership, and there are three types of freehold estates. If it's not a freehold estate, it's a less than freehold, which is a leasehold estate. So a leasehold estate there are four types of leasehold estates discussed in chapter 12. Now, what are leases? These are not ownership, right? Leases, a lease is when an owner intentionally conveys all their interest in their real property to a tenant for a limited period of time as defined in the lease. Okay. So in the book, on the right-hand side of page 74, or second paragraph under estates and land, we're going to highlight the amount and kind of ownership interest that a person has in real property is an estate and land. And then I want you to cross out the word ownership. They only use the word ownership in that definition because this particular chapter is going to be discussing the three types of freehold estates which talk about ownership. All right. Boop, boop, boop. So next to number 1, where it says freehold estates, I want you to write ownership in the book. And beneath where it says less than freehold, I want you to write chapter 12, page 161. That's where we go over the leasehold estates in chapter 12.
Can you repeat that one more time, please?
Yeah, like you see here on the slide, next to number 2 in the book where it says less than freehold or leasehold estates, I want you to write chapter 12, page 161. That's when we're going to go over those 4 types of leasehold estates. All right.
Got it.
So, what is a leasehold estate? Before we get into the freehold, what is a leasehold estate? Well, these are estates for a specific period of time. Hold on, I lost my place. Too much clicking. These are estates for a limited period of time. For a specific period of time. A lease signifies the tenant's right to occupy an owner's property for a limited period of time as defined in the lease. Leases involve tenants. And leases are considered to be personal property, an intangible asset. They're not part of the real property. A lease signifies your rights or describes your rights. Okay. There are 4 types of leasehold estates, which we're going to go over in chapter 12 once again. They are an estate for years, a periodic estate, a tenancy at will, or a tenancy at sufferance. These are later discussed in chapter 12 on page 161. So now let's get into what this chapter is about. This chapter is actually going to be talking about, I'm not going to go into these leasehold estates in any other depth other than that for right now. Right now, we need to get into the freehold estates, the 3 types of freehold estates. Okay. There are 3 types. And here we go. We have fee simple, fee determinable, and a life estate. Now, fee simple is also called a defeasible fee. I'm sorry, wrong. Fee simple is also known as, it goes by several names: fee, fee simple, and fee simple absolutes. Actually, we have this written on another slide, so I'm not going to do that all here right now. Then we have fee determinable and a life estate. So here's the estates and land, the 3 types of freehold estates. I'm just going to put a number there. 3 freehold estates recognized in New Jersey. Okay, these are the 3 common types of freehold estates. We have fee simple, which is also known as fee simple, or fee simple absolutes. It goes by those 3. So it doesn't matter how they word it. They could word it as simply as a fee estate, a fee simple estate, or fee simple absolute estate are all the same thing. They are describing the same thing. It's the highest form of ownership, recognized by law. Highest form of interest, of ownership, interest, the most complete form of ownership in real estate recognized by law. It's unrestricted ownership forever. You own the property without restrictions. It's not based on any restrictions. Even after you die, you can determine what happens to your real property. Fee determinable. A fee determinable estate. Here, we're going to get rid of the bullet point on this first one. That there. And we're going to move these left one. Okay. So a fee determinable estate is also known as a defeasible fee or conditional fee. So it goes by those 3 names: fee determinable, defeasible fee, or conditional fee. This is ownership forever as well, but it's based on a restriction. So it's ownership based on a restriction. Ownership based on a restriction. Ownership that's based on a restriction. If the restriction is violated, ownership would revert back to the person who placed the restriction in the deed. And this is called the possibility of reverter. Okay. A possibility of reverter means that it's possible that the ownership can revert back to the previous, not just the previous owner, it could revert back to the person who put the restriction in the deed to begin with. So Shell gas station puts a restriction in the deed when they sold you the property that said that you cannot use it as a gas station anymore, ever. And that's fine, you're going to use it as an auto shop only. And then you sell it to me. Well, it's not a surprise to me because you're only passing on the rights that you held. So in my deed that I get from you, it also says that I cannot use it as a gas station. But I figure, you know what, I've owned this property for a couple of years now. You're out of sight, out of mind. Shell gas station's not coming for me. Well, I'm going to make a gas station out of it. If Shell gas station should find out about that, they can take me to court and regain ownership of the property without paying me anything because I violated the terms of the sale. It is ownership forever, but it is based on a restriction. And as long as I don't violate that restriction, I have ownership just like a fee simple estate. But if I do violate that restriction, there's that possibility of reverter where the property could revert back to the previous owner. Or it could go to somebody else called a remainder man. A remainder man is a third party named in an instrument. Instrument's a fancy word of saying document. It's a third party named in a document or instrument to be a beneficiary. Now, this restrictive condition that's added into the deed runs with the land. What does that mean that it runs with the land? That means it passes on to the next owner and can only be removed by the person who added the restriction, their heirs, or court.
He lost his lip.
All right? So a life estate is ownership. Now, you guys understand this one with how the remainder man works? Shell gas station.
I'm trying to.
Okay, here. How about this? I'm moving out of New Jersey. You are my neighbor. You're a good neighbor. I like you. We got along really good. I'm getting the hell out of New Jersey. I'm selling my property to somebody, but I'm putting a restriction in the deed that, I don't know, let me come up with something stupid. Say that you're a good neighbor. You asked me if I could put a restriction in my deed to make sure that whoever comes in doesn't put a garage on this side of the property or a shed on this side of the property because it would cast a shadow over your garden and you like to grow your vegetables and stuff. And I say, fine, I'm going to put a restriction in the deed that says that as long as you are my neighbor, and whoever owns this property can never build a shed or garage or anything that would cast a shadow onto that side of the property. All right? It's a weird restriction, but is there anything illegal about it? No. So
No,
I added
but I do feel that could depreciate the value some, right?
Then don't buy it.
Bingo.
That's my terms. Take it or leave it. Okay? So I put this restriction in. It's not an illegal restriction. If you agree to it, you have to abide by it. Now, I sold you the property and you figured, hey, I'm the owner now, screw him. So you put up a shed. You violated the terms of the sale. I can take you back to court to regain ownership of the property because you violated the terms of the sale if I find out about it. Or if I'm dead, my heirs would inherit any rights that I have. My heirs can take you to court. Or I could have named my neighbor as the remainder man. So my neighbor, who I was trying to help out to begin with this restriction, if they see that you build something that casts a shadow, you violate that term, that restriction that I placed in the deed that you agreed to, they can take you to court to take the property away from you because you violated the terms of the sale. Basically, I named my neighbor to be the remainder man. That's a third party named in the document to be the beneficiary. So they would benefit if you violate the term of the sale. If you don't violate the terms of the sale, they gain nothing ever. But if you violate the terms of the sale and I name them to be the remainder man, they could take you to court and take ownership of the property from you. That's what a remainder man. It's just a third party named in a document to be a beneficiary for something or other.
Okay, so question, Victor.
Sure.
Can you give an example? Just listen to this example because I'm trying to understanding it in my head.
Make it quick.
Say for instance, I have a property, and I said, okay, the terms are, I am giving it to my daughter.
Okay.
But my daughter is the owner of the property until her father dies.
All right, hold on a second. We didn't get there yet. Hold that thought. That's coming up. You're jumping the gun. We're getting.
I'm a little confused. Okay.
Hold that thought. That has nothing to do with this.
Okay.
All right. I'm selling a property, and I'm basing the ownership on a restriction. And as long as the new owner does not violate the restriction, the property is theirs forever. They got nothing to worry about. But if they violate the term of the sale, then the property would come back to me, my heirs, or if I name somebody else to be the beneficiary, if that restriction is violated, they would be called a
remainder man.
A remainder man. That's all.
I have a question.
Yeah.
I have a question. So, using the same scenario that you had used, not allowing a person put a garage or a shed because it's blocking the neighbor's garden. You're the one that placed up the. You're the one that placed up the restriction.
Yep.
Then God forbid later on down the line you had passed, and then the neighbor has sold the house.
Well, hold on a second. The way that I worded that restriction was that as long as she's the neighbor and you cannot build a structure or do anything, because it was specifically for her garden, because she liked to plant plants, and you know what, I was just being a nice guy, you know.
Yeah, if nobody knows, if nobody finds out.
Can she put that in as a selling point, saying, hey, look, they can't put a garage there because it's blocking
no,
this?
Because the way that I worded it I put a time limit on it. I said it's as long as she lives there, as long as that's
okay.
As long as she's the owner of the house, as long as she lives there, that restriction is there. Okay. Now, if I did not say that, if I just said you could never build anything on this side of the property that would cast a shadow on that side of the that neighbor's property, then that's forever. That means I could sell that property to you, you buy it, you got to abide by that restriction. If you resell that property to somebody else, the next owner has to abide by that restriction. That's forever. I could attach it to a time limit and say for the next 10 years. Or I could base it upon a happening as long as the neighbor is the owner.
Gotcha.
That particular neighbor is the owner. Okay. So there's a lot of ways to word it, right? Look, there's other wacky restrictions I think they mentioned later in the book. Kind of like, here's one. Listen, my wife and children died in a car accident with a drunk driver. And now I cannot stand that. People disgust me that drink and drive. I'm on a mission to rid the world of people who drink, period. I don't like drink at all. So I'm going to put a restriction in the deed, or maybe, yeah, whatever the reason is. Okay, let's go with that, my reasoning there. So that's why I got this state of mind that I'm going to sell my house. And whoever I sell the house to, I'm going to put a restriction in the deed that no alcoholic beverages can ever be present or consumed on the property. Could that reduce how many buyers are going to want to buy that house?
Of
Definitely.
course.
Absolutely.
Without a doubt.
Yeah.
And could that lower the value of the property as well?
Yeah.
Yep.
Yeah, without a doubt. But is there anything illegal about what I'm asking?
No.
No.
No. So if you don't want it, if you want to get your drink on every now and then in your own house, don't agree to buy the house with that restriction. Because if you agree to it, well, I'm only selling that property if that restriction's in it. Well, guess what? Time to move on and buy a different house, because
So Victor, I'm sorry, did you state
Makes
that
no
once
sense to
this
own
is
a piece
placed,
of property and have restrictions on it.
yeah, the least restrictions possible. Go ahead. Sorry.
did you state that once you put this on your deed, say for instance you own this property, and once you decide that, okay, what if you're having like this crazy day and you decide, okay, you know what, I'm gonna put this on it, and once you place that in the deed and it's signed and sealed, can it be changed? Can you decide you want to take it off?
Okay, so let's see. I put that restriction in the deed and I sold the property to you. You had no problem with it because you don't drink anyway. But now you sell the property to somebody else. Now, when you sold it to them, they knew that that restriction was in the deed as well. But they figured, you know what? I'm going to go back to the guy who put the restriction in the deed and see if I can get him to remove it. And if you come back to me, I mean, I had a reason for putting it in there. So I'm steadfast. I do not want it removed. But let's just say that, you know what, my heart's not that sold on it. If you offer me enough money, you bribe me somehow, I could possibly be persuaded to allow you to drink in your own house.
That is crazy.
And so basically, you can come back to the person who put the restriction originally in that deed to get them to remove it. Yes, it is possible.
Oh, okay. I thought once it's on there, it's for life.
It is for life if I did not put an expiration date or upon a certain happening that it would be removed, or I just stated that it's for life. Then it is for life. It's there forever. But I could always, somebody can come back and I could agree to remove it, and then it's fine. It can be removed if the person who put that restriction in originally agrees to remove it.
Right.
Or their heirs, or whoever, if I die, and my family then takes over, my family has the right then to decide. Okay. Next one is a life estate. A life estate is ownership based on the person whose life it is given to. So a life estate is ownership, however, it is based on the life of the person that it's given to. Life estates are usually given. Hold on, I'm just looking for something real quick here. All right, life estates are usually given. I give you a life estate. A life estate is based on the person's life in which it's given to. So let's see, a life estate is ownership. It is ownership. It is ownership. A life estate, I cannot stress enough, it is ownership. But that ownership is based on the life of the person it's given to. So if I give you a life estate, I'm giving you ownership of my property. And you have all the rights to ownership that any owner would have. You could sell it, lease it, give it away. You could do whatever the hell you want with it. But that ownership, you only have that ownership as long as you're alive. When you die, you cannot leave that property to your heirs. Because when you die, that property comes back to me. So upon their death, ownership reverts back to the person who gave the life estate, or to a remainder man if I name someone else to be a remainder man. So life estate is ownership based on the person's life it is given to. And you get all the rights to ownership based on a person's life who it is given to, and has all the rights of ownership. I'm going to put to sell, lease, mortgage, give away. Upon the death of the owner, upon their death, ownership reverts back to the person who gave the life estate, or to a remainder man. So is ownership based on the person's life it is given to? That's why you cannot leave by will. And you have all the rights of ownership. You could sell it, lease it, mortgage, give it away. Upon your death, ownership reverts back to the person who gave you that life estate, or to a remainder man. All right.
Victor.
Yes.
And a question there. In that case, for example, you give it to me, and I'm selling, then that's it. That whatever you give it is done, right? It's not the new person. If I die, the other person has to give it to you back, or no?
Yeah. If I gave you a life estate and you die, the ownership comes back to me.
But if I selling the property in the time I'm alive, what's gonna be happening?
Okay, hold on a second. So if I give you my property and you sell it, what are you selling? You're selling
property.
You're selling the real estate plus all the rights that you had. And you have all the rights to ownership. But those ownership rights are only good for as long as you're alive. So whoever buys that property from you is only buying that property and all the ownership rights, but it's based on your life. If you die, they lose it and it comes back to me still.
Wow. And the person lost all the money?
Well, they better make their offer accordingly, knowing that what they're buying is a life estate based on your life.
Wow. So that life estate won't be transferable to the new one.
You mean, can you transfer the person's life that it's based on? No.
Oh boy.
Only you can do it. Only you can do it. Because
only I can do that.
Okay.
All right. Here, let me. Yeah.
That's one of the things, and the title has to check whatever condition have it when we buy a house.
It'll be written in the deed itself what kind of estate you're buying.
That means that the title company has to check all that.
That's why you do a title search.
And the buyer attorney has to be sure there's nothing on that condition. It's completely clear.
Yeah.
Oh, okay.
Yeah, you got to make sure. Well, I mean, there's nothing wrong with you buying a life estate as long as you're aware of what you're buying. So aren't you going to, if you're buying somebody's life estate, you're probably not going to pay them as much as you would if you're just buying a fee simple estate, right?
All right. Yes.
Somebody else had a question there?
No, I was trying to have an example. Like,
okay.
I know this.
Okay, hold on. Let me give you an example, okay? Hold on, Jenny. Give me 1 second. I'm going to give you an example, okay?
All right.
I'm going to give you an example in just 1 second. Hold on, bad examples here. There are so many different versions of this one story out here that I'm about to give you, but a lot of them are fuzzy on the facts. They don't have the right information on the facts. I did a lot of research on this, and I just want to make sure that you have all the facts to it when I point it up, because I'm sure you guys will have a couple of questions, but.
Yeah, because what happened, I have this person that I know,
Uh-huh.
and he take care of his parents all the time. But he also have brothers and sisters that are taking advantage of that situation. So they are thinking when the fathers die, they are gonna get something of the property. But when the parents die, the property is coming back to the brother that bought the property and take care of the parents. So the heirs have to find out what they are gonna do, because the house is not gonna be for them anymore.
Mm-hmm.
It's just because the parents allowed them to stay there. You understand what I'm saying?
Yeah, we're going to get into that in a second, because that's a little bit different. But here, hold on. Let me show you something. Anybody recognize this guy right here?
Yes.
Yeah, Hugh Hefner.
That's Hugh Hefner, and this is the Playboy Mansion.
Oh yeah.
Yeah.
Well, Hugh Hefner actually sold the Playboy Mansion before he died. And he still lived in the Playboy Mansion. All right. I'm trying to find a story here about it. I was trying to find some kind of a story about this by doing a quick Google search. Hold on a second. I'm only finding images. That's why. Hugh Hefner, basically, like this story over here about Connecticut real estate, this is wrong. Playboy Enterprise sold it but Hugh had to pay $1 million a year in exchange for being able to live there. That's not true. Hugh Hefner only had to pay $100 a year. Hugh Hefner, when he was still alive, he sold the Playboy Mansion. Okay, he sold the Playboy Mansion to his neighbor. Okay, he sold the Playboy Mansion to his neighbor while he was still alive, with the condition that the person who bought the property for him had to give him back a life estate that would allow him to live there for the rest of his life. So basically, Hugh Hefner sold the Playboy Mansion to somebody with the condition that he give ownership back to Hugh so that he could live there. Now, that one condition was based on Hugh Hefner had to pay his neighbor $100 a year. Okay, it's not $1 million a year like this story says. There's a lot of different stories out there that go about Hugh Hefner and that's just not. This story's not true. I got the link somewhere. I'm not sure exactly where I got it, but there's a lot of different stories to this, and you'd actually be surprised what happened with Playboy. Hugh Hefner actually, he was not rich at the end of his days. Even though he sold the Playboy Mansion for $100 million. Okay, his original asking price on it was $200 million. However, it was in disrepair. It needed a lot of work. And the original plan was his neighbor wanted to buy it because it was so many acres of land. His neighbor wanted to buy it and was going to just expand, include it into his estate and make it larger. So he may have had plans to tear it down. But according to the agreement, Hugh wouldn't agree to that. He had to agree not to tear it down. Playboy Mansion. See, he originally listed it for $200 million to his neighbor. His neighbor was the heir to Pabst Blue Ribbon, you know, the beer company.
Right.
Let me see. So this is Pabst Blue Ribbon, but he also owned what's it? It's one of those heirs to those food fortunes that have all Procter. Was it Procter and Gamble? No, not Procter and Gamble. One of them, so similar to Procter and Gamble, where they own a lot of different brands of food and such. So this guy, one of the things he owned was he was the heir to Pabst Blue Ribbon beer, and it's one of these like Procter and Gamble type companies where he owned all of this stuff. So Hugh Hefner sold the Playboy Mansion to this guy with an agreement that he gave Hugh a life estate. So what did he do? He bought the Playboy Mansion for $100 million and gave ownership back to Hugh Hefner. So Hugh Hefner can live there for the rest of his life. You know, but that agreement, you know, also required Hugh Hefner to pay him $100 a year. I don't know what that was about. Maybe just to make it legal. Because every contract has to have something of value given in exchange for it. So basically that was a true example of a famous life estate right there. All that property on the Playboy Mansion, right? And some very expensive area in real estate. So there's a real life example of it. And unfortunately, Hugh Hefner sold the Playboy Mansion, got a life estate. He only had to pay $100 a year to remain there for each year for the rest of his life. However, Hugh Hefner died the very next year. So that ended up getting the property back the next year.
So that was a good deal.
It was a good deal for him. Yep.
Yeah.
Yep, absolutely. All right. Let's go back to the slideshow. But there's a real life example of where a life estate would be used. Now, life estates can also be used in cases where, say that you're selling, you know, somebody was trying to bring this story up before. Say that you have children, you were married and you had children with somebody. Now you're divorced and you're married to somebody else. And you put in your will, you know, you want, or not necessarily in your will, you could do this through a life estate, that you want your husband to be able to live, or your spouse to be able to live there for the rest of their life. You want your kids to get the property, but you want the kids only to get the property after you and your spouse die. So that you don't want your kids kicking your spouse out of the house, you know, because that's not their father, you know, after their death. You know, so there's kinds of arrangements like this that could happen using life estates.
And then kids kill the parents.
Hopefully not, because then they'll go to jail, right?
What?
Now, you have something also called, there's a twist to a life estate. There's also something called a life estate per autre vie. Per autre vie. A life estate per autre vie. Per autre vie means for the life of another, or it's based on another person's life. Okay, this is not French, this is Latin. Any kinds of wording that we're going to be learning like this, legal terminology uses Latin. There is the same phrase that has the same meaning in French, except it's not spelled P-U-R, it's spelled P-O-R. In French, it would be P-O-R, pour autre vie. But it's still pretty much the same, it has the same meaning, for the life of another. So a life estate per autre vie is when I give you a life estate, but not based on your life, but based on someone else's life. So let me give you an example. Let's just say my elderly parent is sickly, and you have some nursing experience, and I'm getting the hell out of New Jersey. I'm going to give you my house. I'm giving you a life estate. I'm giving you my house with a life estate. But it's going to be based on my elderly sick parent's life. And it's going to have a further it's going to have a further restriction in there that you have to live in the house and so does my parent, and you have to take care of them. But upon the death of my parent, because the life estate is based on my parent's life, not yours. But when my parent dies, you lose the estate and it comes back to me. So there's your incentive to take good care of her.
Exactly, and not to kill them.
Right?
I actually know someone who had experienced that.
Yeah.
They actually lived in a house and they was in charge of everything. I didn't know what it was called at the time. But
now you know.
And they got like a good 6-7 years out of it. And then once the
what the hell?
elderly person had passed away, they had to move out.
You know, what the hell? They're giving you ownership. I mean, it's a free place to live. You got a free house. You can do whatever the hell you want with it, you know? So you could own this house. Now, in this particular instance that I spelled out, see, if I didn't spell out that you had to live in that house, you could have thrown her in an old age home and rented the house out or sold it or sold the life estate, right?
Exactly, yes.
Right.
So I had to put in those further restrictions in there. Otherwise, you still have ownership, but you have all the rights to ownership. You can do whatever you want with it. You know, you could sell it, lease it, give it away, you know. So I had to put those additional restrictions in there that you and my elderly parent had to live in that house and you had to take care of her in order for that life estate to be in effect. Otherwise, it could be terminated. All right. So these are the 3 types of freehold estate. Wait, so is a life estate a form of ownership?
Yes. Yes.
Yes.
Yes. Yes.
It is ownership, but it's based on your life, or based on the person's life it is given to. A life estate per autre vie is not based on the life of the person it's given to. It's based on someone else's life. Right? So the term per autre vie means for the life of another, based on another's life. So a life estate per autre vie is not based on your life, but someone else's. All right. So fee simple is the highest form of interest recognized by law. The holder is entitled to all the rights in the property. On the owner's death, the estate passes to their heirs. Fee, it's also known as fee simple, and fee simple absolute. Yeah, I'll just keep that there. Fee simple absolute. Okay. Now, fee determinable, the one that's based on a restriction in New Jersey, an estate that can terminate on the occurrence or non-occurrence of a specified event, as long as that event or restriction, as long as that restriction is not violated, your ownership continues. But there's the possibility of reverter and a remainder man involved. Okay, so this one slide number 7, is the one that gives all the details, gets into the nitty gritty. This is just the slides the book manufacturer gave that I didn't delete. Okay, which I probably should just. Okay. So we can just copy these over here. So the fee simple estate, highest form of interest recognized by law. Highest form of ownership interest recognized by law. It's unrestricted ownership forever. Holders entitled to all the rights in the property. On the owner's death, the estate passes to their heirs, known as fee simple, or fee simple absolute. Okay. Fee determinable. Let's highlight this one. The determinable estate, New Jersey, an estate that can terminate on the occurrence or non-occurrence of a specified restriction. So fee determinable, also known as defeasible fee or conditional fee. Defeasible fee or conditional fee is ownership. Is ownership forever, but based on a restriction. If the restriction is violated, ownership would revert back to the person who placed the restriction in the deed. This is called the possibility of reverter, or
remainder.
It would go to a
Remainder man.
And a remainder man's a third party named in an instrument to be a beneficiary, right? So we'll just put that there. So we're going to add over here that, oh, I'm not going to add it there. We're going to add right here that
And you can have more than one beneficiary, right?
What's that? You can have
Can
more
you have more than one?
For the remainder man, I guess you could, but I'm assuming that though.
Assuming.
All right. You know what? I don't want to have this so small. Okay. I would assume that possibly you could, but that would get a little complicated. Then you get people fighting over who gets it, unless they get to share it. So I guess you could. Anything's possible. And lastly, a life estate is limited to the life of a specific person it is given to. There's a reversionary possibility of reversionary interest. What do you call restrictions placed in deeds?
I mean,
What is that
things
question?
you cannot do. I mean, that are restricted, like
well, there's a name for it.
no
What
pets allow.
What do we call restrictions placed in deeds? Well, this is a legal promise. A legal promise is also known as a covenant. So this would be called a restrictive covenant. Not a coven. Coven is a bunch of witches. This is a restrictive covenant. A covenant is a legal promise. This is a restrictive legal promise. So restrictions placed in deeds are called restrictive covenants. We'll have that on a later slide as well. A life estate can be tied to the life of a third party. That would be per autre vie, right? Life estate per autre vie. And a holder of a life estate has true ownership of real property with all the rights and benefits. But only for their life. a life interest may be sold, leased, mortgaged, or given away, but it's always will end on the death of the person whose life the estate is measured. All right. So, cannot be left by will. Cannot be left in a will to heirs. There we go. Dower and courtesy. We went over this before. This was New Jersey abolished the creation of any new dower or courtesy rights in New Jersey in May 28, 1980. Dower is what? That's the wife's right. Courtesy is the husband's right. So dower is the wife's interest in her husband's estate upon his death. Courtesy is the husband's interest in the wife's estate upon her death. New Jersey abolished the creation of any new dower courtesy rights as of May 28, 1980, and instead now gives both parties, both the husband and wife, the right of joint possession of the property that is their main marital residence. All right. We got here this fine print here. I got property acquired before this date gives the surviving spouse a life estate of half interest in all the real estate owned by the deceased person, no matter what other provisions are made in the will. In New Jersey, children may be disinherited, but the surviving spouse is entitled to at least 1/3 of the estate and the property. Okay. Life interest. It's not of half. Life interest in all. I wrote that before too. Spouse of life in all real estate owned by them. Okay. And we already went over right of election and all that stuff. We went over this in chapter 20. Remember that we did that earlier?
Mm-hmm.
So I'm not going to beat that dead horse, but we can go to the book now. We can highlight the things that we went over. Page 75. I want you to highlight under leasehold estates where it says, it's just above where it says fee simple estate in bold. I want you to highlight leaseholds are considered to be personal property, not real property. And right immediately after that line, either intangible or incorporeal asset.
Page 75 on the left or right side?
Just above where it says fee simple estate in bold. Do you see the title? You see it?
Mm-hmm.
Okay. So just above fee simple, it says fee simple estate. It says leasehold estates. You're going to highlight that second sentence. Leaseholds are considered to be personal property, not real property, and it's an incorporeal or intangible asset. And then under fee simple estate, which is just below that, you're going to highlight the first sentence as well as the last sentence. Basically says that fee simple estate is the highest form of ownership recognized by law, and that it goes by three names: fee simple, or fee simple absolute. They're used interchangeably. They all mean the same thing. It's ownership forever without restrictions. Then go down to the next one, fee determinable. And I want you to write above this, ownership forever, but based on a restriction. I want you to pencil that in there. Ownership forever, but based on a restriction. Because if you're only
what do you want this, what do you want us to write it at?
Above fee determinable.
Ownership forever, but based on restriction.
That's correct. Ownership forever, but based on a restriction. And then I want you to highlight fee determinable is also known as a conditional or defeasible fee estate in land that can terminate on the occurrence or non-occurrence of a specified event. Then go down 6 lines, and at the end of the 6th line, you're going to highlight future interest is called the possibility of reverter. You're going down 6 lines after the first sentence that you highlighted under fee determinable, and you're going to highlight future interest is called the possibility of reverter. And then lastly, highlight at the last line, a remainder man is a third party named in the instrument. And I'd pencil in at the end of that to be a beneficiary. To be a beneficiary.
I do not see the part where it says a remainder man.
It's in bold under the last line under fee determinable.
And what did you say to pencil in? I'm sorry.
To be a beneficiary. To be a beneficiary. So it's a third party named in an instrument to be a beneficiary. And then the next thing we're going to write next to life estate is ownership, but cannot leave by will and is based on a life. If you don't think you got enough room there, write it under it. Is ownership, but cannot leave by will and is based on a life. So a life estate is ownership, but cannot leave by will and is based on a life.
Page 75, right side.
Nope, down the bottom, life estate.
Life estate, okay.
Underneath life estate or above it, wherever you could fit, is ownership, but cannot leave by will and is based on a life. Okay. And on the right side of the page, second paragraph. So it's basically the second paragraph under life estate. We're going to highlight a life estate per autre vie for the life of another or for another's life. A life estate per autre vie for another's life. It's in the second paragraph, 4th line. Okay.
Wait, I don't find it.
Second paragraph under life estate, 4th line down. Life estate per autre vie for another's life.
El segundo párrafo.
I don't see it. The beginning of the sentence says, then Charles would have a life estate for autre vie for
No.
Like,
Yeah, the beginning of that sentence says that, correct, yes.
It's life estate, 4th sentence down. Oh, life estate answer the definitely wrong for you.
You see the paragraph that says life estates can also be tied to the life of a third party? See the paragraph that starts with that?
Or right above, when Betty dies, Charles' interest. You see that?
Yeah. After that.
Just above that. It says life estate per autre vie for another's life.
Oh, got it. Otra vez for another's life.
Everybody got that now?
Yes.
Yes, sir.
All right.
Yes.
Now go down to dower and courtesy. And you're highlighting like the first 3 sentences that say, dower is an ancient right under which a wife has certain interest in her husband's death in any real estate he owned during their marriage. Courtesy is a similar right that a husband has in the wife's estate. As of May 28, 1980, New Jersey abolished the creation of any new dower or courtesy rights. And instead, they give the right of joint possession to whatever is the primary marital residence. So just highlight all that. Now, it's important to understand the dower and courtesy rights because we need to be able to understand what the spouses need to sign, who needs to sign contracts. So let me continue reading. It says, the real estate broker must learn which rules apply to any specific case in order to judge whether both spouses need to sign documents or only one, when only one owns the real estate. Well, basically, if you were married before May 28, 1980, it doesn't matter if only one person's listed as the owner. You both need to sign all the documents because your spouse has an interest in your property. If you're married after May 28, 1980, only the spouse that's listed as the owner needs to sign the documents, unless it's the primary marital residence. If it's the primary marital residence, then both spouses, of course, need to sign. Turn to page 76. And they continue explaining that same thing, scenario, what I just explained to you here. All right, next is encumbrances. If you are encumbered by my weight, forget about, guys, what is an encumbrance? Do not read this chart. Do not read this slide. The word encumbrance in the everyday English language.
A claim?
An encumbrance, it's something that weighs on you, right? Let me give you an example. If I jumped on your back and I hold on,
A weight.
you're encumbered by my weight, right?
Yes.
A burden.
Yeah. Under pressure, burden.
Now, can you still move? If I jump on your back, can you still move around?
A little, maybe wiggle.
Yeah,
no.
You could still move. It's just going to be a lot harder to, right?
Right.
Yeah.
Right.
Yes. Because you're encumbered by my weight. I mean, you could still move, but it's a lot harder to move, right?
Right.
So you guys got that visualization of me jumping on your back and you're like, oh, whoa, and you could like hardly move now. You're trying to stabilize yourself. You could still move, but it's harder to move.
Yeah.
Now, before we even talk about encumbrances with real estate, let me ask you a question. Without knowing what an encumbrance is in real estate yet, if real estate is very similar, can you move real estate that's encumbered by something, whatever a real estate encumbrance is, which we didn't go over yet?
No. You can, but it's probably hard to.
Hold on. Can you move if I jump on your back? Yes, you can, but it's harder.
Yes.
So with real estate, can you move it, sell it, if it's encumbered by something? Yes, you can. It's just harder to.
Right.
I want you to keep that visual and that comparison in your head. This way you don't get confused ever. So now, when we're going over encumbrances, now we're going to learn about the types of encumbrances. But look, before we even learned about the types of encumbrances, we know that if real estate's weighed down or encumbered by something, there's some kind of a problem. Can you still sell it? Yes, you can. It's just harder to. So let's go over now what those encumbrances are. An encumbrance is a
claim.
There we go. An encumbrance is a claim, lien, charge, or liability attached to and binding on real property. It limits its use, value, or title. Liens are financial claims on property. Liens are considered encumbrances, but they are financial claims on properties like a mortgage lien. Or if you get a lawsuit, you get a judgment against you and somebody places a lien on your property based on that lawsuit, the money that you owe them. It's a financial claim.
Or the taxes, back on the taxes.
Tax liens, etc. Correct. They're all financial claims. So liens are specifically financial encumbrances. Mortgage liens, tax liens, lawsuit judgment.
Mechanical liens.
Now we have, well, that's, yeah, because it's for money. It's for money. Mechanics lien, yeah. A mechanics lien is a contractor's lien that hasn't been paid. You have physical or usage encumbrances as well. Now, these are not financial. A physical or usage encumbrance would be a deed restriction. You cannot use the property. You can't have alcohol in the property. You can't use it as a gas station. Can't build a shed on this side of the property. Could those things limit the value or desirability of the property?
Yes.
You can't use it for a certain purpose?
Yes.
Yeah.
Yeah.
Easements, we're going to get into. We're going to get into licenses, and we're going to get into encroachments shortly as well. Okay. Basically, I'll give you a quick rundown real quick. Easement is a right to enter someone else's land for a specific purpose. Licenses are permission to enter the land of somebody else for a specific purpose. And encroachment is anything that crosses over the property line. So if your neighbor builds a shed, but it goes over the property line, or they put up a fence, but the fence is on my property, they're encroaching in my territory. That's an encroachment. Okay. So as far as encroachments go, I got another idea there. Here's a brain teaser. All liens are encumbrances, but not all encumbrances are liens. And that's true. And you may have gotten a little bit lost. If you got lost in that, let's just slow it down for a second and do translation in our head. All liens are encumbrances. Okay, wait. So what's a lien? A financial claim. So all financial claims are encumbrances. But not all encumbrances are financial claims. All right, that makes sense. You see how we do this? If we slow it down and we read it and we translate the words in our head because we know what the words mean now, that's what you should do on exams as well. How you should read the questions. You should translate them in your head like that before you continue on. Now, encumbrances, liens, and otherwise, they run with the land. So, what does that mean? Liens attached to the property, not to the property owner. So if you sell the property and it's encumbered by a lien, guess what? The next person who buys the property is buying the property with the lien and has to pay them. So real estate taxes have first claims against the proceeds of a sale. What kind of sale? Well, all sales. Real estate taxes have to be paid first. But if in the event of foreclosure, that there's a foreclosure sale, liens have to be paid. The real estate tax lien has to be paid first. Now we have different categories of liens. Liens can be voluntary or involuntary, right? Or they could be general or specific. What is it? What does voluntary mean?
Want it to happen?
A second mortgage?
Something that you wanted. What does involuntary mean? It's something that you don't want. What does it mean general when we're talking in general? It's a wider scope, right? Remember I told you this already? When you go like this, when you talk about the word general, you should go like this. When talking in general is a wider scope. It means you could do more or it covers more. So a general lien would cover all the property that you own, whereas a specific lien covers only one specific property. General covers all the property you own. Specific covers one. Got it?
Yes, sir.
All right. So here's some examples of voluntary liens. A mortgage loan is a specific lien. And it's voluntary because you went out of your way to get it. It's specific because if you don't pay it back, can they touch any other properties that you own? No.
Yes.
No.
No, it's only specific.
They could only go after that one property.
Oh, yes.
So that's what I mean by it being specific. Home equity line of credit. This is just another type of mortgage loan. It's specific lien. It's voluntary. You went out of your way to get it. Involuntary liens are things like real estate taxes. Nobody wants to pay real estate taxes, but you still have to pay them, right? So these are specific liens, though, because if you don't pay your real estate taxes on a property and you own more than one property, they could only go after the one property that you did not pay the taxes on. Unpaid federal income taxes. These are also involuntary lien. Who wants to pay taxes? However, income tax is a general lien. The IRS can come after all the property that you own. Hell, they could even come after you. They could throw your butt in jail until it's paid off, right? You're paying it with the time.
Yes,
Lawsuit judgments are considered general liens as well, because you could take that judgment. A judgment is a decree from a court. It's a letter that just says you owe this person money. We know that it's one thing to owe someone money, another thing to collect it. So if I have a judgment against you in a lawsuit and I find out you own a couple properties, I could take that judgment and create a lien on all your properties until it gets paid back. So lawsuit judgments are general liens. Now, satisfaction of judgment is a document that's recorded by the lender in the public record showing that the lien had been satisfied, meaning that it had been paid off. So when you have a loan and you pay off that loan, does the lender remove the lien from the public records?
They're supposed to.
No.
No, they write that letter that say that.
Yeah, correct. So anytime any document is added to the public record, it's there forever. It's never removed. When you pay off
Does
the
it
loan,
show that it's been satisfied?
Yeah, yes.
To put the world on notice.
Because when you have a loan on a property, that loan becomes a lien against the property. So your lender will record that lien, which is a financial claim, in the property ownership records in the county repository where they keep all the documents pertaining to ownership. So that document there is going to be forever now. But once you pay off that loan, that lien had been satisfied. They don't remove the lien. They just add another document to the public record that says that the loan had been paid off and satisfied, that the lien had been satisfied. So now, if somebody's doing a title search, they could see, okay, wait a minute, this guy had a loan on the property, he had a lien. Oh, but wait a minute, he also there's a satisfaction of lien that matches up. Okay, so he paid that lien off. So you could actually see the order that things are happening in if you do a history search.
Right.
You could see, oh, well, he took out a loan from this company, but wait, he paid it off on this date and they recorded the lien, satisfaction of lien on this date. Okay. So this is how we could trace through the public records everything, all the history of that property pertaining to property ownership. Okay.
Yes, sir.
Any liens on the property create a cloud on the title. What do I mean by a cloud on the title? I mean like a dark thunderstorm cartoon cloud.
Yes.
You guys ever see a cartoon where they would have like the one thunderstorm cloud just hovering over the one property?
Yes.
One house? Yep. If you're buying a house, would you want to buy the house on the block that's got thunderstorm cloud always hovering over it?
No.
No. All right. So that indicates that there's some kind of a problem. You want to clear up that cloud and let the sun shine in, right? So
yes, sir.
What is a cloud on the title? Well, title means ownership. A cloud means it's not clear. There's something that's not clear. There's a problem.
Something attached to it.
Right? Because a cloud, you can't see the sky clearly, right? I'm trying to get you in this train of thought. So the title means ownership. Cloud on the title means it's kind of cloudy, maybe who the owner is, or there's some kind of a problem pertaining to the ownership records. Now, we'll get into how clouds can be cleared up. But first, financial claims. Liens are financial claims on property that provide security for the debt or obligation of the property owner. Voluntary lien is one you wanted. An involuntary lien is one you don't want. General liens affect all property you own, and specific liens only affect specific properties. Specific liens only affect one property, one specific property, not all the properties that you own. All right. Now, the priority of liens. What is a priority? Priority determines the order in which liens are repaid in the event of foreclosure. Who gets paid back first?
Taxes.
Well, the priority is determined by the date of recording in the public record, with the exception of two things. Tax liens always jump to the front of the line.
Yep. Uncle Sam wants his.
And then mechanics liens. A mechanics lien is a mechanic/contractor's lien. Okay. They're retroactive. Back to the date. Mechanics liens are retroactive. Back to the date the work was performed or the materials were delivered. Whichever happened first. So it doesn't matter the date that they recorded their lien in the public record. It's retroactive back to the date that the work was performed or the materials were delivered. That's how mechanics liens are a little bit unique. So what is a lien? A lien is a financial claim against property that provides security for debt or obligation of the property owner, right? So that's a lien. And then liens can be voluntary or involuntary or general or specific. The priority of liens is determined by the order in which they're repaid in the event of foreclosure. And that priority is determined by the date of recording. When we record documents, we record them in the public record. That just means that we added something to the public record. Tax liens always jump to the front of the line to get repaid. Mechanics liens also can jump ahead, but they're retroactive back to the date that the work was performed or the materials were delivered. But they'll never jump ahead of taxes because two things are certain in life: death and taxes, right?
So mechanics lien will jump in second, or would it still go by date?
Well, it goes according to the date that the work was performed or the materials were delivered. Gotcha. Not according to the date that they went down to the county hall of records to record it. That's how most liens take their priority according to the date that it's actually recorded, added to the public record. But
However, taxes go first.
taxes jump to the front of the line. We don't even look at date. They just jump to the front of the line. And mechanics liens, they go according to the date that the work was performed or the materials were delivered, whichever occurred first. So let's do some highlighting in the book on page 76. Under encumbrances, let's just highlight the numbers, or you could put a highlighted box around number 1 and 2 there that leans the different types of encumbrances. Then under liens, we're going to highlight the last sentence that says liens, real estate taxes have first claim against the proceeds of such a sale, and then write foreclosure sale at the end of that line.
What is that?
The last sentence in the first paragraph under liens. Real estate taxes have first claim against the proceeds of such a sale. And then you're going to write foreclosure sale at the end of that line, because that's what they're talking about. That's the type of sale they're talking about.
Okay.
And I explained to you liens can be voluntary or involuntary or general or specific. And I gave you here the definition on this slide of what that means. Now, the next step on the next page 77, effect of liens on title. Liens and other encumbrances run with the land. What does that mean? That means that if you transfer the ownership and there's a lien on the property that had not been paid off, guess what? It's still attached to the property and the new owner has to pay it. Although the new owner, technically speaking, the new owner does not have to pay it. The property that they own does. I know it's semantics. Technically, the property I own doesn't have to pay the, technically I don't have to pay the lien. If I just bought your property and it has a lien on it that I wasn't aware of, technically I'm not personally responsible for paying that lien, but the property that I own is, because that lien is attached to the property. If I was personally responsible for paying it, you could garnish my wages, but you can't, because I'm not personally responsible, but the property that I own is. That's why they attach the lien to the property to begin with, in hopes that when the previous owner sold the property, that nobody in their right mind is going to purchase it unless those liens get paid off and satisfied first.
I always thought that when a property is sold, whatever lien is on the property automatically gets paid, and then the owner who sold the house
automatically. Nothing's
well, that's what
automatic.
I assume. Well, you know what I mean? Because how can the owner get his?
There are no
portion of the.
Hold on. You're overthinking. There are no automated systems in place to transfer.
Okay.
There's humans involved. And so if we transfer ownership, if I buy your property from you, if I want to find out there's a problem, do I get automatically notified that something's busted in your house?
No.
No, I got to do a
then allow me to reword it. Allow me to reword it, okay? I always assume that if I sold
there's the word.
Assume.
Yeah. If I sold Victor a property, okay, and I had a lien on the property, and then we did the whole transaction in the bank, but before the bank cuts me my check, they deduct whatever liens have to be paid off first in order for me to get my profit. Isn't it that way? Doesn't it work that way?
No. Hold on a second.
Attorney.
Your bank.
Attorney, yeah.
Hold on a second. Your bank that you have as the seller and any outstanding loan that you have on them, they just care that their lien gets paid back. They don't give a shit about any other liens that are on that property.
Gotcha.
The attorney.
If I'm buying your property, I want to find out if you have any liens on that property. If I'm buying cash, right? If I'm getting a mortgage loan, my lender won't give me the money to buy your property unless I find out if there's other liens on it, because those liens would then have priority before them, because they were recorded and attached to the property before their loan, and their loan is a lot larger probably. So they want to make sure that they're not going to get wiped out by any other lien. Yes.
Victor,
So that
the
will
property
fall
that-
under title search.
Yes.
the
Title search.
property-
Thank you.
Yes.
Thank
the
you.
property that I just bought, we have a lot of situations. We were supposed to close on the 31st December last year, but it didn't happen because I was still getting documents and so.
Yeah.
As soon as 2020 arrives, the first thing my broker told me, you must pay your taxes in order to get this loan. So I did everything I have to do, and once I pay my federal taxes,
That's your income tax.
It's when they
so that you qualify.
finally,
That has to deal with qualifying to get the financing to purchase a property, though.
Mhm.
We're
Yeah.
talking about when you own a property already and you're selling a property, you would have the liens. We're talking about liens that are attached to a property that somebody owns, and when they're selling that property, the buyer should do their own home inspection of the public records to find out if there's any liens attached to the property that have not been repaid yet. Because if they're not repaid, then they run with the land, meaning that you as the buyer will be responsible for paying them off. And even though you're not personally responsible, your property that you just purchased is. And they could force repayment of that lien by foreclosing on the property. Foreclosure is a legal process where a lien holder tries to gain ownership of the collateral that was put up for the loan.
Yes, but that's the reason he said he want me to pay my taxes this year, because getting the new loan, they want to make sure I'm not gonna get a lien because I didn't pay my taxes at the time.
Well, you gotta get, hold on a second. You gotta get a property first. It has nothing to do with the lien. It has to deal with qualifying for the loan. You have to own a property first before they can put a lien on it.
Yeah.
You know, let's see. So liens attached to the property, not to the property owner. And the priority of liens is established in which is the order in which liens are paid. Tax liens take priority over all other liens. Otherwise, their repayment is determined by the date of recording in the public record. Mortgage liens, construction liens, contractor lien, mechanic lien, they're retroactive back to the date that the work was performed or the materials were delivered. Judgments are a decree from the court saying you owe others. That's another type of lien. And then there's other liens, I guess. Lis pendens is a public notice of possible future legal action against the property owner. All it is a public notice. It gives notice to all interested parties in the property, including prospective purchasers, that somebody has an interest in the property. So it's a notice recorded when any suit is filed that potentially affects title to a specified parcel of real estate. Well, no, it's not when a suit is filed. This is incorrect. A lis pendens is a public notice recorded it's a public notice
To put the world on notice.
of possible future legal action that is pending and may potentially affect title to a specified parcel of real estate. So it gives notice to all interested parties, including prospective purchasers of someone else's interests, that someone has an interest in the property through this public notification. Now, list pendants lists can be purchased. You could get a list of all people who are behind. When you fall behind on your mortgage payments, at least 2 months behind on your mortgage payments, lenders file a list pendants in the public record that basically says there may be a possible future legal action against the property owner. What kind of legal action are they talking about?
Foreclosure?
Foreclosure. So, as a real estate agent or as an investor, would it be helpful to know about getting a list of all people who are at least 2 months behind on their mortgage payments?
Yes.
Yes.
Well, here's 2 resources on this slide that I gave you. One is njlistpendants.com, and the other one is RealtyTrack. I think njlistpendants.com is cheaper because they only do list pendants lists. RealtyTrack gives you list pendants lists, a list of foreclosures, and a list of bank-owned properties. So they're more expensive.
And this is for what a lot of investors use, correct?
Well, I don't know if a lot of investors use it, but they could use it.
Yeah. Okay. That's interesting.
And let me add this to our links page here of links. Duh. All right, so I added that also to our links page. Okay. Save. Okay. All right. In the book, under effects of liens on title, let's go to 1, 2, 3, 4, 5 lines down and highlight that liens and other kinds run with the land. Encumbrances, liens, and other kinds run with the land. Highlight that. Encumbrances, liens, and other kinds run with the land.
Okay. Where is that?
Under effects of liens on title. You see that title? It says effects of liens on title.
Oh, yes.
Go down 1, 2, 3, 4 lines at the end of the line and highlight encumbrances, liens, and other kinds run with the land.
Yes.
Got it.
So they go with the real estate and they're still legally binding even after the sale. Then the next paragraph, we're going to highlight liens attached to the property, not to the property owner. So even though the owner is not personally responsible for paying the debt that's secured by the lien, they could still lose their property if the creditor took court action to enforce payment of the financial claim. Because even though you are not responsible for that lien, the property you purchased is. Next paragraph.
Legally, they can't come they can't come after like deducting out of your paycheck.
Correct.
Or your income taxes. So
Correct.
they only have access to
correct, because
property.
you don't own that. You don't own that. You don't owe them money. The property you own owes them the money.
Gotcha. Gotcha.
You should have made. That's why you should have made sure that that debt was paid before you completed the purchase. But you didn't. So now your property's responsible for paying it. Thus, by that way, you are de facto responsible for paying it. Okay.
That falls on the title search lab doing their
Or you're not doing
as
it.
far as
You're not doing a title search, or the title search company not doing a good job. That's why when you order a title search, you should also get title insurance, because if they miss a lien or something, then you're insured. They would have to pay it off.
nice. That's a good idea. Thanks.
Yep. All right. Highlight the priority of a lien determines the order in which liens will be repaid or paid off. And then go to the last 3 lines and highlights priority is normally determined by the date of recording in the public record. I had all this stuff in one of the previous slides.
When you said the last 3 lines, right on the priority liens?
Well, yeah, you see the last 3 lines at the end of that line, it says priority, which is normally determined by the date of recording in the public record.
Gotcha.
All right. And then go to, we already went over contractors and construction liens. Yes, we did. So on the upper right-hand corner of the page, highlight construction liens are also known as mechanics liens. And then next to last line, we're going to highlight they are retroactive to the date when the work was in question began or when the materials were delivered.
I'm sorry, what page is that on?
77.
Top right.
Yep.
Oh, okay.
Under
This looks like
construction, we're just highlighting the title, construction lien, also known as a mechanics lien.
Mm-hmm.
And then we're going to the last sentence, and we're going to highlight from the point that says they are retroactive to the date when the work in question originally began or when the materials were delivered.
Got it. Thank you.
You're welcome. A judgment is decreed by the court saying you owe someone else money. It's one thing to owe someone money. It's another thing to collect it, right? There's other liens. Okay, so let's see. Turn the page. Easements. Oh, I expected us to get so much further today, but either way, let's go through this, try to bang this out real quick. We got 20 minutes left here. So easement is a right acquired by one party to use the land of another for a special purpose. Easements can be these are different kinds of easements. You could have an easement appurtenant, an easement in gross, an easement by necessity, easement by prescription. We have party wall agreements, party wall easements. Now we're going to go over creating an easement and how to terminate an easement. So what is an easement? Easements run with the land, okay? So easements run with the land. It is a right acquired. An easement is a right acquired by one party to use the land of another for a particular purpose. That is what an easement is. Easements run with the land. A party may have an easement right in the air above a parcel of the real estate or land. Or under it, right? An air above it. That's the air rights, right? You could have air easements or subsurface rights. Or subsurface rights, easement rights. The holder of an easement only has rights, not an estate or ownership interest in the land over which the easement exists. And lastly, easements can be appurtenant or engross. Easements may be either appurtenant or engross. So what does that mean? Well, an easement
Can be attached to.
Yeah, easement appurtenant. There's two categories of easements. Let's first go over an easement and gross because it's the easiest one to understand. Easement and gross is a utility easement. And if the need for the easement were to cease, the easement would cease to exist. You know, this is a public utility easement. A public utility easement. So how can they put a telephone pole on your property? Well, it's a public utility easement. You probably bought your property with it already there. If they wanted to add one there, well, the first 6 feet of your property, they just need to get permission from the municipality to put a utility public utility pole there, because your municipality has an easement right for the first 6 feet of your property. If they wanted to, they could put a sidewalk there, right?
Right.
However, if they wanted to put a telephone pole in your backyard, they would need to get your permission to do that. Would you just give them permission to put a telephone pole in your backyard?
No.
Nope.
No.
Well, how could we create that easement right? How could we come to some kind of an understanding? If they gave you enough money, would you?
Maybe.
Money talks.
Okay, so maybe. That's good enough. All right, but we're just seeing how there's different ways that easements can be created, right?
Right.
Now, easement appurtenant. So there's two categories. All easements are either engross or appurtenant. An easement appurtenant is an easement that grants the rights to the owner of an adjacent parcel of land. Adjacent means they're touching your property, not the guy across the street. So you got a neighbor's property that's touching your land, that's an adjacent parcel. And an easement appurtenant always has a dominant estate and a servient estate. And it's just like it sounds, dominant and a servant, right? This easement runs with the land, so once it's created, it passes on to the next owner. The dominant estate is the one that benefits from the easement, and there are the only one that can terminate it or give up their easement rights. Basically, what it's saying is, if it's established that you have rights, can someone take your rights from you?
Yes.
How?
Yeah, it all depends. No.
Nobody can take your rights from you. You have the right to remain silent, and if you give up that right, see, you could give up your rights, but nobody can take your rights from you. They're yours. They're your rights. So once it's been established that somebody has an easement right, nobody can take those rights away from you, but the person can give up their right. With an easement appurtenant, who's benefiting from having the easement?
According to the chart, there will be lot B on top.
Well, let's go according to the slide here so far. It's the dominant estate. The dominant estate is the one that always benefits from the easement.
Okay, I see. That would be A.
All right. So the dominant estate is the one that benefits from the easement, and they're the one that can terminate or give up their easement rights. You can't, when it's established somebody has an easement right, you can't take that right from them. What is an easement? It's a right to enter someone else's land for a particular purpose. And if the person has a right to cross over your land for a specific purpose, You can't just say, well, no, you can't cross over my land no more, because they have a right to. You can't take that right away, but they could give it up. Now, why would I want to give up my right to cross over your land? If you make the
Because I
juice,
don't want to bother you.
if you make the juice worth the squeeze and offer me money, I could give up my easement, right?
Gotcha.
So if we look at this picture in the diagram on page 78, at the top, you got lot A on the left and lot B on the right, lot B on the left and lot A on the right. They did that kind of backwards. Lot A owner has a lake in their backyard. Lot B owner has an easement appurtenant right to cross over into Lot A owner's property to get access to the lake. Why would I want to give up my lake access? Which one of these is the dominant estate? Lot B or Lot A?
Lot A.
Lot B, because they're the one that's benefiting from the easement. They get to cross over Lot A owner's property and use the lake. Lot A owner is serving, they're the servient or the servant. They're serving their property up on a platter, while Lot B owner, the dominant one, they're dominating them, walking all over their property like a big bad bully, right? So that person is benefiting from the easement because they're dominant. They're the dominant one. They're like, get out of my way while I get to the lake on your property. They're the one that's benefiting from it, right? And Lot A owner can't do nothing about it because at some point in time, Lot B somehow, we haven't figured out how, but somehow Lot B owner has an easement right to do so.
Hey, baby, you can go ahead on.
Now, how did they create that right? I don't know. It could have been done in a couple different ways. Maybe at one point, Lot A owner owned both lots. And he figured, you know what? I'm going to subdivide this property. I'm going to build another house on it because I can. And I'm going to sell that house and make some money. Wait a minute. How can I make that property more valuable? Maybe if I give them access to the lake, I could make it more valuable. Would that property be more valuable if it had access to the lake?
Yeah.
Yep.
Yeah. So maybe they created that easement right when they subdivided the land and they sold one off. So an owner can create an easement when they're transferring the ownership like that, right?
Bargaining chip.
It's a way to get more money. Now, if they wanted to terminate that easement right, can Lot A owner terminate that right?
No, because
No.
it's already been established to Lot B.
Correct. You can't take away somebody's easement right. They could give it up. Lot A owner can go to Lot B owner and say, hey, I'd like to buy that easement right so you no longer have access to the lake. And if they agree to, well, then you could terminate it. But otherwise, nothing you could do. Next one is easement by necessity. Easement by necessity is when it's necessary to gain access to your property. It's usually for landlocked properties. All right, so let me open up see if I have any slides here now. Yeah, let me open up a slide. I'm sorry, the whiteboard. And let's go to the whiteboard. And an easement by necessity, we could highlight, let's do some highlighting here. On the left side of page 78, let's highlight the title, List Pendants. And then let's go halfway through the paragraph, and we're gonna highlight on that same line where you see it in bold, we're gonna highlight a list pendens is not a lien, but rather a notice of possible future legal action against the property. Okay?
Okay, underneath lease pending.
Halfway through the paragraph, you see where it says list pendens in bold?
Yes.
Page 78.
Yep.
And where?
Halfway through list pendens paragraph, where you see pendens in bold. on that line where you see it written in bold, halfway through it, it says a lis pendens is not a lien, but rather a possible, let's see, a lis pendens is not a lien, but rather a notice of possible future legal action against the property. You're highlighting that. This is we're just highlighting the stuff in the book that we've seen on the slide already. All right?
Yep.
Now go down to easements and highlight the first sentence. A right acquired by one party to enter the land of another for a particular purpose is an easement. And then I want you to underline the words a right. Easement is a right. And then I want you to go to the next page. On the right-hand side of the page, you see where it says licenses. I want you to highlight the first sentence there that says a permission to enter the land of another for a specific purpose is a license.
We're still on page 78, but on the next half?
79.
We're on page
79.
Yep, on the right side of 79, licenses. Under licenses, you're highlighting the first sentence. It's permission,
okay, gotcha. Thanks.
Permission to enter the land of another for a specific purpose. And then you're going to underline the word permission. So what's the difference between an easement and a license? An easement is a right.
Right.
A license is permission.
Permission.
Let me ask you a question. Can somebody take away your rights?
No.
So easements cannot be taken from you. But can somebody revoke your license?
Yes.
Yep.
Yes. Permission can be revoked. That bit of knowledge could possibly help you on exam. Now, let me give you an example of a license. A license would be like me saying, "Hi, neighbor, how you doing? You know what? Feel free to come over to my house. You could jump in the pool anytime, even if I'm not at home." I just gave you a license to enter my land for a specific purpose, to use the pool. Now, if I get into an argument with you and I'm all pissed off and I'm like, you know what? I don't want you on my damn property anymore. I just revoked your license.
Yep.
Licenses do not need to be in writing. They can be verbal. Easements, however, they have to be in writing and they will be usually added into the deed itself. Okay?
Yep.
Now, I wanted to get to a point to draw you a picture. There we go. About an easement by necessity. We have lot owner A, and we have lot owner B. How does lot owner A get to their property?
They have to cross through lot owner B.
They got to cross over lot owner B's property, right? They have to. So they create a driveway so that they could get access to it. Why is this pen so thick? Hold on. All right, so let me just erase that line real quick. So they got to create a driveway, or they use a road that they use to drive in, get access to their property, and to get out of their property. So this is an easement for ingress and egress. Ingress means entrance. Egress means exit. So it's an easement for the purpose of for entrance and exit for landlocked
Can you
property.
mute somebody's background, please?
Sure, I'll mute it all.
I hear like a pot.
Yeah.
Thanks.
So an easement for the purpose of ingress and egress, entrance and exit, is an easement by necessity when the property is landlocked and the only way to get to your property is by crossing over your neighbors. But can lot owner A, so they could they're using this driveway, right? Can they park their car and just leave it right here?
No.
No. Why?
It's still on property B's, on their property pretty much.
Because that's owner B's property, correct?
Yeah.
So they cannot do that. All right. So that's what they're just using it for, ingress and egress. They cannot park their car there. They could only use it to get into their property and out of their property. And then they got their own house on their property. They got their own house and their own driveway over here, right? But their property begins and ends right here, right? Who needs to maintain this driveway?
A.
Whose property is it?
B.
So B
Property
has to maintain it. It's their property.
But A is using it. I charging them.
That's right. They're the dominant estate.
Okay.
Get out of my way while I cross over your property to get to mine. Right? They're the dominant. They're the dominant. And B is the servient. They're like, yes, sir, here's my driveway. You can cross over it. Right? And I'll shovel it. And I'll maintain it for you.
Victor, I have a question.
And A's like, yeah, that's right. I thought so. Because they
I have a question, Victor.
Right to. Because they're the dominant one. Yes.
Okay, my question is this. B owned the lot first. B decided to sell portion of the lot to A, okay? And of course, the way how it's set up, you know, it shows the red being property owner of B. Can B still be the owner of it and put it down on a deed by selling it to A, that A maintains that piece of road right there since he's the one using it? Do you understand what I'm saying?
Yeah. If that's how the easement was created, if that was specifically written at the time that easement was created, saying that A has to maintain this driveway, is that what you're telling me?
Yes, sir.
Yeah. If they stated that at the time they created the easement that they could use this, however, B owns it, but A has to maintain it. If they wrote it that way in the deed when it was created, then yes.
Okay.
That's a lot of ifs.
Yeah. A will maintain it, but B's still paying taxes on it.
Yes.
Yeah, it's their property. All right.
Yep.
Hold on a second.
Okay.
Hey, what the hell's the name? Huh. Wait a minute. Why is this thing not giving me? Hold on 1 second with this poll here. This thing's not giving me. Oh wait, did everybody? Vote on that poll before? It's been open for the last 3 hours.
No, earlier.
On the afternoon one?
Okay, so let me close that one. That's why it wasn't letting me launch another one. Let me launch another poll and put for afternoon attendance. Launch it. Okay.
This is for afternoon, yes.
Yeah. We're not going to finish going through these easements right now. We're almost done with the chapter, but we still got about another 20 minutes left. So I'm not gonna hold you guys here through that. So we're gonna release now, and then we can finish this off on
Monday.